Good morning, Mr. Shaskalson. Good morning, Ms. Magula.
Good morning, Chair.
Good morning, Mrs. Gxasheka. Yes.
Chair, I'm not sure if we are ready to begin at this stage. I understand that there was a request for a possible postponement. I don't know where we stand.
Ms. Magula.
Thank you, Mr. Chairman. Mr. Chairman and Commissioners, today we're meant to proceed as arranged yesterday, but there's a bit of a predicament that we are facing. So I am requesting that, it's my humble request that the matter be rolled over until the 2nd of March, because there are documents which were received during midnight, and when we perused those documents, we found that we have to give a thorough attention to them before Ms. Gxasheka can proceed, and they are voluminous. Hence, we request that the matter stand down. And also, there are documents that were received this morning, a document that was received this morning, and it is very crucial that we go through it thoroughly and consult through it before we can proceed. So that is my request, Commissioner.
What is the nature of the first documents? Regarding one set, we have been advised, in fact, the Commission's attorneys gave us copies of an arbitration. Reverse peace. Yes. That's the one type of document we are aware of, but you seem to be referring to two categories. What's the nature of one of those, the remaining category?
The first one is the one that was received yesterday, mid or early hours of the morning.
What's the nature? What's the nature? That's my question.
The nature of it is it's tender documents, and they're in a very big volume. They have about, it's 411 pages, if I'm not mistaken.
Is that not the tender itself? Because if it's the tender itself, I don't know how Mr. Shaskal, I'm still going to ask him to respond. But if the voluminous document is the tender document itself,
yes.
I wonder if the Commission would want to hear evidence on the contents of that document, paragraph by paragraph or clause by clause.
It's not, Commissioner, it's not only the
yes.
tender documents.
Yes.
There are also transcripts of Dr. Mkhwanazi in the very same volume of documents, and some spreadsheets in that document, of which it needs to be thoroughly, when I need to thoroughly go through them and thoroughly consult with my client and make sure that we have everything, we don't leave anything that is required from us to assist the Commission in finalization of her testimony. So it's those documents and the other 3 emails that were received this morning. We received 1, and the other 2 were received late last night. Yes. Mr. Commissioner, those are the documents that I'm referring to.
Okay.
And in order for her to proceed, we need to go through, yes, we've consulted from yesterday, from the time that we were offered, we've consulted, but we are not yet finished due to the bulkiness of the documents, Mr. Commissioner. It is my humble submission that we are not willing to waste any time of the commission. We want to assist the commission as much, as soon as possible as we can, so that we can reach at least to the finality of of Ms. Gxasheka's testimony. So, Mr. Chairman, on the last occasion when the matter was postponed, it came to my mind that we were given the dates, that is the 26th of yesterday, the 27th, and the 2nd. So my request is, can we fall off at least to the 2nd of March to proceed with the testimony so that we can expedite, because she has already started and we just need to sort this issue out, then we swiftly proceed with her evidence, if the commission can allow us that opportunity. Thank you, Mr. Commissioner.
Thank you, Ms. Magula. Mr. Shaskalson?
Chair, we have a difficulty with this request. I think one needs to get clarity on what documents were provided when. The tender bundle was provided on a late Wednesday night. That was the document. That was the bundle of documents that I agreed not to ask questions on yesterday, and in respect of which we stopped early yesterday so that Ms. Gxasheka and her legal team could work through them. Those documents are not, well, they're not new in the sense that nothing has changed in relation to those documents since we agreed to start this morning. Yesterday, Commissioner Khumalo asked a question in relation to the evidence of Dr. Mkhwanazi, and we said we would extract the relevant passages of the evidence of Dr. Mkhwanazi and make them available so that the witness could look at them overnight. The transcripts of Dr. Mkhwanazi have been there for weeks. They've always been in the possession of the witness. What we did yesterday is we specifically extracted 6 pages from a bundle of documents that has already been there for a long time and said, these are the 6 pages that are relevant to Commissioner Khumalo's question. There are 2 additional documents that are new documents. The first is a 2-page letter written by the witness herself that was emailed that relates to the rules in respect of the retirement fund and taking early retirement and medical benefits. That was made available to us after the hearing yesterday, and as soon as it was made available to us, we had it forwarded to our learned friends. This morning, we were given a copy of an arbitration award in the arbitration between Mr. Spiss and the municipality. The arbitration award itself is date stamped 23 February. I don't know, we received it from Mr. Spiss this morning. I don't know when he received it, but we received it this morning. We made it available. It's not a particularly voluminous document. The commissioners have seen it themselves. And there are a few short questions to be asked in relation to it. The award speaks for itself. This is not a matter that requires much answer. So and we can't just roll over onto Monday. We have another witness scheduled for Monday. And we certainly would oppose this postponement. At best, from our side, if Ms. Gxasheka and her legal team need a bit more time now, we would ask that they be given a little bit more time now. But we can't waste a day. And in relation to what is new, it's the arbitration award and a 2-page letter. And the arbitration award itself is, it's
14 pages long.
14 pages long, and the letter is 2 pages long. This is not something that takes a great deal of time to consult on.
Ms. Makula, do you agree with Mr. Shaskalson's description of the documents, even including the times of receipt, times/dates of receipt?
Yes, Mr. Chairman, I agree with Mr. Shackleson with the time and the documents that have been received and the number of pages that of the evidence that has been received. Yes, I agree with him. I fully agree with him on that. But, Mr. Commissioner,
Yes.
I would like to request that the Commission should at least take into consideration that it's not about only the documents that have been received that are that makes us to request for a postponement. In these documents, she has to answer on them. The client Ms. Gxasheka has to answer on them. And for her to answer on them, there are annexures maybe that she will need that will support maybe her.
You say maybe.
Let me remove the maybe corrections. There are annexures that she may need to support her answer, and that will assist the Commission. That is the request. That is the reason why we are requesting that we stand at least the matter down until Monday.
Ms. Makula, the only voluminous document is the tender document, on
Yes.
my understanding.
Yes, Mr.
And Mr. Shaskalson says that that's been with you and Mrs. Gxasheka from Wednesday already.
Yes.
So, insofar as that document is concerned, I would not understand the request at all. In fact, I should not say I would not. I do not. I do not understand the request at all. So why would you not be ready if you've had the document from Wednesday already?
Not that we are not completely ready, Mr. Commissioner. We are partially.
Are you the completely? I don't understand.
Not that we are not completely ready. We are partially ready. If maybe we can then be afforded an opportunity that the matter stand down for at least some time, then.
Why are you not ready from Wednesday if you've had that document from Wednesday?
We started with the document. We consulted, as I've already explained to Mr. Chairperson, that to me, it was very crucial, and for my client, it was very, very crucial that we go through each and every item that is in
You
the
mean
document.
clause by clause? Go through that tender document clause by clause?
Yes, Mr. Chairperson.
Let me just quickly, I'm still going to come back to you because I've not dealt with all the documents.
Thank you.
Mr. Shaskalson, are you proposing dealing with a tender document clause by clause? I would be surprised.
Not clause by clause, but I can provide a list of pages to which I will refer.
Perhaps, yeah, please do that. Then let's go on to the document, the transcript, pages of the transcript that were provided pursuant to a question by Commissioner Khumalo. That's only 6 pages long. Surely that cannot detain you.
No, it cannot.
So that's not an issue.
That's not an issue.
Okay. Then there's a 2-page letter by Mrs. Gxasheka. That too.
That's not an issue.
All right. And then the arbitration award is only 14 pages long. That too, I think, should not detain you.
That won't be an issue.
So we are left with only the tender document.
Yes.
Mr. Shaskalson has offered to give you the relevant pages that you should focus on and on which he's going to be questioning Mrs. Gxasheka.
If that is the case, Mr. Chairman, then we
are ready to start.
Yes, if that is the case, we can stand down a matter for a while. Then we will.
I propose that we start. Then what we will rather do, let us see during the tea break what we should do, whether we should extend the tea break or we'll decide.
Thank you.
Let us start now.
Thank you for
Is that in order?
It's fine. It's fine, Mr.
Thank you very much. Yes, Mr. Shaskalson.
Thank you, Chair. There was an issue of my. There was a possibility that there would be a supplementary witness statement dealing with the emails in relation to the tender. Sorry, in relation to the issue of vetting of EMPD members, because there were emails that were relevant. Now, those emails have been provided to us, and I understand the request is that I take the witness through the emails. And can I just check that the commissioners have copies of those emails? Sorry, the commissioners won't have copies of those emails, but they're about to be handed up. And can I just see the pagination, if any? Okay. It's not paginated. Okay. One of 13. Chair, these documents rightly belong in the main annexure file because they are an annexure to the witness statement itself that ought to have been included. Can I suggest that we actually paginate them at the end of volume 6 so that they would start on page 2062? And if we start at page 2062 and just continue.
Thank you, Mr. Shaskalson. We request the attorneys to do the pagination for us and appropriately marking the documents for us. You'll just identify the documents so that we are able to follow, Mr. Shaskalson.
The problem is that they are sequenced in a way where it will be quite tricky to do that. Can I make a suggestion?
Yes.
In view of the fact that we are... there's been a request for extra time. We're going to have to paginate before I can start this. Might I suggest that we stand down until tea time now, and then so we take the break now rather than at an extended tea time?
What time are you suggesting we come back?
11 o'clock, 11:15, whatever the Commission deems appropriate. But in that period, that time can be taken advantage of. I will give the list of the page references in the tender document. We'll get your documents paginated, and we'll move much more smoothly afterwards.
Thank you very much. Let's adjourn
So
and resume at 11.
the legal opinion and the vetting issue. And you should now have had your little bundle of email correspondence paginated. It starts at 2062, and it would be at the back of file 6 if it's been put into a file. (2062). And Chair, because it's an email chain, we have to jump around a little bit. And so I think that the starting point, the earliest email I can see, is at page at 2070. If one goes to the foot of 2070, which is page 9 of 11, the chain starts with an email from Chief Mapiyeye. It's to Mrs. Gxasheka, and it's on the 26th of March 2024, just before 3 p.m. And if we go down, essentially, Mrs. Gxasheka, the Chief was asking you for a meeting, was he not, to deal with inter alia the issue of criminal records.
You see that, Mrs. Gxasheka? It's at 2070 and 2071.
And one of the people who was copied on that email is Lifu Makhoba, or Makoba, I'm not sure how to pronounce it. Can you just explain who that person is?
Good morning, Chairperson, good morning, Commissioners and everyone. Thank you, Evidence Leader. Lefu Makoba was the acting divisional head for employee relations. Thank you.
Thank you. So she was reporting to you in the HR department?
Certainly, yes.
So the next step in the chain is if we go up to the middle or to the top of page 270, we see that Ms. Makhoba then writes to Njabulo Zulu, who I assume is in the legal department.
Yes.
And says, "Dear colleagues, how far is your progress on a legal opinion on the EMPD employees with criminal records?" So she's writing to legal saying, where's this opinion? If we go up the page, just sort of middle of page 269, you thank her. That's an email from you to Lifu Makhoba still on the 26th of March, 7 p.m.
Yes.
Thanks for following up on this. And then 68, a response is received from Thabo Makwiting, who I assume is in legal, and he says, "Good evening, colleagues. I've signed off on the comments today. Advocate Zulu will send to you first thing tomorrow. Please accept my apology." And so this is legal saying to you, you'll have the opinion tomorrow. We're sorry. Sorry, it's late. Then, late the following day, tomorrow, which is the 27th of March, we see at the top of page 2068, Mr. Zulu of Legal emails you saying, "Dear colleagues, Please find attached legal comments on the EMPD matter. Regards, Njabul. And was that the email that actually attached the opinion?
Yes.
My next step, and I don't think I've missed anything, but if I have, call me out. On the 5th of April, 2024, Lifu Makhoba emails Chief Mapiyeye, Julius Mkhwanazi, sorry, that's on page 2067. Emails Chief Mapiyeye, Julius Mkhwanazi, and Revo Spies, Ivan Duplessis, and various others. Dear colleagues, as per the discussion of the meeting of 2 April 2024, with Chief of Police and his management team, as well as the HOD management team, kindly receive the legal opinion for your processing and way forward. So this seems to be the first time that the opinion was given to the EMPD.
Yes.
But it refers to a meeting that's taken place in the meantime between yourselves and the Chief of Police, or yourself, the Chief of Police and his management team and your management team on 2 April. And that we don't see in, well, we don't see a minute or anything of that meeting. Do you have any recollection of what happened at that meeting? And just to contextualize it for you, you would have been in possession of the opinion by that stage, which came to you on the 27th. It hadn't yet been forwarded to the police department.
Thank you, Chair. In best of my collections, I think, and also my evidence yesterday was that this is where we were discussing the processes. The legal opinion, as we were reading it, it was confirming some of the things that needs to be done.
Sorry, maybe if I can assist you in that regard, can we go to 2043, or just keep this bundle open, but 2043 of the annexure bundle, oh no, it's the same file, page 2043 of the same file. It should be file 6, because I think that is the legal opinion that we're talking about, and it might have your file 6 of 6, 2043.
Yes, we were summarizing the issues that were discussed regarding that, the legal opinion, which it talked to, I think in page 2043, it was talking to the description, for instance, of the employees that were vetted, and activities that happened, and so forth and so forth. The following page, it was about the EMPD reports, the master fingerprints results, and so forth, and then the questions to be answered. If I can go straight to those questions, the first one on page 2044, paragraph 4, that for the sake of clarity and convenience in application of the law to the facts, we will categorize the employees, those who are acquired criminal convictions prior to employment, those who acquire criminal convictions during employment, and those who acquired pending criminal cases during employment. I think we all understand the challenges at EMPD and IPD, where they would be found with criminal cases while at their work time. Those who were declared unfit to possess a firearm during employment in the city, and those who failed to submit their fingerprints. Then they came and discussed the law facts to the issue where employees who acquired conviction, how should deal with, and the processes that we needed to follow, including disciplinary hearings. I'm summarizing, Chair. That we need to have, especially where you are declared unfit to hold a firearm and so forth and so forth. So at a high level, my recollection was in that meeting then we needed to come with a process of embarking on these different categories. And also, I've said yesterday that the issue of getting consent and the expungement where it's required. So this is what we were finalizing after they've given us the categories that they had. So we're just cleaning the house. I then further, we agreed that HR doesn't have capacity to hold, to conduct that process. Therefore, they will have to source it and get it done by themselves. But then they keep myself and the accounting officer abreast. And as I said yesterday, again in the meeting, you could find the back and forth among themselves, back and forth. Others are suggesting this process, others are suggesting that process. So the email of Lifu was focusing on that, Chair, that what process we're supposed to follow and what we're agreeing that needs to be done. And I would like to reiterate from what I said yesterday, there were challenges because some of them said, I already have this, I don't need to do it, but you are pushing that others must be done, you know, and the issues of capacity that we discussed. I think that's what I can recall at this point in time. Thank you, Evidence Leader.
Thank you. If we continue in the chronology, it goes to the top of page 2066, where you then write shortly after the email from Lifu, you write to Chief Mapiye and Revo Spish copying Julius Mkhwanazi. Dear Chief and Revo, please provide us a report regarding the category of employees as you explained in our meeting. Also find attached the legal opinion so you proceed with your internal proceedings. And what were you referring to as the category of employees that they had been explaining in the meeting?
Okay. Can you take me back to the annexure now? I just closed it.
The annexure is LLG
I've got
5th.
it. I've got it. I think I did read in terms of the description of how it should be done, the types of employees, the types of employees that they need to categorize. I've read that in terms of the legal opinion. So we're referring to that basically. That they need to redo their...
Can you please just restate that category for clarity?
Employees who acquired criminal conviction prior to employment.
And can I just clarify that you're on page 2044?
2044,
Oh,
paragraph
no.
4.
Okay, if you are referring to that longish list, it's fine. You don't need to. Okay.
Thank you, Chair.
Thank you.
Now, your email was on 5 April at 1:46 p.m. The next email is from Julius Mkhwanazi, and that's on the same day at 4:21 p.m. And he responds, although your email was addressed to Chief Mapiye and Deputy Chief Spiss, Julius Mkhwanazi responds directly to the email and says, "Good afternoon, colleagues," responding directly to you. I have set up a team within operation to verify the fingerprints as submitted to us by Deputy Chief Revo Spiss and Deputy Director Vanda van Rooyen. We've discovered that this is the old criminal record data. Some of the people on no retirement, I'm not sure what that means, cleared by the courts resigned. And then he says, I suggest we start the process of verification afresh so we get the correct data of criminal record for every employee. as the HOD was explaining, this is going to affect the whole city. It will be wise if we start with the correct and clean data as operations we're combat ready to start the process since we're the most affected one according to this old criminal record. So if I understand correctly, he's saying this data is not accurate. Some of it is incorrect. We need to start from scratch. And because it's my section that is most affected according to the existing data, let my section take responsibility for checking getting proper fingerprints. Is that a fair summary of what he is saying?
That was my understanding as well, Chair. Thank you.
You then responded the following day, and that is at page 2064. And you respond to his letter on Saturday, the 6th of April, 7 in the morning. Please note this is your EMPD process and concur that it must be done seamlessly. To ensure accuracy at all times, employees must be vetted and a final outcomes report must ensure that the data provided is correct, current, accurate, valid and reliable and legally and relevant. Legally, all the correct processes and SOPs must be observed and adhered to. Please keep the accounting officer and HR informed of the process to embark upon and timeframes by rather providing a comprehensive report to this whole process where possible. So do you want to explain your response here?
Thank you, Chair. My response is exactly what I've said yesterday and today, Chair, that I've said in our meeting, it's their process. They've got capacity, they assist the city anyway. They must run with it. And we already provided guidance in terms of how it should be done and so forth. And all we need is a seamless process. And obviously, Chief is leading the department. And my communique specifically, it talks to the Chief and the senior management, but specifically to the Chief. And eventually, based on our agreement previously, was that it keep us informed as we embark on the process, because once it's concluded, then it also determines the labor relations processes that we must commence with and be able to assist them where HR gets to start to be involved. Thank you.
Then there seems to have been a delay of a full year, because the next email in the chain is at page 2063, the middle of the page, and it's Sunday, April the 6th, but now it's 2025, not 2024. And you write to Julius Mkhwanazi saying, "Dear Acting Chief, this is the issue the councillor is referring to. We need to act on this before they use it against HR and EMPD." And below, what you're doing is you are forwarding your last email of 6 April 2024, exactly a year ago. The "Dear colleagues, please note this is your EMPD process." So it seems to me, and again, correct me if I'm wrong, that what had happened is that the matter had sometime later been raised in council closer to April the 6th, 2025. And at that point, you went back to Julius Mkhwanazi and said, "We need to act on this. If we don't, they're going to use it against our departments. The councillors are going to take action against our departments." Is that correct?
If I recall events, it might not have necessarily been the council meeting, but where we report majority of our issues is at OCMOL. So it might have been the OCMOL, the structure I've discussed yesterday.
Sorry, can you just explain that structure?
Is the oversight of the executive, mayor and legislature offices committee. So they've been following up on majority of EMPD issues. I think that's where we get to engage about EMPD issues. I think it could have been Councillor Bach. It was where it was discussed. And it was not for the first time. They kept on discussing these issues. And where it would have been in council as well, it would have been the EMPD, MMC Community Safety, that would have been responded. So it became an ongoing matter that needed to be resolved. So my aim of the meeting was to say, can this happen? Can you follow up on my email that was sent to you guys a year ago? Thank you, Chair.
And were there any other communications in relation to this issue between yourself and Mr. Mkhwanazi in the intervening year?
After this one?
No. Between April 2024 and April 2025?
Directly so, I'm not, it might have been verbal, but where we have been meeting and discussed these issues, it was in the OCMOL. As I said, OCMOL kept on following up that EMPD get this process done. I don't sit in their executive management meeting. I wasn't sure what was happening there, but in the OCMOL, all of us will be sitting there. So it will be discussed that it must happen. And I was also trying to emphasize that time is running. Why is this not happening? Thank you.
That seems to be the last email in the chain, because
Yes.
the next email is on page 2071, which is just your own personal email where you
Yes.
have sent the email chain for filing. Is there anything you would want to add further in relation to this topic? Because from my side, I'm happy. Well, I mean, I will come back to ask you questions, but that from my side seems to conclude the initial process of just taking you through the emails.
I'm comfortable so far. Thank you, Chair.
Chair, that concludes the process of leading the witness. So I'm afraid now the questions get a bit more intrusive. And maybe we can start.
So maybe before you start, there was also the issue of the tender. What has been decided about that?
And I've given a list of references that I'm going to refer to. And in fact, I'm proposing to start right there. So can I ask you to go to page 168 of the supplementary. Two of two.
Thank you so much.
168.
Can you mention the page again?
168.
Apologies for that. 168.
6168.
168. Thank you, Chair.
And there you'll see a document saying bids are hereby invited for the following: Human Resources Department, Strategic HR and Talent Management, contract PSHR 13 of 2023, the appointment of accredited skills development providers to implement various qualification and skills programs on an as and when required basis from date of award till 30 June 2026. And the closing date is 24 July 2023. The foot of the page, you'll see that that invitation is issued in the name of Dr. Mkhwanazi. Did she play any role in this process?
In its entirety, or the advertising process?
Well, in advertising the bid or the bid more broadly?
I don't think so, because the advertising from the process, my understanding, the HR will draft the specification, and then the specification will be taken to the bid specification committee for endorsement. The only role that the city manager will play is to appoint the committee. In fact, all the committees, the bid specification committee, the bid evaluation committee, and the bid education committee, that's her role. And the main stakeholders, it will be the chairperson and the whole committee of the bid specification committee. I wouldn't know 100% of the supply chain processes, Chair, if it goes to her for signing or not. Normally, HODs, they don't get involved in the tender processes, so it would be very difficult to give every detail. One area I think should be involved is to appoint the committee. Thank you so much.
If we go up to 162, which is the bid document itself, or the start of the bid, it says that it's prepared by the HR Department, Division Strategic HR and Talent Management, and it's prepared for the Department of Human Resources Head Office, and in fact your name is given there. And it says, if anyone gives the email address of Makosi Makamba on both prepared by and prepared for. So what role did you play in relation to the preparation of this bid?
Chair, as much as my name is put there, as you can see, the email, it's not my email. The role that I will probably play, because I say these documents are, HODs are not involved. It will be the agreement, maybe on how the spec will be, just to look at the documents. Because in terms of technical expertise, it's the divisions, training and development, who will understand what are the requirements. And my understanding, this specification should have remained the same for the longest time. I did make comments at some point that their current tender, because it has been following the same process all along, it doesn't cover everything. I said, where preferable, I would love us to see having formal education as part of the tender, where we do have challenges, Ekurhuleni, of formal qualifications. I think as I speak now, it can be verified. I'm not 100% sure. I know we have media space here. Even at EMPD, if I'm sure, there might be no acting chief now. It will be only the acting HOD because of lacking of qualifications at those levels. I can't recall if they included it on the tender, but I know that the appointment of service provider with formal qualifications, it did not happen.
And what is your distinction between formal qualifications and informal qualifications? Are you
I
talking
think what I
degrees and
meant-
diplomas versus other
Please,
NQF qualifications?
please repeat the part referring to degrees and diplomas because you spoke at the same time, Mr. Shadrack.
What do you refer to by formal qualifications? Is it a distinction between degrees and diplomas on the one hand and other NQF qualifications on the other?
Thank you, Chair. Yes, exactly. That's what I wanted to confirm, that majority of the time, our tenders are focusing on unit standards. And that's what is confusing the institution, because unit standards, it basically means you would have done certain modules with certain credits, and majority of the time, it's very difficult to consolidate and translate it into a formal qualification, especially timeously. So, but if you take a route of having a formal certificate, diploma, degree, honors, masters, it will then assist to improve in our qualification profile of the city. Then you accumulate those unit standards over a longest time. And majority of time, employees, they tend to get tired and never get to finish a formal qualification. So that's what I was aspiring towards, that let's just go once and get formal education. That is my own definition between the unit standards and the degree, certificate, and so forth. Thank you, Chair.
Where does Makosi Makamba work? Presumably she's in HR somewhere, but where is she?
I don't know where she is. I think her contract expired or she resigned, I can't recall, but she's no longer with the city.
Who would have been responsible within the department for this tender?
It was her.
But, presumably it must have been allocated to her for a reason. Would she have sat in strategic HR and talent management? Or
Yes,
how
she
do you
was
do
the-
this within?
She was the divisional head for strategic HR and talent management, and the training and development was falling under her. It was a subdivision in in the strategic HR and talent management division.
And you talked about 3 different committees: a specifications committee, a bid evaluation committee, and I think you said bid application, but I think it's bid adjudication committee.
I said adjudication.
You did say, I apologize, I misheard. So the specifications committee would finally sign off on the specifications that go into the tender.
Yes.
And who sits on the specification committee? Who decides what those specifications are?
I will respond from a position of assumptions. As I say, I don't normally go and do this. I haven't done it in a long while. My understanding, the city manager will appoint an HOD for a particular department, and then will also sit with other HODs and with a mix of divisional heads. So it will be comprising of high or senior management.
In relation to the specifications committee?
Yes.
Did you sit on the specifications committee, this one?
No.
So the HOD in this case was not appointed to the specifications committee because you were HOD.
Can you repeat your question?
You were HOD.
Yes.
But you didn't sit on the specifications committee.
Yes, I did.
So there wouldn't have been an HOD on that specifications committee.
If I were to go and sit there, I'll sit to go and present it, to present the item. But what I'm saying, the committee comprises of different HODs and divisional heads from different departments.
I understand now. What about the bid evaluation committee? Who sits in that?
Also, it will be HODs and divisional heads.
Drawn across all departments?
Yes.
But presumably, if you have an HR tender, and the bid evaluation committee is checking for compliance with the requirements of the tender, is it not?
Yes.
Before you get to 90-10 or 80-20, you need HR people in there who will understand what is being asked for.
The divisional head would have sat in that as well. I think she will sit in the bid specification, and she will also sit in the bid evaluation committee.
And that would have been Makosi Makamba.
Yes.
And again, on the adjudication committee, who sits?
My understanding on that one, it will be the group chief financial officer, who might be the chair, if I'm not mistaken. It will be the HOD legal, and then it will be other HODs as well. I'm not sure if you'll find a divisional head in that particular committee. Thank you, Chair.
And the bid adjudication committee is the one that makes the final recommendation of an award.
Yes, Chair, thank you.
If we look lower down on page 168, sorry, we've moved from 168, but let's stay on 168. Let's go back to 168. It says that acceptable bids will be evaluated by using a system that awards points on the basis of 90 points for bid price and a maximum of 10 points for specific goals. You see that? It's the 90-10.
Yes.
Now, in a system where you're operating 90-10 and 90 goes for price, would you agree that you need to have an objective means of comparing prices? That prices must be, you need to compare apples with apples. That if 90% of the points are going to go on price, the price must be a number that is in fact the price.
I think we're giving opinions, Chair, right here, because I want to give you my opinion, but in terms of the technical knowledge and expertise, I think Finance Department can be able to do that. But my opinion, I think I fully agree with you. If the laws and the circulars could change and not only focus on the price, in some particular areas we could get quality of work done. I think before COVID, around 2019, 2020, I served in a bid evaluation committee for a year or less than a year. And it's one of the frustrations I had that in some instances you miss a very brilliant, good company that can deliver. But because of the price, then you have these problems.
No, I understand that dilemma, but if the system says 90-10, then
yes,
price is 90% of all of the points. Now, one of the successful bidders here was a company called Buena Vista Learning Academy. And we see that they were one of the successful bidders in a document that is well, the document starts earlier, but there is an announcement in November 2023 that we see at page 128 of the same folder. It starts at 128, and if we go down the next page if we go down to 130, we will see that the second from last item, row on that item says PSHR 13 of 2023. the appointment of a panel of accredited skills development providers to implement various qualifications and skills programs on as and when required basis from the date of appointment till 30 June 2026, Buena Vista Learning Academy. So they were one of the successful bidders here.
Yes.
Buena Vista are a company which are controlled by the partner of Mr. Kat Matlala, a woman called Tsakani Baloy. And if you go to page 168, sorry, not 168. If you go to page 124, you'll see a Windeed search on Buena Vista. 124. And you'll see under company information that starts at the foot of 123, on 124 it says that the registered address is 23, well, I won't give the address, it's a registered address. And that registered address, if we go down to the next item, just is the same address as the residential address of Tsakani Baloy. You see that?
Yes.
And if we go down to page 123, we'll see that at the time of the bid, there was only one director in Buena Vista, and that was Tsakani Baloy. Both of the other two previous directors had resigned. And we see also, if we go back up to 124, that Ms. Baloy only became a director of the company on the 26th of June 2023. That was a week after the bid invitation had been advertised, and it was less than a month before the closing date for the bid. You see that?
Yes.
And that, I want to put to you, ought to be something of a red flag if one is adjudicating tenders. If one sees that the only director becomes a director after your bid advertisement date and very close to submission date, that should raise some suspicions. Would you accept that? You're nodding.
I agree.
There are more red flags here because when she became a director, if we go down to page 127.
Your mic, Mr.
If we go down to 127, we know that as a director of this company, she applied in the name of Buena Vista Learning Academy, but at the time she became a director, the company was called Mokoko Grill. It seems to have been a Chesenyama company. That we see at page 127, and the very first item, there was a name change on the 11th of July. And in brackets underneath is the previous name, Mokoko Grill. So after the bid was invited, and less than 2 weeks before the deadline, Mokoko Grill became Buena Vista Learning Academy. I want to put to you that that was another red flag that might have been picked up if
Yes.
you accept that. Let's look at the bid price. We see that at 169. There it says 7 programs, and it says total bid price 66,500. But if we go to page 158, we see a spreadsheet that the municipality have provided to us of the payments to Buena Vista Learning Academy on this contract. And although they bid with a total bid price of 66,500, in the period from 23 July 2024 to 5 September 2025, they were paid 3,484,987. Do you know how that could have happened?
Okay, I want to understand that the total bid price, it means that you're going to tender for 6,600, for 66,000 for the whole tender. I want to have clarity on that, Chair. As I say, I'm not an expert on that. But on the spreadsheet, it will be the allocation of training as required by departments, where she will then go and train.
So these are payments that are made, and I think I remember recalling in your statement you said that HR itself doesn't have a budget for training.
Yes.
Is that correct? So you can't pay for training, but the line function departments will pay for training.
I've said they are also battling to pay for training. Majority of the time, the training will be paid by the SETA. And the Ekurhuleni, we're still striving to get our own budget.
So when you refer to the city, it's not clear to me what you mean. I mean, technically every department's part of the city, but who do you mean when you say it will be paid for by the city?
The SETA.
Oh, by the SETA?
Yes. We receive grants from the SETA on an annual basis. There will be an indication, then they submit money in the city on a quarterly basis.
So when it says departmental, if we look at page 158, when it says departmental cost center description, projects, HOD's office, projects, management, HOD roads and stormwater, what does that reflect? Surely that reflects payments from particular departments.
It means it's the money allocated. The departments, they will ask for a particular training, and then we'll allocate that training for that department. And once they are done with the training, it will be paid from the SETA's grants. So where it says departments, it means training, it happened in those departments.
So what you're saying, if I understand you correctly, is that the city has access to SETA funds,
Yes.
or funds that it can use out of its skill development levy payments and the like, and it will allocate from those funds, or certain departments will have a claim on those funds for training.
Yes.
And so the money is ultimately paid for by the city, albeit what it results in is a credit on skills development levies, the funds that the city would otherwise pay to the SETA.
Yes, technically you can say that.
I flagged some of the red flags in this bid. I want to suggest that there were a wide range of others. The first is the CSD registration report. And that one sees at page 311. And it records that the CSD registration on the created date was
Apologies, Chair, I'm still getting the page.
311.
Thank you.
It records under created date, which is when the CSD registration takes place, that CSD registration took place on 20 July 2023. So this company was registered with the CSD 4 days before it submitted.
Yes.
It also obtained its BEE certificate 4 days before it submitted, its first BEE certificate. One sees that on page 311. CBE issues certificate issue date, 20 July 2023.
Yes.
We've already seen that the only director was appointed on 26 June 2023. If one goes down to 389, one sees that the bank account was only opened on the 17th of July 2023.
Yes.
Will you agree that all of these are red flags that ought to have been picked up in the tender adjudication process, either by the BEC or the BAC?
I fully agree.
Can I point to another one? If we go to the CSD report, it says that the vendor is not VAT registered. That's at page 313.
Okay, I don't see that part.
If you go to page 313 under tax information, it's got an income tax number, and then it says, is the supplier a VAT vendor? And it says no.
Okay, yes, I can see that.
But if we look at the bid, we see that the turnover that is claimed in the bid, and I've unfortunately lost my reference, is, I think it was 35 million rands in the previous financial year. So there was 35 million rands, I'll get you the reference in a minute. 35 million rands of turnover in the bid, cited in the bid. Sorry, Commissioner.
Number on 191.
On page 191, thank you very much. What was your turnover in the previous financial year? It says 35,174,600 rands. And what's significant, if we go back to page 311, is that if we look at the industry classification that is described for Buena Vista Learning Academy, it says its core industry is not, in fact, training, but construction. So it says on page 311...
Perhaps you should have concluded the point about not being VAT registered, and yet there's a 35 million.
I need to refer to construction because
thank you.
There are training providers who don't have to be VAT registered.
Oh, thank you.
But there are no construction companies that don't have to be VAT registered. So if we look at what is said in the CSD report, it says the core industry is construction, and the percentage share of annual turnover is 35% from construction activities. And if we take the 35 millions quoted in the bid as the previous financial year's turnover, 35% of that would be over 10 million rands, which is way over the VAT threshold. So there seems to be a fraud of some sort taking place here. Either it's a VAT fraud, you're nodding.
I think so, yeah, I wouldn't know.
Or this turnover figure is a fictitious figure. Either way, there is a fraud either on the city or on the receiver. There seems definitely to be a fraud on the city because, the city or the Department of Finance, because if we go back to page 311, although the bid says we saw annual turnover was 35 million, we see that the CSD registration says that the total annual turnover is 10 million or less. So one of those two figures must be lying, possibly both. Do you agree that this VAT fraud ought to have been picked up in the course of the adjudication process and ought to have resulted in a disqualification of this bidder?
Yes, without having technical knowledge, I fully agree though. As I say, finance, they can answer better on this, but us seeing here, I fully agree with you. So, thank you.
Can I point to another fraud that ought to have been picked up in the process? If you go to page 181, you'll see that Buena Vista described its principal business activities as training and skills development.
Yes.
But if we go to the CSD at page 311, we see that we're told that its principal business is in fact construction.
Yes.
They can't both be true. You agree?
As I say, from my level, I don't know your expertise, it looks like there is some discrepancies, unless they are saying they are doing training on construction of buildings, I don't know. But from what we see, I see those irregularities. Thank you, Chair.
Mr. Chaskalson, what do we do with industry classification 2? Because there they do mention that it's education.
Indeed, but if one looks at principal activity, 35% is for construction. I think it was a 25% for education. 35 for construction is a 25 for education. So the principal activity of this company, according to the CSD report, is construction. Can we go to page 184 of the bid?
184.
There it says that the legal entity is a company, not a joint venture. You see that?
Yes.
But if one looks at the bid, it is based on partnership agreements, which is what one would expect to see in a joint venture, not a company. So we see that at page 303, the bid is supported by a subcontracting agreement where the principal is CTC College, Pty Limited, and the second partner is Buena Vista. And I'd ask you to note that CTC College is represented by MJ Madzibadela. We're going to come back to MJ Madzibadela later. There's a partnership agreement there. And if we go to page 375, we see another partnership agreement, this time described as a memorandum of understanding between Nhlanhla Cleaning and Security and Buena Vista Learning Academy. Now, the bid had to be based on a partnership because Buena Vista, being a Chesanyama company, or apparently a Chesanyama company that until recently was in a completely different industry, had no training accreditations of its own. So if we look through this bid, we will see that there are no training accreditations that Buena Vista itself had. And let me take you there. But for now, before I take you there, would you agree that if Buena Vista had no training accreditations of its own, it couldn't qualify for this bid? Certainly not without entering into a JV with somebody who did.
I'm going to repeat that I'm agreeing with you from the layman's point of view, and I don't want to say I'm talking here on behalf of Finance Department. From the layman's point of view, but I'm sure Finance will have reasons and understanding of how subcontracting works. So I don't want me conceding to be a position of the Finance Department. I'm just saying from the layman's point of view, all this looks very strange. Thank you, Chair.
Let's go to accreditation. There were a series of accreditation letters put up by Buena Vista. There were 5 in all. The first one appears at 343. Sorry, the first one appears at page 332. And you'll see that that accreditation letter is issued to a company with a similar name, but a different company, a company called Buena Vista 143 Pty Limited.
Yes.
But it was issued if one looks at the print date, on 5 April 2023.
Yes.
When this company wasn't called Buena Vista Learning Academy, it was called Mokoko Grill. You recall that?
Yes, I recall that, the name of
So it had to have been issued to a different company altogether, because if it was issued to this company, it would have been addressed to Mokoko Grill. The name only changed in July 2023.
Chair, I keep on agreeing on certain things, and my concern here, I'm not a technical expert on this, and I don't want to sound like I'm going to be supporting irregularities. But I see something that says, attention, Matzibadela, excuse me if
Matzibadela, yes,
Yes.
we're going to get to Matzibadela.
Yes.
You'll
so-
recall that Matzibadela was part of CTC, the partnership agreement.
Yes.
So this is an accreditation letter issued to a different company with a similar name, but issued to a company belonging to the person who has now apparently, if indeed these are not all forgeries, who appears to have gone into partnership with Buena Vista Learning Academy.
Yes.
But it's not an accreditation letter for Buena Vista Learning Academy.
Well, it says here Buena Vista 143 Pty. I don't know what that means, or it's another company of Buena Vista. Yeah, but I agree with you. It's not the same as the initial name on the tender.
Indeed, it's not the same, and it couldn't have been the same, because
Yes.
at the time that this letter was issued, if this letter is not an entire forgery, 5 April 2023, the company hadn't changed its name to Buena Vista Learning Academy Pty Limited. It was still called Mokoko Grill Pty Limited. It only changed its name 4 months later.
Yes.
Now, the fact that an accreditation letter to a company with a similar but different name is included in a bid for Buena Vista Learning Academy strikes me as an attempt fraudulently to pass off this accreditation letter as an accreditation letter of Buena Vista Learning Academy. Do you have any comment on that?
I'll repeat, in some areas I sort of agree with you where I see irregularities, but I will not make deductions on behalf of another department. Thank you.
Well, I also want to put to you that this attempted fraud ought to have been picked up, and it should have resulted in the disqualification of Buena Vista Learning Academy. You're nodding.
I'm nodding. As I said, from our layman's point of view on my side, it should have been picked up. I agree with you, Chair. Thank you.
The second accreditation letter is at page 343. That's an accreditation letter issued to CTC College Pty Limited. The third, and again, it's not for Buena Vista, the third accreditation letter at page 357 is issued to CTC College, and here we see Mr. Mkhwanazi as the addressee. Again, it's an accreditation not to Buena Vista but to another entity. The fourth accreditation, page 370, is again to CTC College, not to Buena Vista. The fifth accreditation is to Nhlanhla Cleaning, and you'll remember that Nhlanhla Cleaning were the second entity with whom there was a partnership agreement.
Yes.
Again, there's no accreditation of Buena Vista.
Did you mention the page?
372. 372.
Thank you.
So Buena Vista produced no evidence of any accreditation that would have qualified it for this contract. Do you accept that?
Yes, from the layman's point of view, I accept that. Thank you.
What do you mean by that? I mean, this one, there's nothing because in respect of everything else you've been saying, you lack the necessary expertise. I don't see the expertise here. This is about letters of accreditation. If you think there are letters elsewhere, maybe that's what you should say. This one has nothing to do with the expertise which has been your refrain throughout.
I think, Chair, what I'm trying to say, there's certain processes regarding subcontracting and also working with certain institutions on matters. I just grappling to understand how those agreements work. Hence, I'm saying from my point of view, indeed, something doesn't look right, but I don't want to speak for the finance department because they will be a technical expert and understanding how maybe these things are done, Chair.
Technical experts who will say there were letters of accreditation directed to Buena Vista training. This is a simple factual issue. I do not see this expertise that you keep referring to, at least not on this instance or not in this regard.
Chair, maybe we're not understanding each other. I'm saying...
I understand you perfectly. I understand what you are saying, but I do not understand what you mean by it. Yes, please.
Thank you, Chair. I'm saying, Chair, there are ways finance will do things about partnership, about memorandum of understanding to ensure that there's compliance. I don't want to speak for them, for that department, but I'm saying from where I'm sitting, I'm not from finance, things doesn't look good. I agree with you, but I'm saying my position, I wouldn't say, I might say it doesn't look good as Linda, but they can come and say the reason these things happened, it was because of this and have an explanation.
I will not take it any further, but I just do not understand because this is about, is there or isn't there a letter? It's a simple fact, nothing about expertise, but as I say, I will leave it there.
One of the other requirements of the bid was letters of reference. There was a letter of reference at page 317. It came from the city of Johannesburg, but it was a reference in support not of Buena Vista, but of CTC College.
Yes, I see that.
So that tells us nothing about Buena Vista.
Yes.
Then at 3 to 8, we see a reference which is in favor of Buena Vista, but it comes from CTC College and the ubiquitous MJ Madzibadela. So at 318, we see there is a letter purporting to be a reference in favor of Buena Vista in recognition of their exceptional performance in successfully delivering the training, recognition of prior learning assessment and moderation for National Certificate in Occupational Health, Safety and Environment, NQF Level 2 program for 80 learners. Buena Vista has consistently demonstrated their dedication to providing a comprehensive and high-quality education. The training program developed and executed by BVLA has effectively covered all the necessary components of the national certificate. On and on it goes. But it comes from Mr. Madzibadela, who is their ostensible partner in this project. Then there's another one, also a reference letter for Buena Vista. That's on page 319, coming from a company called Symbol Consulting. And would you believe it? It's also signed by Mr. Madzibadela. Page 319.
Yes, I can see that. Sure.
And just to complete the picture in relation to Mr. Madzibadela, he also pops up in the bid at page 357, where he is, and I think we've actually been there already. Yes, this is the third accreditation letter, which is for CTC, and which is addressed to him personally. So it seems to me that what's taking place here is definitely a fraud, and it may or may not involve Mr. Madzibadela. It may be done completely without his knowledge. All of these things may be being put up without his knowledge. Or he may be colluding in it, we just don't know. But what we do know is that Ms. Baloyi and Buena Vista Learning Academy have, in this application, perpetrated a fraud on the city and have taken almost 3.5 million rands out of the city as a result of that fraud. Would you agree with that?
From the deductions that are made, I agree with you, Chair. Thank you.
Before I leave this topic, let's look at the financials that were put up by Buena Vista. Page 395 is where we find the 2023 financials. And they purport to be certified by an accountant. I won't mention his name, but we are going to call him, because if he did certify these financials, he has something to answer for. If he didn't, then we need to know that his name has been used fraudulently. On the following page, page 396, there is a signature of Ms. Baloyi as director. And what you'll notice about both of these pages is neither of the signatures is dated. One doesn't see a date on any of this, which I want to put to you ought to have been another red flag. One doesn't see financials that are signed without a date in the ordinary course of business.
I fully agree, Chair.
There is another fraud, which is that if one looks at page 403 of the financials, and bear in mind that these are financials for the year ending February 2023, we see there is a note in relation to directors' remuneration, which says that a salary of over R1 million was paid to the director Tsakani Baloy, or T. Baloy. But of course, in the year ending February 2023, Ms. Baloy was not a director of this company.
I agree, Chair.
So what we have is a bid that is full of transparent frauds, but none of them seem to have been picked up in your procurement process, in the city's procurement process. Do you have any way of explaining how this could have happened? It's not just one disqualifying feature that was missed, it's about 10.
Thank you, Chair. As I said, I'm not involved in the procurement processes. I've explained it, all those three committees. I don't sit. The line department, who's got a tender that is ongoing, doesn't sit there. Finance might need to explain. It's going to be very important, Chair, that I explain. I've never seen this lady in my life. The only time I saw her, it was on TV when this whole thing started. If she goes in a mall, I go in a mall, we'll probably pass each other. I don't know her. I've never seen her. If what happened here, the perception is she was done favors, it will have to be taken with finance. I'm not involved in these processes. Thank you, Chair.
You see, on the strength of a bid that should have been disqualified on any one of a number of obvious grounds, the city has paid 3.5 million. And it's paid it to a person who just happens to be the partner of Kat Matlala, who is driving around with blue lights that were obtained through the city. Does that not strike you as somewhat worrying on both fronts?
Chair, when I was speaking to my legal team yesterday, and we're going through the payments, this is one of the companies. At some point I said, they mustn't be utilized. Initially, when I took over, after I think Makosi left and I started being involved here before we could fill the position on training issues, I picked up that there was no rotation. Therefore, we couldn't guarantee equitable share of service providers. I called my team in that division and I said, this must be done correctly. I further called the head of EPMO to come and assist in terms of coming with the system to ensure that bidders are given equal opportunity. And there were about 2 or 3 bidders. I was not necessarily happy with their work. And if I recall, this was one of them. I said, when I saw that there was a payment that happened in, I think in November last year, I was a bit concerned because in my take, I said, let's stop utilizing this bidder. But because I would have been involved probably to sign the order, I'm not 100% sure. I didn't find those documents here. I can't explain why did we continue with this bidder, but there were 3 of them I was not happy with their work. And the certain demands that I understood that they might have wanted to do work specifically for EMPD. And I put a red flag on that. And I will still take full accountability that continued to be utilized, despite the fact that I said I'm not happy with them. There were 2 or 3 of them I said I'm not happy. And I really want to emphasize, I've never seen this late in my life. But I did pick up that the work that they were doing, I was not 100% happy with, and some of the demands that were starting to be made. Thank you, Chair.
So can I ask a couple of issues flowing from your response? You seem to have had a range of concerns. The one is that the work was not satisfactory. Is that that this company was not providing training of a sort that you've regarded as satisfactory?
In terms of the tender that we agree, what must happen on the tender, if I can recall some of the areas, you train, after training you give certificates. And sometimes how the certificates are done and how long they take to be done, it gives problems. So as I say, as much as I can't recall all the events, there were 3 of them I was not happy with how they do the work and how long it takes to get the certificates. I think it was in one of those reasons that I said, let's not use this particular company.
And this was one of those companies?
Yes, Chair. Hence I'm saying I got shocked when I saw that there was, again, I'm not sure that the payments that happened towards the end of the year, because we don't always pay immediately after the work has been done. If it was after I've stopped or it happened before I said they must stop being utilized, that I couldn't answer to, Chair. Thank you.
And when would you have raised your concerns and asked for this company and 2 others not to be paid any further?
I think it would have been, let me check, I don't have specific dates. I don't have specific dates. But it was during the time I started looking at the allocation of work and the equitable share, and then also the performance, because one of the systems I've put in place was we must report to finance of the work that is done quarterly. So I can't recall which quarter and when did I do that red flag, but I did pick up as one of the red flags and the companies I wasn't happy with. Thank you, Chair.
I mean, can you give us any specificity? Are we talking about 2024, 2025? When would this have been?
If I can just get the page of the invoices. I think it would have been towards end of 2024 or early 2025, Chair. I think, yeah, towards end. It would have been maybe, let's say, around that April 2025, maybe.
There's another issue with this payment schedule that, well, before we get to the payment schedule, can I ask you, you said that there was an allocation issue that concerned you. Do I understand you correctly, meaning that there was, as it were, a panel of service providers who'd been appointed? There were more than one successful bidders on that bid. And this service provider was getting more than their fair share. Is that what the concern was?
It might not be this one in particular would have got more share. There would have been more others that would have got more than she would have. So when I was talking about equitable share, I wasn't specifically focusing on this particular one. I was just talking in general for the whole panel that has been appointed.
So that was one of the issues you were addressing. You were addressing 2 issues. You were addressing allocation and you were addressing quality of work. Yes. And you recall that this provider was flagged for one or both of those issues.
Yes. Thank you, Chair.
Who did you raise these issues with? And where would there be a documentary record of it?
The documents, it will be the allocation schedule. And I raised it with, as I say, head of EPMO. And the lady was assisting after Mkhwanazi left. But in terms of records, what records you can get in the city is the allocation schedule. Thank you, Chair.
But if you raised it with someone, there should be a documentary record of that. I mean, presumably it would be written down somewhere in an email or in a memorandum. Where would we go to find that?
The allocation schedule, you should find it in HR or you should find it in finance. As I say, if I recall, we also submit quarterly reports. So between, I wouldn't know the name specifically in finance, but in HR, from the training team, I think the acting HOD will able to assist where the team can collate the documents and make them available.
But that's the allocation schedule, but I understand that, or maybe I'm misunderstanding your evidence. Did you issue any instruction to someone saying, don't allocate work to this service provider, either they've got too much already or they're not giving us certificates? Will we find an email or a memorandum to that effect?
I'm not 100% sure if there will be an email, Chair. When my team raised the issue, their concerns, and I follow up those concerns, I then made that decision there and there that don't allocate this person work. Sometimes when they do bring the allocation schedule, I do make comments, but I can't recall. Hence I'm saying I think in the allocation schedule, you should get some of the answers you're looking for.
But I'm still trying to understand the process here. There must be written records of decisions of this nature. Where will we find them?
Hence I'm saying on the allocation schedule, it should give a direction. Rather than that, I doubt you'll have any other information. But I can check the emails. I will ask the city, or they can assist you because I think they do have access to my emails to check if there would be any discussions of that nature.
Who produced the allocation schedules?
It's the divisions, talent, HR strategic and talent division. There's two ladies. There's a gentleman and the lady. There's Zama and the gentleman, I think is called Ngozi, I forgot his name. They will be the ones that will bring the schedules.
Mr. Shaskalson is asking for proof of you having queried the allocations, and you referred to the allocation schedules, which you say were produced by other people, not by you.
Yes.
So he wants to understand how you referred to that if it was not your document.
As I say, Chair, I would normally make comments. I'm hoping that those comments can be found. And another way, it will be seeing the pattern. There should have been a change from beginning of when we started allocating and how the tender started going. You know, I can't recall all the events now, but sometimes, for instance, I wouldn't sign a document. I'll just return it and say I'm not happy. So that's why it becomes difficult to get all the evidence. But I'm sure the lady is very helpful. Uzama can be able to assist.
Thank you.
Thank you, Chair.
Just to clarify, I had understood your evidence earlier to be that when purchase orders were brought to you, you refused to sign them. So you are surprised that subsequent to that, there were payments made to this company. Did I understand that part correctly?
I said, Chair, I was shocked that there was a continuity up to towards the end of 2025. And I said, I take full accountability. That's what I said to the legal team. I should have picked it up. So, you know, so I'm taking full accountability. But surely, I know for sure that I was not happy with their work.
But what did you say something about purchase orders and the fact that you had to sign them and you refused to sign them?
No, I said, Chair, I made a note and maybe an instruction that says, let's stop utilizing this company because of the challenges they brought to me.
And
however,
sorry to interrupt you, where would we find that, where you made a note that we should not use this company anymore?
I said we might not have that. The only thing that can assist is the schedule, because sometimes I do make comments. I'm hoping that we can able to find that. Number two, you will see in the schedule that I don't think it's the worst company, it's the best company we paid, the highest. It's probably the lowest of the lowest. That you'll able to see that panel can guarantee you. So to me, what lacked in this evidence was that schedule. Or looking at all other companies, instead of focusing on this one, it will tell you how the funding was allocated. If that can be found, it will really assist this commission. Thank you.
Mr. Scots.
Mr. Gxasheka, just to understand about the purchase orders, were you responsible or were you in the chain of signing purchase orders?
I would have been a chain, Chair. As I say that, it's, the work will start at that division and then ultimately come to me. Even that evidence will be important because I would like to know, was I signing everything? If I did not, maybe might find that I didn't even sign the last ones, you know. So I would really would like us to find that information.
Would any payments be approved if they did not have if the purchase order, there was no purchase order with your signature on it?
It might be if the signing document, the purchase order doesn't need my signature. But if it needs my signature, it can't be paid. So hence I'm saying I'm not 100% sure if I was signing after I said they must stop or I did not. I would like to see those documents for me to comment.
Yeah, I'm not asking a question about before or after. I'm trying to understand how the system works. This is a service for your department. You are the HOD. You said something about purchase orders and you signing, and I'm trying to clarify that evidence that in the normal course, do you as HOD, if things are done regularly and properly, do you as HOD sign purchase orders?
Yes.
Okay. And would they be paid in the normal course? If in the normal course you sign purchase orders, would they be paid without your signature?
In fact, the payment, it doesn't happen after purchase order, Chairperson, through you, Chair. It happens after the invoice has been signed off by the department and my team and say that the work has been done.
Yes.
Then, under normal circumstances, I must sign that invoice before finance pays.
Yes.
Yes.
So unless there was any irregularity, as in removing your name as one of the signatories or someone forging your signature or representing that they are you, payment would not be made unless you have also signed off.
Yes, it should be like that.
Thank you.
Thank you, Chair.
Thank you. I propose to move to a different topic at this stage unless there are further questions from the Commission on the issue of this tender.
Just ask, I'm not sure how that I understood. No, I know I didn't understand what your answer is if you gave it. Mr. Chaskalson asked you about your role and involvement with this procurement process. And somewhere in your answer, you said, I would have made a presentation to the bid specification committee. Correct me, you will correct me if I misheard you, or you were just speaking generally, that's one. Keep note that. And then the second one was you were explaining who sits in the BAC, the Bid Adjudication Committee. You said the CFO, and then you said HOD. According to my note, you said CFO, HOD, and other HODs. Can you just explain that? So clarify first whether I heard you properly to say you would have made a presentation, and then the second is who in fact are the other HODs? When you say HODs, how do they get selected?
Thank you, Chair. I said at the beginning, Chair, my role on the bid specification process, I commented on a document that is crafted by Mkhwanazi. And I said they've been doing these kind of documents for years now. My only concern was that it doesn't have formal qualifications like a degree or honors and postgrad. If I'm not mistaken, let me correct myself, they might have a few diplomas and certificates, but a degree, and majority of our adverts, and they want a degree. That was my comment. going to the bid specification committee, I need to be understood. There's about 20-something HODs. So the city manager will appoint committees, bid specification committee, bid evaluation committee, and bid education committee. And those committees comprises of HODs and divisional heads. Then on the BAC committee, it will comprise of, you correct, I did say, I think the chairperson is the group CFO, and then he will sit with other HODs from the city. And my understanding, once a document, a tender has been adjudicated, it then goes to the city manager for the final signature. But the adjudicating committee would have made a recommendation. So that is my understanding of how these processes go.
I think what I wanted to understand is the other HODs. When you say HODs, who sits there? Does the client department, such as you, for example, in this contract that we are talking about, or in this bid we are talking about, so you are the client, you are procuring the service. Do you get as HOD to sit in the BAC?
No.
Is there a rule that says you don't sit, or it just happens that way, that you were not selected to come and sit on this one?
I was not part of any of these committees. The city manager used her discretion to appoint these 3 committees, and I don't serve in any of the 3.
Thank you.
Thank you.
Just a small matter of clarity. When you commented about the sort of qualifications that you thought should have been specified, or rather, which Ms. Baloyi did not have, according to you, in what capacity did you comment?
I commented as endorsing the bid specification document from the division, my division, one of the divisions I'm responsible for, when they come with the criteria. So I've said, you always using these similar qualifications. I'm aspiring that we move beyond just having diplomas or unit standards. Can we include degrees and others? That's all my comment was.
At what stage of the process was this?
It would have been before they go to bid specification.
So during once bids were in, you never participated at
No.
at any stage?
As I said, I don't know if it's a rule, but my observation for the all years I've been in the city, if it's your department that is tendering,
Okay.
I haven't seen an HOD who go and present an item in
thank
any of those 3 structures.
Thank you.
Thank you.
Sorry, I said I wanted to leave this topic, but just flowing from those questions, it does occur to me that there's something else I need clarity on. At what stage before the bid, or how long does it take before the bid goes out for public invitation for the bid to be finalized for the bid specifications to be finalized at bid specification committee? In fact, if you can take me through the process from the very beginning, because presumably this process is triggered by a decision in your department, we need to procure these services. Then there's a process of finalizing specifications. Then the specifications are adopted by the bid specification committee. Then there's an invitation that's put out publicly. Then the bid then tenders get submitted and go through the BEC and the BAC. I'm interested in understanding the length of the process before the invitation. So at what point in relation to this tender would a decision have been taken, we need to ask for new service providers for training?
Without specifying through you, Chair, understanding how National Treasury craft the circulars, but the ideal situation, it must be 6 months before the current running tender expires. So it would, it normally should start, if it's gonna end in June, June the following year, it should start about January.
And there was a running tender in place in this case that was going to expire. Was there a training tender in place?
Yes, there would have been a tender in place.
No, not there would have been. I mean, you were head of department. Was there or wasn't there?
There was.
There was. So 6 months before the expiry of that tender, there would have been a decision taken, let's get ready for the next tender. And do you know when that tender expired? Because the closing date for this bid was the 24th of July. So you wouldn't have, I would imagine you would have wanted to leave some time for the bid to be awarded rather than having a period where your old tender expired, your new one hadn't been awarded, and you then had to extend or find some other solution.
And what's your question?
So when would the old tender have expired?
It would have been, normally it expires end of June. So it would have been end of June 2023 or 2024. Our financial year ends in June. So it would have been June between those two, 2023 or 2024.
But the closing date for this tender was 24 July. So the bids had to come in on the 24th of July.
Which year?
2023.
Okay.
But if the bids are in on the 23rd on the 24th of July 2023, it certainly couldn't have been that the old tenders were expiring in June 2023 unless there was mismanagement of the process. Do you accept that?
It happens sometimes, and the reason being, hence even a national treasury standard says start 6 months before, but sometimes you'll find out between the department and the bid specification committee, there's left and right, and eventually they find each other, then endorsed, then gets advertised. Then after being advertised, it goes to evaluation processes. Even there, sometimes there will be back and forth, and the aim is to identify these irregularities we identified here today. And in those instances, it doesn't always happen. There might be an extension of the previous tender.
So you can't tell us exactly when the old tender would have expired, but you think it is likely that it would have expired either in June 2023 or in June 2024. Thank you. That clarifies that for me. The next topic that I want to move to is very briefly just to deal with two issues relating to Mr. Spies, and I don't want to spend too much time, but the first relates to your allegation yesterday that what Mr. Spies did in respect of I think it was the Sintel tender, was misconduct, and you slightly backed off from the allegation that this was fraud. But were you aware yesterday that Mr. Spies's challenge to his suspension in that regard has gone to arbitration, and an arbitration award has been made in favor of Mr. Spies against the city? Were you aware of that?
No, I wasn't aware. In fact, I was shocked when I saw it, because when it was supposed to have happened, the next appearance date, I think it was a month ago, we had an understanding with the city's lawyers that they will allow me to appear here at Madlanga Commission, and then thereafter I will go and present my case there. So I wasn't aware. I only saw it when you sent to the legal team I work with. Thank you.
Because there are certain features of this arbitration award I want quickly to run through with you, because it's not just an award in favor of Mr. Spies, it is a truly emphatic award in favor of Mr. Spies. On page 421 of the bundle.
Mr. Chaskasin, we put away the tender documents file.
Yes, although I think it's probably going to be in the same file. It's page 421 of the same file.
Oh, yes.
The award.
418 of file 2 of 2.
It should have been filed at the back of your.
Yes.
Is it? It is.
Yeah, in the supplementary.
Sorry. Yes. So at page 421. On 5 February 2025, the applicant was served with a letter of intention to suspend dated 4 February, which was signed by Linda Gxasheka and Maripa Machokocha. The applicant stated that he had handed in his uniform, equipment, etc. on 6 and 7 January because he was leaving the city already. Is that correct?
I don't know. Apologies, I wouldn't know. You would hand over to, if it's in case that's how they work, you don't work your notice, then you would have handed over to EMPD. Apologies,
Well,
I don't have
but
knowledge.
isn't that something that you ought to have investigated before you decided to issue a notice of suspension? Because if he, in fact, had already handed in his uniform and equipment and was not working off his notice because he had accrued leave or whatever, then what on earth was the point of a suspension?
It's something that I'll learn from it, and it will need to be investigated and ensure it doesn't happen going forward. In terms of Basic Conditions of Employment Act, when you serve your notice, you don't take leave. So if it happened in that department, they will need to correct it.
But if he had handed, I mean, surely this is something you ought to have investigated before you decided to suspend someone. You suspended someone who, at least on the factual finding in this arbitration, wasn't going to be at work for any period of the suspension anyway.
As I said, Chair, I wouldn't think that the department won't comply with Basic Conditions of Employment Act. In your last working months, or your last working month specifically, you don't take leave. So I wouldn't proactively think that, let me investigate that an employee who's serving a notice is not at work, because it's not supposed to be like that. But now that we learn from here, in the future is something that a person would look at. Thank you, Chair.
But isn't it something that you should have investigated? I mean, one of the reasons this suspension was set aside is that you didn't afford Mr. Spies any hearing whatsoever before deciding to suspend him. Isn't this an illustration of what purpose a hearing might have served? If you'd heard him, he'd have said, well, look, I'm not going to be here anyway, so why suspend me?
As I said, Chair, I expected that if you're serving a notice, you should be at work. Now that we know that he was not at work, it's something that I would look in the future.
That wasn't my question. My question was, you had given him a hearing. This would have come out, and you would have understood that a suspension would have served no purpose, but you didn't give him a hearing.
What happens, you get a notice of the intention to suspend, you respond to that, and then the suspension happens. And after that suspension happened, there was an investigation report that was done. So the process was followed. I'm not 100% sure when you say we must have given him a hearing. Maybe I'm missing you, Chair. Through you, Chair.
Well, let me leave that one. Can I take you to...
Can I just ask, the process that we have come to know works at EMPD is you first give an intention, a notice of intention to suspend. That's what Mr. Chaskasin is discussing with you, that there's an intention to suspend before you say, I have suspended you now. And that hearing is they respond to your intention to suspend and say why they should not be suspended. That did not happen here. In fact, what Commissioner Spies said is the same time as he got his intention to suspend, he actually was told you are suspended. And you are responsible for that process.
Chair, I would have to go through the document thoroughly. I think we're speaking the same thing, that my understanding of the process is it will be noticed to suspend, you reply, and then we suspend. If there was an irregularity on that, I will need to investigate. It shouldn't have happened that way. And as I say, I have not had enough time to thoroughly go through these documents and get the award. Maybe after lunch, can I respond to that? But ideally, the process is we suspend. Where we normally differ, it's when we say, while you are being served, then bring the documents. But normally you respond, after responding, then the determination is made.
When we come back from lunch, I would like you to provide an explanation of what happened here. Thank you, Mr. Chair.
There's another significant finding here. If we go to paragraph 12 on page 423, where the arbitrator appears to have had regard to the recommendation of the Bid Adjudication Committee and the decision of Dr. Mkhwanazi, because he refers to documents. The Sintel contract was extended from 1 July 2024 after the contract was re-evaluated by the Bid Evaluation Committee. The applicant referred to the minutes of the Bid Adjudication Committee dated 28 June 2024, Vide A134 forward, and he pointed out he wasn't present at the meeting. The Bid Adjudication Committee inter alia recommended to the City Manager on 28 June that the appointment of Sintel be extended to 31 December 2024, and he cites page 170. On 30 June 2024, the City Manager, Mkhwanazi, approved the extension of the Sintel contract until 31 December 2024, A171. What is your comment to that? Have you ever seen the Bid Adjudication Committee recommendation and the decision of Dr. Mkhwanazi?
I've seen, thank you, Chair, I've seen them, but I will just need to check again in terms of the dates where there was a discrepancy. After, in the documents and the minutes, if I recall properly that I read, it said it was approved for 90 days. But then, after the 90 days expired, it continues beyond the 90 days. I will just try and find that document. But the issue was the discrepancy in terms of the additional 3 months.
We have an arbitrator saying that there is a recommendation that is approved that says the appointment of Sintel Pty Limited ... be extended to 31 December 2024. Are you saying there's no such recommendation?
I will have to check, Chair. All I know is if there was a 6 months extension, then there was an additional 3 months that was not approved. The issue that was at concern was the additional 3 months beyond what has been approved by Dr. Mkhwanazi.
But look at what the arbitrator finds. On 30 June 2024, the City Manager approved the extension of the Sintel contract until 31 December 2024. And there's a reference to a page. Can I take you to another document that actually reinforces this? It's page 256 of your annexure bundle, not the not the evidence bundle, so it will be file 2 of 6. Two five six. This is a letter from Sintel to the city. There are 2 paragraphs I would emphasize. The first is paragraph 2. As you are aware, the extension letter was ambiguous regarding the term of the extension. Upon verbal confirmation between Ms. Agnes van Rooyen and Mr. Johnny van der Merwe, it was confirmed that the extension is for a minimum of 3 months up to 30 September and a maximum of 6 months up to 31 December. That's the letter that's given to the supplier. And then, paragraph 3, over the past 3 months, we received various informal communications, since neither WhatsApp or email communication constitutes an official notice to terminate the contract, from Colonel van Rooyen and DCOP Spies, that the contract terminated in September. So here is the supplier saying, Chief Spies has told us that the contract terminates in September, but in fact, the letter of appointment says it runs to December. And you are taking disciplinary action against Chief Spies for allowing a contract which an arbitrator finds runs to December to run beyond September when he has written to the supplier saying this contract terminates in September. Do you have a comment on that?
The issue, Chair, is exactly that there were verbal discussions that were taking place, and there were also understanding was the 30th of September. And putting somebody on suspension, Chair, it's not being punitive. It's for us to investigate the matter. So in this instance, we needed to ensure that River Spies and John van der Merwe are accounting for the confusion. The intention was not to punish anybody. So the disciplinary process started because we needed a clarity that there's verbal discussions versus what the contract might have ran. And decisions were made by EMPD, and our role as HR was to just assist them to ensure that there's clarity with this tender. Yes, I agree with you, the tender would have said up to 3 months and a maximum of 6 months, but the decision to ensure it's maximum of 6 months, it was the decision of EMPD. And we were assisting EMPD with the investigation.
But what this letter says is the opposite of that. It says that Mr. Spies has written to them, either on WhatsApp or email, saying this contract terminated in September. Did you do any process of investigating whether that had taken place and whether Mr. Spies was totally innocent of the alleged misconduct that it seems Mr. Mkhwanazi and yourself wanted to lay at his door?
The reason for putting him on suspension was to conduct that investigation, exactly that, Chair. If maybe he did not leave the city, we could have even exonerated him. But we all know the intention of putting somebody on suspension is to ensure that you investigate further without the interference of that witness. And that's the approach and the support we're providing from HR.
But you knew he was already leaving the city. You knew already in January that he was leaving the city. He'd given notice of early retirement in January. And he was going to leave the city with effect from the end of February. So you, in the first week of February, knowing that he's going at the end of the month, put him on suspension? Can you explain why?
And if I may add to that, he's already at home because he's serving 1 month notice. So he's saying, my 1 month leave, which I'm owed, my notice period, I will serve it while I'm at home. So already he's not at work. What's the reason for suspending him when he's at home and not at work?
As I said, Chair, is the suspension is to investigate. The issue that an employee is sitting at home and serving notice at home, it should not have happened. A notice you serve at home. And the issue of suspension, let's say he was at work serving a notice. It was for him to be away from the process, but I was not aware he was already at home from the side of the HR, because I would have stopped that and said he was supposed to be at home. And just because you're serving a notice, Chair, it doesn't mean you cannot be investigated.
Perhaps we should take the lunch adjournment at this stage.
Can I just make one last comment? If you look at paragraph 28 of this arbitration award, the arbitrator makes an extraordinarily far-reaching finding. He says, I am not satisfied that the respondent ever believed that there was a prima facie case of misconduct against the applicant, either regarding his alleged appointment of Syntel or regarding his extension of the Syntel contract. When an employer suspends an employee without having any reasonable basis to do so, it is axiomatic that the suspension of the employee constitutes unfair disciplinary action, short of dismissal. Essentially, you have an arbitrator finding that the city has acted in bad faith towards Mr. Spies. And that is in a process that you appear to have driven. What's your comment on that?
Chair, an arbitrator will always make its own judgment, and based on the evidence that is provided in front of that arbitrator. And awards that are made are always subject to review. And what is shocking in this matter is that it was concluded without my evidence, where I would have fully prepared and go and testify on this matter. So every arbitration is subject to review. I'm not in the city now. The city can decide that they want to review or they want to pay Mr. Spies. Really, my comment is that every award is subjected to a review. And without me participating in that arbitration process, I will not take accountability for. Those who went and embark on this process, they must take accountability. At least if they waited for me to prepare after coming here next week, I would have been there and I would have put my story and then the arbitrator make a final decision. At this point in time, all I can say, every arbitration award is subject to a review and is subject to the facts that were put in front of the arbitrator at that point in time. And Chair, I want to agree that I've seen that there's things that we could have done better. I want to agree on that. We could have done things better. And I've gone through that document. I didn't even browse. I just slid just through it. And I think if I can put my detail into it and go through it, and if I was given an opportunity, I don't know what the arbitration outcome would have been. Thank you, Chair.
What I do want to say is that in your statement, you accuse Mr. Spies in this regard of fraud. Now, do you want to withdraw that allegation at this point? Do you want to apologize to Mr. Spies?
Chair, I already spoke yesterday about issues of fraud. And I think Commissioner Baloyi, we discussed that thoroughly. And I said...
it was in a different context.
I was about to say...
It was about the pension payout.
Yes.
You're being asked about these charges, this charge of disciplinary.
I need to respond to that.
Yes.
The issue, Chair, we discussed about fraud yesterday and was asked to withdraw. it was exactly the issue of pension fund. And the issue of the extension of the contract is something else. And what I'm saying, I don't know if my statement, I spoke about fraud when it comes to the Sintel issue, or I was referring to the process that we embarked upon in terms of the allegations that were brought to the fore. If they are, I will go through my statement and I will come and give another answer if there is need to have another answer after lunch. But I don't recall talking about fraud issues on this particular matter.
Let me help you. Paragraph 104 of your statement. He was suspended for the fraud and related matters of the extension of the service provider contract. Page 35, paragraph 104.
Yes, hence I've said that the issues of fraud, I'll come and clarify after lunch, the issues of fraud that we embarked upon, it was in relation to how the retirement was embarked upon.
No, you say he was suspended for the fraud-related matters of the extension of the service provider contract. You say that in paragraph 104 of your statement.
Okay.
Do you want to look at paragraph
104, page 35.
That does not require consideration and a response after lunch. It's your statement, so please have a look.
Come again, Chair?
I'm saying that does not require that you consider it during lunch and come and respond after lunch. It's your own statement, so please have a look at that paragraph and respond.
Okay, I'm looking for it.
And respond to the question.
Okay, in terms of the disciplinary action, paragraph 62, reverse peace disciplinary proceedings emanating from an unauthorized extension of a service provider's contract beyond the BAC, Bid Adjudication Committee, agreed 3 months. Reverse peace informed the Commission that he has retired and he
Mrs.
still...
Gxasheka, page 35 of your statement, paragraph 104, in line 5.
Okay, maybe I'm reading. Okay. On the supplementary, maybe I'm reading
Yes,
the wrong
sorry,
one.
are you in the original, in the supplementary?
Oh, okay. Okay, 104 says it is important to elaborate and make the Commission to comprehend that Rivers Peace was not dismissed. He took early retirement in order to go and work in the city of Tshwane. He therefore did not leave the city as a result of a new staff establishment, but rather because he found a job at the city of Tshwane. While he was serving a notice, it was discovered that the city, Ekurhuleni, in the city of Ekurhuleni, he was suspended for fraud-related matters of the extension of the service provider contract, and the evidence is labeled in the file. Chair, I would like to say that I see the discrepancy. In my original statement, when I was talking about the fraud issues, I was relating to how the retirement process was dealt with. And we engaged on that issue yesterday, that what is fraud versus maybe misleading, you know, and I agree that maybe misled. I would like to correct 104 to read the same way as the old statement, if possible.
But what's
so
your
I'm
response?
acceding through you, Chair, that we can correct that.
Withdraw the fraud allegation.
I'm withdrawing the fraud. I don't think it's a fair word to anybody. There was a misleading in terms of the pension fund issues. We could have dealt with that very well, better than he could have done. But on this matter, it was indeed about the extension of the contract. It's either 3 months and who went and extended beyond 3 months and the 6 months. Thank you, Chair.
Can I just clarify? I mean, you say that you want to frame it as you did in the first statement. Unfortunately, the same allegation of fraud is in the first statement, so I think you should withdraw it there too. If you go to page 22 of the first statement, paragraph 64.3, can you just confirm that you're withdrawing that allegation of fraud?
I've already done that, Chair. That misleading might be different from fraud. It might be a definition issue. But
No,
on the issue,
if you go to 64.3, fraud is mentioned twice. 64.3 at the foot of page 22.
I'm responding to that, Chair, that it was an issue of an extension of a contract between 3 months and 6 months.
Mrs. Gxasheka, it's a
Yes, sir.
simple point. Are you withdrawing the reference to fraud even in respect of the original statement, yes or no?
I did withdraw it, Chair. I'm
No, we're
withdrawing
talking
it.
about the original statement now.
I'm withdrawing it, Chair.
Thank you, thank you.
Thanks, Chair. Can we resume after lunch at this point?
Let us adjourn and resume at 2:10. Yes, Mr. Shaskalson.
Thank you, Chair. I want very briefly just to touch on the second allegation of fraud against Mr. Spies, but very briefly. We traversed some of it yesterday, and I didn't understand you to persist in the allegation of fraud, but I do want to draw your attention to a letter that you yourself wrote, and it is at page 410 of Supplementary Bundle 2. .410. It's page 410. It is a memorandum addressed to all employees by, the heading says Ms. Gxasheka. It's dated 16 August 2022, and it's about extended medical aid membership. And paragraph 1 says, this memo serves to confirm that employees who retire from council service in terms of the provisions of their respective approved pension or provident fund rules will be eligible for extended medical fund membership and an extended medical contribution benefit from the council. And then it's in paragraph A, it indicates who it covers, and A says retire on pension. Employees who've reached their retirement age as per their pension scheme rules and retire from the city's employment qualify to participate in the extended medical aid membership. Then in paragraph 2, it says the term retirement also includes early retirement as contained in the rules of the respective pension provident fund. So would you accept that Mr. Spies was entitled to take early retirement and claim the extended medical fund membership? In terms of your own letter?
Thank you, Chair. If an employee takes early retirement, he's entitled to the benefit. Thank you.
I want to move to a separate issue altogether, and that's the charges against then Brigadier Mkhwanazi. And those charges are in the annexure bundle to your statement. That would be file 2 of 6. And it's annexure LLG 18 on page 90 of that file 2 of 6. Do you have them?
Yes.
Are you familiar with these charges?
Yes, I am.
And you'll agree with me that they are very serious charges.
I agree.
And if we look at charge 4 in particular, it seems to me that this is the most serious of the lot. Charge 4 reads, on or about the period 2021 and 2022, you directly stroke alternatively indirectly allowed third parties to impersonate police officers through the memorandum which was contained on the letterhead of the city of Ekurhuleni, Ekurhuleni Metro Police, and furthermore allowed third parties to unlawfully use blue dash lights, knowing very well that the said third parties were not allowed to impersonate police officers by using blue dash lights. Will you agree with me that that is a particularly serious charge? Allowing people to impersonate police officers unlawfully.
Certainly.
And we now know with hindsight that the people who are alleged to have been allowed so to impersonate police officers are people under the control of someone who is currently standing trial for charges of attempted murder, kidnapping, and other serious offences. We know that. Will you accept that?
Can you repeat that, through you, Chair?
That the people who were allowed to impersonate police officers, people working for CAT security, were people who were working for someone, CAT Matlala, who is now facing charges of attempted murder, kidnapping, and the like.
I'm really battling, through you, Chair. I'm really battling.
Well, let me break it up. Who is it alleged did Brigadier Mkhwanazi allow to impersonate police officers?
I don't know.
Surely, surely you do know. It is, well, to whom were these blue lights made available?
From what I've heard and seen in terms of the video clips, it was made to Mama Cats or something like that.
Have you consulted the investigation file in relation to these charges ever in the course of the last 3 years during which they've been pending or potentially pending?
Remember, I've instituted a forensic investigation, so I'm fully aware. I think initially I couldn't hear your question.
You've done a forensic investigation, but have you read the allegations that gave rise to these charges?
Yes, I have.
So you say it was Mama Cat who is alleged to have driven with blue lights. Who else is alleged to have driven with blue lights?
As you read, that they were furthermore allowed third parties to use or flash blue lights. I
And
don't know who are those third parties.
You don't know?
No.
You don't know that there are allegedly people working for CAT security, that it is CAT security vehicles on which these blue lights were installed?
As I say, I don't know. I've never seen them. I don't even know how they look like. But from what you're saying, I agree that there were third parties that were allowed to use blue lights.
Are you saying here today that you're not aware of the fact that these allegations relate to the use of blue lights by CAT security?
No.
You're not aware that... How can that be?
I don't think we're getting each other here, Chair. I think we're missing each other a lot this afternoon. I'm saying I'm aware of the charges and I'm aware of what transpired. But the question that says, do you know these people? I'm saying I don't know these people. That's all I'm saying.
So you're aware that the charges are
Yes.
that CAT security was allowed to use blue light vehicles that were registered through the EMPD?
Yes.
Yes.
Please
And-
don't nod, please speak. Are you saying
Yes,
yes?
yes, Chair.
Yes, all right.
And
That's
you're
what,
aware-
Mrs. Gxasheka, that's what the question was throughout.
Yes.
You're aware that Cat Security is a company controlled by Mr. Cat Matlala?
Yes.
And you're aware that Mr. Cat Matlala is currently facing charges of attempted murder, kidnapping, and the like?
I saw that on TV. I was shocked. Yes.
Sorry, you were shocked.
Yes.
What shocked you about it?
Everything that I saw on TV that was said about him, the attempted murder and all.
And it shocked you, did it shock you because you knew him and were surprised that these charges were being laid against him, or did it shock you for another reason?
Okay, can you ask one question at a time?
Well, why did it shock you?
That there was allegations against him of an attempted murder of a lady, a former girlfriend.
Yes. Why did that shock you? Why did it come to you as a shock that Mr. Matlala was alleged to have attempted to kill his former girlfriend?
I think every attempted murder in terms of gender-based violence concerning to a woman, it will shock anybody. I'm not sure we'll be expected to have it normal.
So it's not specific, you don't have no personal knowledge of Mr. Matlala that caused the shock. It was just the nature of the alleged offence.
I've seen Mr. Matlala. I've met Mr. Matlala 2 or 3 times in my life. When I met Mr. Matlala, he raised a complaint of a woman who was pregnant and who was beaten up by the senior member of EMPD. And number 2, he raised other issues that, through you, Chair, I will not be comfortable to discuss here. Hence, when I asked for what is this, a risk threat analysis, I was serious about. When he was complaining that Ekurhuleni were protecting these 2 senior members, who, as I said, the first one he sent a complaint of a woman who was beaten up while she was pregnant. And the second one, it was that we were about to appoint a city manager and there were favors that were done. When this was brought to me, I said, I don't have the complainants. I don't have details. He then said, I'm protecting those 2 people, and because I'm protecting those people, it's gonna take us to a public protector. In one of my last conversations with Mr. Matlala, I said, I'm gonna say it in Xhosa, I'm not sure how I'm gonna translate in English because I said it in Xhosa. I said, if you've got issues, go and report them where they are relevant. When I saw him in December or January on TV, that's why I was shocked that a person who wanted to complain about another person, he can also do violence. And I told my husband, and I said, I've met this guy before. And what is shocking is that I said in my last conversation, so even some incidents that I have, maybe let me not get there, but I started panicking. That's the last time. And I'm gonna reiterate, because I can see I'm being associated with him there. I'm gonna reiterate, I've never met his wife. I don't know them, 2 of them. All I know, I met him about 2 incidents. As I said yesterday, I don't think every incident of Ekurhuleni is gonna be discussed here, Chair, because it's gonna implicate, with due respect, you are in a fact-finding strategy, and we're here to assist you. But I've said to Ekurhuleni before they suspended me in the OCMOL, have your own task team and deal with other issues that the Madlanga Commission will not be able to. Thank you, Chair.
So to take a step back, we have charges that a company owned by Mr. Matlala is allowed to pass itself off as, or people employed by that company are allowed to pass themselves off as police officers because someone inside the EMPD has unlawfully given them access to blue light vehicles through the offices of EMPD. Those are the charges. Those charges are sufficiently substantiated that independent attorneys engaged by the city have said, there is a case here, let us proceed with disciplinary action against the man who created this situation, Brigadier Mkhwanazi. You agree?
Yes.
That took place in the first half of 2023, that charges were formulated and that the attorneys were ready to proceed. And we sit now 2.5 years later, and nothing appears to have been done about this case. Mr. Mkhwanazi still hasn't been called to his disciplinary commission, as far as I can work out. You're nodding.
I'm waiting for you to finish your response.
Okay. How do you explain that? You were in charge of HR over this period. How do you explain that?
I've explained yesterday, I'm not going to start on the usurping of powers. I'm going to focus on the LR procedural matters that count most here. I've taken the commission through the emails where the charge sheet never got to see the day of light. Subsequent to that, Mr. Nhlanhla never delivered the charge sheet, and it was very clear that games were being played. Communications happened, including where Chief of Police wrote himself and said, I'm withdrawing the charges of Mr. Mkhwanazi. In fact, he says, I'm withdrawing the investigation, I think something like that. And when you look how this was managed by Mr. Nhlanhla, even how Chief has spoken to it, if you go to the forensic report, it's very clear when he talks to the charge sheet how it went. It starts when there was a decision to institute a disciplinary hearing. When Chief has submitted that to Mr. Nhlanhla, Mr. Nhlanhla took almost a whole month just to appoint the attorneys. He took the whole month to even implement. He goes and says in his statement, I read that, all of it yesterday, where he says, because IPID has confirmed that an arrest will happen, we had discussion and decide what is the point of me appointing attorneys if the people are going to be arrested. And he took that decision on his own. By the time he decided that he must appoint attorneys in the 30th of May, the DC was already stopped. The suspension was uplifted. My role, I signed the upliftment, I did say that, through an instruction, through an engagement. And in all our statements, Nhlanhla, Chief of Police, and mine, there's a collaboration that an instruction happened. The next area where I was involved, I explained all of this yesterday, it was on the issue of advising on the deployment. The question that remains is, why did the DC not take place? And that's why I instituted a forensic, that how clumsy can we be in having this DC concluded? The report of the forensic report came back, I think it was on the June 2024. And I said yesterday, when that report came back in June 2024, it was supposed to have gone to council. And in the midst of issues, there was an IPID report and then finally a legal opinion. Now I'm going to come back to the issue of usurping of powers. I've explained Section 64B, I've explained Section 64C. where everything ultimately lies with the accounting officer and ultimately lies with a chief of police. My role, if it was not enough commissioners, I'm sure there's room for improvement. But the latest I got myself involved on this matter, it was October, just before my suspension, where I still said, can I have the final file from Mr. Majang? Apologies. Mr. Majang, remember, is the one who served the charges. If we paid Mr. Majang and there was an instruction from an accounting officer to continue with this DC or where I could advise, it would have been if I had the file. I further said that in the forensic report, it spoke about limitations. So with the gaps, for me to go back to the accounting officer and say, look, we have to get this DC to go, it wouldn't have been easy without having all the information have. But most importantly, that the commission must remember, there was a legal opinion. Beyond that, it becomes difficult for me to take full responsibility. Lastly, the disciplinary process of Mr. Mkhwanazi, as far as I know, has commenced. My advice on that was, you don't even need to suspend this employee any further. Can we proceed with the DC? And that happens when there's a new city manager. As far as I know, as much as I'm not in the city, the DC, now that there's a new accounting officer, it's underway. And I'm one of the people who advise that I think there is an answer, a case to answer to. Let's fast track. We don't even need to suspend, but the DC must happen. And that subsequently was suspended. Thank you, Chair.
Let's take it step by step. The first issue, as I understand it, in relation to this DC, was back in 2023 when there was a failure to serve the charge sheet on Brigadier Mkhwanazi. You remember that?
Yes.
Now, we have conflicting versions. We have one version which says that that didn't happen because you had given instructions that he shouldn't accept it. You deny that. Have you taken action against anyone for failing to serve the charge sheet on Brigadier Mkhwanazi?
If you read the forensic report, by the time that recommendation was made in that year, Mr. Nhlanhla was no longer in the system. So it would have been very difficult to take an action against him.
But why did you have to wait for a forensic report on your version? It's quite clear that Mr. Nhlanhla had the responsibility to serve the charge sheet. As you say, all that required was an email because Brigadier Mkhwanazi was no longer suspended.
As I said earlier on, Chair, there's decisions that were made here. In that, there's an accounting officer who must account on these issues. There's the head of EMPD who must account on these issues. And at some point, some of the discussions were taking place without me. When I got to fully focus on this particular matter on its own, it's after the email, the anonymous email, where I said, can we get to the bottom of this and understand what happened? In between, majority of issues were discussed between a chief and the accounting officer. When chief said, I'm stopping this process, he then says to me, let's go and talk about it outside the institution. I said, I don't do talking outside the institution. It's your discussion with the accounting officer. I was not involved. Discussion took place between chief, accounting officer, and legal. I was not involved. And if they decided amongst three of them to stop the DC by allowing, saying the investigation is stopped, there was nothing I can do. Where I started having interest, it's when it got to public space and we realized that there were irregularities.
Gxasheka, what are the irregularities that you now realize there are?
As I said, Chair, firstly, we took long to deal with the matter. And my understanding, I think even when the chief of police wanted to meet with me, probably wanted to raise his frustrations. Because you can see that he signed this institution to discipline in April. You know, come in June, still nothing has happened. I think that's where his frustrations were. That's number one. And number two is when decisions are made, I'm not going to discipline or I'll discipline. I'm still making my mind. It's the second irregularity that we can improve from. And the third one is we appoint attorneys. After appointing attorneys, the process is stopped. It also becomes an irregularity, both on the procedure and also financial. And the last issue is, I think the legal opinion, we could have done much better on the legal opinion. And I think we've all learned from that.
I'm trying to understand your evidence and the chronology or sequence that you put. You became involved with this matter, and you became aware that Chief Mapia has written a letter where he says the investigation is withdrawn or something to that effect. You became aware of that. So at which point do you recognize there are irregularities? That's why I'm asking you, what are the irregularities you're referring to? And at which, maybe let me add a second thing, at which point do you say you became aware of irregularities?
I became aware of all the irregularities after we've done the forensic, that indeed we could have managed this matter better.
Hold on about managing it better. When is that? When you say after the forensic report, when is that?
It was in June 2024, but Chair, maybe let me rephrase this. When I said let's have a forensic report done, surely we did something wrong. I agree that with the current charges that we have, you could not just say, I'm stopping the process. And understanding that the chief stopped the process based on frustrations, that's number one. Number two, there's also a legal opinion.
No, he didn't stop the investigation. That's not his evidence. Let's not restate his evidence incorrectly. His evidence is he stopped because he was instructed, not because of frustrations. He says, I was instructed to stop.
Yes, I'm correcting myself. In his letter, though, he did say, I, Chief Mapia, I'm stopping. But you correct in other evidence, he did say he was instructed.
Yes.
Yes.
Okay. Yes, I'm still interested in, or I still need to hear you. What are the frustrations, rather, what are the irregularities that you say you later picked up and then you ordered a forensic investigation?
It's how the whole process was conducted.
No, but you knew how it was conducted. You knew there's a letter from the chief which says I'm withdrawing the investigation. And the conversation that Mr. Chaskalson is having with you is, these are serious charges. You are head of HR. And then I tag on. You see a letter from the chief that says, I've stopped the investigation on these serious charges. You are head of HR. At that point, what do you do about it?
When I got to know about stopping of the investigation, as I say, I started collating information after the anonymous letter from Mr. whatever, that says we favored, the city manager and the CFO, they favored Julius. Then when I start collating information, as much as it wasn't enough, I've realized files were everywhere else except in HR. Then I realized there's a problem here. And hence then I instituted that a forensic must be embarked upon. Number two, in the meeting we had with this accounting officer, we also felt that let's change even the disciplinary procedure so that HR and legal take full accountability. Remember, before that, I was not fully accountable. The main responsibility I had was more suspensions. Before and after that, other people are involved. In Mr. Nceza's statement, he also confirms that certain things were happening at an EMPD space without him being involved. However, there are decisions between Mr. Nceza and myself that we've made.
Let me stop you, Ms. Gxasheka. The matter is now with human resources. It's now with human resources. That's why Mr. Nceza is there. That's your department at that point. So the references to things were happening at EMPD don't quite work here because you've agreed to this disciplinary process, right? At the beginning, you agree to it, you agree to the suspension. You have one of your subordinates, and I think you say he was your direct subordinate, who is now providing the support to EMPD. You become aware that Chief Mapiyeye has written a letter which says the investigation is withdrawn or it is stopped, whatever that letter said. But you are aware this is about very serious charges. All five, not all six of them, not just charge 4. All 6 of them are very serious charges. You are a head of HR. You have your subordinate who reports to you who's dealing with this. You do nothing about it. You're happy to let it be. And I'm trying to understand that. You're the most senior person in HR. You're head of department. Employee relations falls under you. Discipline falls under you. And you do nothing about it. And then you say, I ordered a forensic investigation. That can't be a proper answer for this. If it was because you were instructed not to do anything about it, it would be a different conversation with you. It's either that or you folded your hands and did nothing about
it. Thank you, Chair. I hope we'll find each other, Commissioner Baloyi. As I said that the minute this matter came to our attention, I'll try and be slow. After the anonymous email, we were all called to account. I think if you read my statement, you read Chief Mapiye's statement and Nhlanhla, we're all called and say, answer, what happened? Roughly, things were explained. That is in August, if I'm not mistaken, around July, August. And immediately after that, the same day, if I'm not mistaken, to show how serious I was with this, I've changed the delegations based on the discussion we had with Dr. Mkhwanazi. After that, I instituted a forensic. The stopping of the investigation, Chair, I thought we discussed it yesterday, that it happened between Dr. Mkhwanazi, Advocate Kemi, and Chief Mapiyeye. I did speak to that I was not involved in those. When I started putting everything together, it's around August, that what happened here, what happened there, what happened there. I don't know if I'm answering you.
No, for now I'll leave it at that. You haven't answered. You haven't explained why you did nothing after you became aware that Chief Mapiyeye has written that letter. You did nothing. Fact is, you became aware of the letter and you did nothing. And then as you sit there, you say, later on I picked up irregularities. The point I'm making to you is you did not need the city manager to say anything to you. Once you became aware of that letter, you as head of department, human resources, would and should have said, if you were executing your duties, you would and should have said, you cannot do that. You can't withdraw the investigation or the disciplinary hearing because these are very serious charges and we must proceed with them.
Chair, as I say, what happened, the discussion took place between Chief Mapiyeye, Advocate Kemi, and the city manager. They made that decision without HR. And subsequent to that, there was a legal opinion that says stopped. I even said, if I recall yesterday, even when they went to the
You said there was a legal opinion that said stop.
That says we cannot discipline Mkhwanazi.
What legal opinion is that?
It was from legal to IPID.
No, that opinion doesn't say you can't discipline at all. We can pull it out if you want to. That opinion does not say to you, you can't discipline. It speaks to a different issue, that there is no fraud, it's not properly justified, and it requires IPID to write back and explain themselves. It doesn't speak at all to, in fact, it doesn't say don't discipline.
Okay, let me rephrase then. What it was saying, that there's not enough evidence that for the city to conduct a disciplinary hearing.
No, it doesn't say that. It doesn't speak to discipline at all. It doesn't say there's not enough evidence to discipline. It says there's no fraud that has been committed. It says nothing about discipline. So you could not have been relying on it. The point I'm making is you could not have properly, if you relied on it at all, you could not have properly relied on that opinion, because that opinion doesn't speak to the disciplinary action.
Chair, I said I'm speaking to a holistic process here. Discussions took place and there was a decision not to discipline. I said the Chief of Police did speak about this. He said, let's go and discuss this thing outside the city. And I said, I'm not willing to do that. The discussions took place amongst three of them. And when Dr. Mashazi has spoken, it is done. The only reason, remember, even when these discussions...
Is your explanation then, which is what I said earlier, you did not do anything because Dr. Mashazi has spoken. If that is your answer, that is your answer. And that became the reason why you don't act. Is that what you're saying?
Chair, it's exactly what I'm saying, but there's something I need you to pick up, ma'am. There's something I need to pick you up, and I think you're missing it. Well, there's these discussions that they made. I continued to try and follow this thing because I always knew it's going to catch up with us. Despite, as I say, officially there's instructions, but there's other ways of managing your boss. Hence, I still said, let's get the what you call this, forensic done. I said, Mahjong Inc. bring back the fund. When ultimately we got the forensic report, yes, it didn't go to council because of the limitations. The minute we had a different accounting officer, I'm one of the people who said, let's continue and proceed with this. So what I wanted the commission to hear is, despite that this process was stopped, from my side as HR, I did not stop. Because the minute, for instance, you change the procedure and say, now, Mr. Nhlanhla, you're no longer responsible. I'm taking over. Today, I'll be here.
You say, why did you decide you're taking over?
Because there were a lot of things I couldn't account to because of the previous allegation. I mean,
it had nothing to do with Commissioner Mkhwanazi's case, right?
It had to do with that and more.
In your statement, I don't think you say that. I think you speak about there were many unresolved cases, and there was a lot of money that is being spent. And even the briefing of attorneys was an issue because the way they were briefing, work was not being distributed evenly. So it wasn't because of the Mkhwanazi case that you changed the delegation of powers. In fact, I think yesterday you said to us, this has always been an ongoing process within the city. So it's not correct to present it now as if that came about because you were concerned about the handling of the Mkhwanazi case.
Look at the dates, Chair. Look at the dates.
Yes.
The dates, remember, every time you are called by your boss, accounting officer, you don't seem to know anything. You can't fully account. I said that yesterday. When the Bikul matter came, the same day, if it's not the following day, which those delegations were changed. Because I'm told you know nothing about these matters. You're not following these matters the way you should.
Let me read you something from your statement. Mr. Gxasheka, at paragraph 36, you say, on or about July 2023, after numerous concerns raised by the accounting
Apologies,
office.
Chair.
Para 36, at page 12, your statement. In fact, I'm reading the old statement. Let's look at where this may be in your new statement. It's a different paragraph. I'm told it's 72 in your new statement. Yes. At 71, that's where I wanted to read for you. Are you there? Are you there, Mr. Gxasheka?
Yes.
Yes. So this is your explanation for this change. You say, on or about July 23, after numerous concerns raised by the accounting officer and HOD Kemi Behari, I revised the financial delegation due to increased labor cases that result in excessive exorbitant labor costs, meaning that the expenditure on labor costs was increasing in an uncontrollable manner and the budget was allocated at legal risk, catering for all COE legal costs. And then at 72, you say that in August 23, the accounting officer raised issues relating to how labor relations cases are handled, especially MPD cases, including the case of Brigadier Mkhwanazi, as it was now raised via an anonymous person or email. This is the big email. So there's no account in your own statement of you acting before this date, before you got to the big email. You don't account for steps that you say you took to ensure that the disciplinary hearing doesn't die.
I think we're missing each other, but we're saying the same thing. I said I started consolidating issues when that big matter came.
Yes, my point exactly, that when you became aware of Chief Mapia's letter, you did nothing. And the next steps you took was when now the story of the failure to discipline Commissioner Mkhwanazi now became public, and you got this inquiry that was written to Jeff Weeks, the big message. That's what got you to start acting.
Chief didn't share the letter. As I said, when I started to say the engagement on the stopping of the process, it happened between three of them. And
so you never became aware of it before you got this big
that's what I'm trying to say to the panel, that to the commission, I got to consolidate and got to know everything, Chair, after the big matter. Then when I'm following up these things, I'm realizing, but we could have done things better. And if you hear me properly, I'm saying, even when we change the disciplinary procedure, I realize it cannot end there. We will account for this at some point. Hence, beyond decisions that were made by the three of them, I still pursued this matter. In 2024, before even the Madlanga Commission inquiry, I was still talking to the attorney, asking for funds. The latest, it was in October 2023. I really appeal that can my side of the story be heard. They've stopped the process. I did not stop the process. Yes, we could have done things faster and not be here. But at least I need that to be heard while everybody else stopped. I alone, HODH, I didn't stop. Thank you, Chair.
Where do we see that in your annexures, that after Chief Mapia's letter, you carried on before the big whistleblowing, I call it whistleblowing loosely, between the letter and when now you're called to account, because now it's gone public that nothing is being done, where do we see that you actually took steps? I haven't seen it in your annexures, and I don't see it in your statement either.
I think what I'm saying, Chair, I got to be aware of this whole matter after the big matter.
Right,
I
thank
really
you.
need you to record that. I got to be aware and I consolidated all these issues and I've never stopped. Hence, I'm here today to still talk to this issue. When they had those conversations to stop this matter, I was not party to. But the minute I got to be party to, I still proceeded and say how best we can close this matter. Thank you.
Thank you, Mr. Chaskalson.
I want to just, if you can indulge for a few minutes, Mr. Chaskalson. Mrs. Gxasheka, the forensic investigation you are referring to, the one where you got a report dated June 2024, that report was investigating 3 allegations. 1, whether Julius Mkhwanazi had been defamed. 2, whether the person using the pseudonym Biki breached POPIA. 3, whether Ngqiza, by appointing Majang as the city's legal representatives, acted without Mkhwanazi's written consent and therefore breached Mkhwanazi's rights. Now, those are the 3 allegations this so-called forensic investigation investigated, and they reached their conclusions. You can find it in Mapieye annexures on page 114. So when you say you took steps by instituting a forensic investigation to determine why the charges were not proceeded with, that is not correct. Because all this forensic investigation does is to go after the whistleblower, Biki. Those are the 3 allegations that are investigated. I don't know if you are in the Mapieye file, the annexures, or if you know where the forensic report is in your annexures.
I've got the I'll use mine. It's just that I don't have the pages.
Are you there, Mrs. Smith? Page 114, Mapieye annexures. Sorry, in Ribo space, my apologies, so my fault. 183 is
You can look at 183.
For
Chief.
Mapieye,
Yes.
Yeah.
Mapieye.
Thank you, Chair. Okay, you can, if you may repeat your question, Chair. Thank you.
All right, so
your
that
comment?
is the forensic investigation. If you look at 223, the allegations they were investigating and the conclusions. Are you on 223?
223.
223.
Yes.
Look at allegation 1, apropos allegation 1, criminal defamation. So they wanted to know whether Julius Mkhwanazi has been defamed or whether somebody in the city has been defamed. And then if you go to just before 13.6, allegation 2, whether the person using the pseudonym Biki has breached section 11 of POPIA by, again, disclosing information relating to Mkhwanazi. And you go to the next page, 224, allegation 3, whether Ngqiza, by appointing Majang as the city's legal representative in the Mkhwanazi matter, acted without obtaining Mkhwanazi's written consent and whether by doing so they have breached the collective agreement. Now, those are the three allegations these forensic investigators were asked to investigate. And they reach conclusions, and that's the sum total of it. Even when you read the front page of the investigation report on page 123, it tells you that it is a forensic investigation into allegations of defamation, breaches of protection of personal information, and appointment and payments to Majang Incorporated. So you can use this as an answer to Commissioner Baloy's question of what did you do when you became aware that the city did not continue with the serious allegations against Julius Mkhwanazi. You can't say, I instituted this investigation, because this investigation has nothing to do with why the city did not continue. This investigation is investigating three allegations. It is going after the whistleblowers who said what they said in the Biki email. And it says so.
Thank you, Chair. Chair, I would like to say that the report, I would prefer if it's written and understood in its entirety. And also beyond the report, my work that I continue to do on this matter, including where we strive to meet with Majang, and I wrote to them that give us the files. There were so many things that were discovered, and even on the recommendations, if you go to the recommendations, I think there's about, so many recommendations.
Mrs. Gxasheka, you're not going to answer my question because you are avoiding it. Let's just go to the report itself so that I can assist you. They tell us how this came about. Go to page 200, the introduction, on page 20, paragraph 7.6. I don't want you to read us this report. We have read it already. We know what it says. Now they tell us how the investigation came about in paragraph 7.6. They say, a memorandum dated 21 August 2023 from you outlined concerns relating to defamatory statements by Biki in his or her email to Wix, as well as possible violation of the Protection of Personal Information Act by you, and requested that the city conduct an investigation and focus on those issues. Who are the recipients of the charge sheet? Who printed the charges? Who is Biki? Contravention of POPIA, labor cases and how they are attended by ER, escalated labor costs. In a letter dated 23 August from Mashazi to Hleza, Mashazi requested that the investigation be instituted into concerns raised by Gxasheka. 5 September 2023, forensic investigation. Nowhere does it say why was the disciplinary proceedings against Julius Mkhwanazi stopped. That's not what they were asked to investigate. And they say so, that your memorandum dated 21 August 2023 was more concerned about defamation, breach of POPIA, and the appointment of the attorneys.
And Chair, if I may add, I think let's focus, it's quite a wide scope. Let's also focus on 7.6.5, where it says labor relations, grievances and labor dispute in the Ekurhuleni Metropolis and how they are attended by ER division. Now, let's understand workplace dynamics. Let's understand complexity of the matters. With the discussions that have happened, wherever they were happening, and stopping this matter, if I were to say to the accounting officer and everybody else, we are just investigating the Julius matter, it wouldn't have worked. The way I've written here, I've said labor relations cases, grievances and labor disputes in the EMPD and how we're attending it as ER division. And to me, I've said yesterday, while this matter, I'm not undermining it, it's very serious. there are other matters as well that we need to look at. And I'm saying today as well that beyond even this issue and the decisions that were made, I felt that let's investigate these matters of EMPD.
Mrs. Gxasheka, can I stop you there? I want you to accept that nowhere in the mandate given to the attorneys do you say, investigate why the charges against Julius Mkhwanazi were not proceeded with. Can you just accept that nowhere in this mandate do you deal specifically with why charges against Mkhwanazi were not proceeded with?
Chair, if they need to be specific on a particular stance that says specifically why Julius Mkhwanazi's investigation was stopped by Chief Mapieye, Dr. Mashazi, and Advocate Kemi, it's understandable. But to me, I was looking at that matter specifically and other matters. I will check the engagement later. I will try while we're busy and try and find it. Maybe in the engagement letter, it might also have the specific. I think there is where we speak about Julius, specifically the Julius Mkhwanazi's matter.
I want
Okay,
to
let me
focus on
help you.
Just where they say you told them here, it's not there. And then you'll be helped about the other letters because I want to leave this page.
Okay.
In this letter, it doesn't say that. In this letter, it talks about cases within Ekurhuleni and EMPD in general in this letter, especially in 7.6.5.
Chair, I've been following how things are going. I agree, Chair, that it won't say specifically why did you stop a DC of Mkhwanazi. And you know why it wouldn't say that? Because the ultimate decision makers, executive authority, has made a decision. And I've said yesterday, when you'll have discussions and debates sometimes, especially with the accounting officer, legally she already have answers. In my situation,
Mrs. Gxasheka, we're talking about this document on this page. We're not talking about decisions of Dr. Mashazi. I'm limiting my question now, having accepted your answer, because you said 7.6.5 says that. We went to 7.6.5. I'm putting to you that 7.6.5 refers to labor relations cases in Ekurhuleni Metro in general. That's what it says, and we can leave it at that.
Chair, I know
bear
I'm
in
going to
mind,
be punished for this, Chair. I'm begging for the last time, Chair.
Sorry, Mrs. Gxasheka. Bear in mind that Commissioner Khumalo is asking you these questions.
Yes.
Because of a response you gave answering a question by Commissioner Baloyi. You said that you instituted an inquiry suggesting that that inquiry was instituted in connection with the Mkhwanazi disciplinary process. So Commissioner Khumalo is seeking to demonstrate to you that this inquiry had nothing to do with it. That's the context. Do you now wish to respond to the last question?
Thank you, Chair. Chair, I'm going to try my last time and I'll give up. And I will take inferences that are made. When you read this report in its entirety, for instance, I'm going to take you, majority of the time the report talks about Mr. Mkhwanazi, even 13.83. For instance, it refers to Mkhwanazi's matter subsequently being withdrawn. It goes further and says recommendations that were made by MAPA and. Even on the recommendations themselves, Chair, on page 26, if you check this matter, it talks about Mr. Mkhwanazi and what we could have been done better, including where we should seek a legal opinion. Where it disturbed this thing, and it disturbed myself, for instance, where I was like, okay, this investigation report is raising other things. 14.4 of the recommendation also talks it says Mr. Mkhwanazi must lodge a complaint against EMPD senior officials. All I'm trying to say, as much as the scope was generic, but ultimately the scope was about the matter of Mr. Mkhwanazi. And as I say, 13.83, it also assists. There are others that are assisting on this matter. It might not specifically say, why did you stop the DC? However, it does talk to that it was withdrawn. Hence, I've said yesterday, and I'm done, Chair, I will accede if I have to. I said yesterday, if this report went to council and it was deliberated, the same way it's deliberated here, I assure you would maybe not even been here. And I think I've given the best I could. All I want to leave you with, I didn't make a decision to stop the DC. Yes, my scope could have been much better. But how do you say, Chair, investigate your own accounting officer?
Well, I think, Mr. Gxasheka, it's to try and make sure that what you say is factually what happened. You have said to us, you ordered a forensic investigation once you picked up irregularities, and you say it to show that you continued to do something to get this matter, to get to a disciplinary process, because that's what this engagement is about. The accusation is you had a role in Mr. Mkhwanazi not being disciplined. Now, what Commissioner Khumalo is doing is to show you that, but this forensic investigation that you requested, you tell us you requested, doesn't support you saying that it was part of you pursuing the disciplinary steps against Brigadier Mkhwanazi. You are correct that this report had something to do with the conduct of Mkhwanazi. That's what the big email is about. So that way you are correct. But what I wanted to do was to read you paragraph 8.3. Now, if you look at page 202, allegations, it states what you have said should be investigated or what should be investigated. It's defamatory statements, 8.1, as Commissioner Khumalo says. It's 8.2 is about leaking of confidential information, and 8.3 is the important one. This is where, for the first time, there's mention of Commissioner Mkhwanazi, but this is what he said, and I want to read that paragraph for you. It says, irregularities, weaknesses exist within the EMPD-ER division relating to management of certain labor relations cases with specific reference to the Mkhwanazi disciplinary matter, which resulted in the matter, this is the complaint, which resulted in the matter being unnecessarily referred to external legal service providers. That's the one complaint, right, that you're asking to be investigated. And or the city incurring escalated/wasteful legal costs, which constitutes a breach of applicable legislative prescripts and or applicable policies, processes, and procedures of the city, and or fruitless and wasteful expenditure. So this has nothing to do with an instruction to find out why Julius Mkhwanazi has not been disciplined. In fact, you're investigating Mlisa's conduct here about expenditure and the briefing of the attorney. So this report doesn't support you. Or what you ask them to do has nothing to do with you seeking to ensure that Commissioner Mkhwanazi is disciplined, not from this report.
In fact, Chair, I was looking for that area where it says specifically to reference to Mr. Mkhwanazi disciplinary matter. And I would like to concede that the way the matter will be understood from the other side and how I understand it, it will be different. And I want to say to the Commission, also look on the complexity of the matters.
What complexity are you referring to?
I'm saying you are an HODHR, you must write specifically and say you are looking at investigating senior management who made the decision to stop a disciplinary process, and you put it that way, it would not be as simple as that. And when you go to our contracts, you even have a clause on termination that says if you don't follow an instruction, that's a misconduct. I'm going to accept, Chair, that it might read differently, but when I said specifically on the disciplinary matter of Mr. Mkhwanazi, the outcome could have been anyway. And one thing I want to leave the Commission with as well. This investigation is sent to an internal audit. It's an independent, separate department. They appoint an independent law firm that could have came at a different outcome of any outcome they want. It was an independent process. I wouldn't want to say it was investigating Mr. Nhlanhla. It was investigating the process of Mr. Mkhwanazi. Where we differ in terms of the interpretation, I will take that, Chair, for the sake of progress. Thank you so much.
For progress, I will not engage much on it, but I'll just make the point that there's nothing about interpretation here. Although you do mention the disciplinary process of Brigadier Mkhwanazi, you are saying in so many ways that what you want investigated is why this matter, the Brigadier Mkhwanazi matter, was referred to external entities. That's what we are saying. And when you talk about interpretation, I think you are suggesting that perhaps from where we are sitting, we are misunderstanding what you are saying. And if you are suggesting that you see that differently, I'm surprised because it says exactly what I've just said now.
Chair, if we can go to page 205, for instance. Hence, I'm saying I'm sitting here, I've got my own, I'm contemplating things differently. In 205, clause 10.5.1, in fact, 10.5.
Is that the report now?
Yes, Chair, I just want to try for the last time so that...
You see, earlier, in response to Commissioner Khumalo, you trying to support your point, you referred to the fact that the report refers to Brigadier Khumalo, I'm very sorry, to Brigadier Mkhwanazi a number of times. Obviously, if in your mandate you have referred to Brigadier Mkhwanazi, the report will refer to Brigadier Mkhwanazi. Yes. That's only natural. Yes. And on my reading of what you referred to, that is exactly the context. So your point to me does not make sense. But anyway, let's hear what you want to refer to.
Objective, establish the processes followed in the management of employee relations at the EMPD and ER division. Obtain and review the SOP with regards to how labor relations cases are managed. Interview the relevant officials from EMPD and ER division to establish the processes followed in respect of labor relations matters. Which officials are responsible, conduct interviews, to determine above documents and annexure. I'm going to leave it, Chair, because I don't think we're finding each other. I think we're not winning on the complexity of my position.
I also wanted to say, reading the report itself, I don't see how that will assist you, because what's important is the mandate that you gave, and the mandate is right at the beginning. And we don't see how the mandate supports what you said in response to Commissioner Baloyi. So going to whatever the report says, I don't quite see how that becomes helpful. But anyway, you said you were stepping off the subject, and we've dealt with it for quite some time now. I think you are correct that we should step off it. Mr. Shaskalson?
Thank you, Chair. I want to just clarify a few things in the chronology and your role and where you say decisions were taken over your head. The key moment, it seems to me, where things go horribly wrong is that on the 21st of June, there is a letter from Chief Mapiyeye addressed to yourself, to Advocate Behari, and to Lieutenant Colonel Erasmus. And it essentially says, we have to serve the charge sheet by tomorrow, the 22nd of June. It's at page 180 of the Mapiyeye bundle. We discussed it yesterday. It says, we have to serve the charge sheet by tomorrow. Please serve the charge sheet. Tomorrow is the last day. Now that's addressed to you and it's addressed to Advocate Behari. I understand your evidence to be that sometime between the sending of this letter and the following day, the 22nd, a decision was taken at a meeting of Advocate Behari, well, not at a meeting, by 3 people, Advocate Behari, Chief Mapiyeye, and the accounting officer, that this prosecution was not going to proceed. Now, is that what your evidence is? That either later on the 21st or on the 22nd, those 3 officials took the decision, we are not going to prosecute Brigadier Mkhwanazi? Yes,
I did say yesterday it's my evidence. I even said when you check, when you look at the Chief of Police, I think Rivers Peace and Nhlanhla, there's where it says as well that I think Nhlanhla is saying the chief called him and said, Dr. Mashazi, Chief of Police and Advocate Kemi met, and that decision was made. So I'm sticking by that.
But you had a letter. You had a letter on the 21st that said, tomorrow is the last day. Please serve this charge sheet. Tomorrow is the last day. What did you do in response to that letter?
I said yesterday, I don't recall receiving that letter. I said, I don't recall. I've seen somebody signed for it, but that didn't look like my signature. I think it's indicted, but it doesn't look like my signature.
It looks like someone called Engelbrecht. Does that...
Engelbrecht.
Mr. Chaskalson, Mr. Behari said that was someone in his office, the Engelbrecht.
I take that back. At any rate, when was it communicated to you that the decision had been taken by the accounting officer and by Chief Mapiyeye not to proceed with this disciplinary process?
I've said earlier on where I got to know issues of certain events that happened in this particular case. It was after August 2023 when I started correlating information myself.
So are you saying that up until August, you didn't know that the accounting officer had said this prosecution must stop?
Yes.
So what did you do between June and August when, as far as you were concerned, there were very serious charges that needed to be brought against Brigadier Mkhwanazi that an external law firm had drawn up at some cost to the city, and that were waiting for someone to serve a charge sheet on Brigadier Mkhwanazi?
I think already we debated this with the commissioners, and it was clear that my report didn't do anything between whenever this happened up to when I instituted the investigation in August.
So you took no steps to push the matter forward between June and August?
Ekurhuleni is many cases. I might not have taken step on this matter because firstly, as I said earlier on, the delegations at the time, they were between EMPD and Mr. Nhlanhla. The only time I revised delegations, it was after August 2020, around August 2023. Yes, steps could have been taken, but some of the issues I missed. They happened outside my space. So nothing I would have done about it.
I just need clarity in that regard, because it seems to me that the job of serving the charge sheet was always a job of your department. Simply serving a charge sheet to start proceedings was your department's job.
We've discussed this yesterday, where in the evidence, in the form of emails, I've said that I've realized there were irregularities. The charge sheet was provided to Mr. Nhlanhla as early as 15th June 2024. And after that has happened, they were back and forth. Ultimately, the charge sheet was never, ever submitted to Mr. Mkhwanazi. And I've said yesterday, I'm really trying to be slow. I'm normally a person who talks fast, and I'm realizing it's not doing justice for me. I've said yesterday, the first email from Majang Inc. said save via an email followed by physical saving. Mr. Mkhwanazi was in the system. The emails of Mr. Mkhwanazi were working. It could have been served. Even when you make amendments, you still make amendments, you make them up to a disciplinary process as you go, as long as it hasn't been concluded. That process, indeed, it was irregular, and it's an area of improvement. And we will improve on it. And that irregular, again, it needs to be understood that it could have been an influenced irregularity. I've already spoken about Dr. Mkhwanazi. One thing I picked up when I was analyzing this, I couldn't understand that between the Chief of Police and Nhlanhla, what could have transpired. Because in Mr. Nhlanhla's statement, he says, on the day of upliftment of the suspension, he had a conversation with Mr. Julius Mkhwanazi downstairs my office. So all these things that happened, Chair, influenced from executive authority down to my division. It's things that we learn from. But it's difficult to say the serving of charge sheet, I would have dealt with it without changing the delegation, number one. But most importantly, if decisions are made by the accounting officer, especially on my contract, I don't know of Mr. Nhlanhla, but in my contract it's very clear on termination that you don't follow an instruction, there will be a misconduct. But I've never said the charge sheet must not be served. I'm really trying to be slow. I've never said let's not serve the charge sheet.
You've repeated quite a number of times that we don't understand the complexity of your position. You've repeated since yesterday that if you don't follow instructions, it has consequences from your superior. Were you instructed by Dr. Mkhwanazi not to institute or to proceed with disciplinary hearing, a disciplinary process against Commissioner Mkhwanazi?
Chair, I want you to understand this. The instruction, it did not happen with HR. It happened with Dr. Mkhwanazi, Advocate Kemi, and Chief Matlala.
No, Ms. Gxasheka, we don't have endless time. I'm asking you a straightforward question. Don't repeat what you've been telling us. You've been repeating since yesterday that Tamashazi, Chief Mapieye, and Mr. Behari, they met and they agreed that they're not going to proceed with the disciplinary. So please don't repeat that. I've asked you a direct question, and I started off by explaining the basis on which I'm asking my question. Since yesterday, including a few seconds ago, you keep saying, if you don't follow instructions of your superior, I think you said you can even be terminated. You said something like that. And all the time you're referring to instructions from your superior, Dr. Mashazi. Hence my question. And my question is simply this. Did you get an instruction, based on what you're saying, did you get an instruction from Dr. Mashazi not to institute or continue with disciplinary action against Commissioner Mkhwanazi? It's either a yes or no answer.
Chair, on the engagement of, I think, 22nd August, after the Bikla matter, because I think the question was different initially, that between the church and wherever, why I didn't do anything.
Now I'm asking you a different question, Ms. Gxasheka, please. Now I'm asking you a direct question. Did you or did you not get instructions from Dr. Mashazi not to discipline Commissioner Mkhwanazi?
On the 22nd, if I'm not mistaken, of August, when we were called into a meeting, Chair, in the discussions that were taking place, it became clear what was the appetite on this matter. Hence, when there was an instruction that let's change the disciplinary procedure. And I take full accountability, no more Xolani Ngceza taking accountability. I then took a forensic investigation process to find a way of protecting me without exposing myself.
Let me stop you there. You say in the meeting you've still not answered my question, but let me work with what you've said now. You say in that meeting it was clear what was the appetite. What was the appetite? According to you, as you saw it in this meeting, what did you see to be the appetite about this disciplinary process?
I would want to attest to what the Chief of Police has said, that it started to look that certain people are targeting Mr. Mkhwanazi.
What was the appetite, Mr. Gxasheka? You were in the meeting. You formed a view there's a particular appetite, whatever you mean by that, about this matter. What was the appetite?
The appetite is the same as the legal opinion.
No.
Can I finish, Commissioner?
No, Mr. Gxasheka. Don't do that. I'm asking you a question that is, it's a second question that I'm asking you that you're not answering. All to do with the instruction from Dr. Mashazi. That's what I'm asking you. You've now introduced the appetite. It became clear. That's your language, right? And you say that when you should have answered my question about whether or not you got an instruction, you choose to speak of an appetite. Now I'm asking you, what was the appetite that you descend out of that meeting to do with disciplining Commissioner Mkhwanazi?
Thank you, Commissioner. I am praying that Commissioner Balo, you're going to allow me to finish. One of the discussions or of the meetings, one of the key points in that meeting was there was a discussion that took place, and there was an agreement that this whole thing is going to be stopped. I won't have the exact words. This whole issue of Mr. Mkhwanazi, it's going to be stopped. Why is it still pursuing? And I got shocked because, as I say, majority of the times I'm not involved in these things. And I've been pressed, I've said that even on labor relations, cost management, it's been the issues I've been dealing with. You are not managing, I've said this yesterday, that Linda, you're not managing your department. Things are happening beyond you. Discussions have taken place. We're going to stop this matter. When I'm talking about the complexity, and I'm going to end here.
Just before you go to
Later,
that's
okay.
what the appetite was. And was this the appetite of Dr. Mkhwanazi?
That's what I'm saying. She was chairing the meeting.
It could have been the appetite of anybody who was in attendance. Was this the appetite of Dr. Mkhwanazi?
Yes.
Thank you.
Just to be clear, you never got an instruction. I think we all understand what you mean or it means when someone says, I got an instruction. Just like you got an instruction that you told us earlier yesterday, that you got an instruction about the suspension, for example. So should I take it from your answer, or should we take it from your response to my direct question? And you now speaking about an appetite in a meeting, that it means you never got an instruction from Dr. Mkhwanazi not to discipline Dr. Mkhwanazi, Commissioner Mkhwanazi. Whether in writing, whether in writing, whether in a meeting, Dr. Mkhwanazi never instructed you not to discipline Commissioner Mkhwanazi.
I'm going to respond to it, Chair, but can it just not end to a yes or a no? I need to give a context.
Yeah, I'm hoping that at the end of it you will have a yes or no, so you can give the context.
Thank you
it's
so
fine.
much. The discussion says, I had a discussion with the other colleagues. We agreed this matter must stop. Why is ER continuing? You are not taking ownership of your department, Linda. We have agreed we must stop this matter, and why is it still continuing? Why it hasn't stopped? You cannot control your people in your division. It might not have directly said you stop, but it's asking me why you haven't stopped. If it doesn't stop, you're going to account. So I don't know if that means an instruction, but it's a very clear tone that says if you don't stop, you're going to account. You are also not managing. The labor relation costs are increasing. The labor cases are increasing.
Yes.
You must stop.
You see, it would be bad if we were to say in our report, Dr. Mkhwanazi instructed Ms. Gxasheka not to discipline Commissioner Mkhwanazi, if in fact that's not what you say to us. That's why it's important to understand what are you saying. But I think you've answered as best as you can, or as best as you are prepared to answer, and I'm happy to leave it to that. Thank you, Mr. Chair.
Thank you, Chair. Chair, as I say, it was maybe it is an instruction. It was an instruction, let me not say that. But the way it was said, it wasn't just say, stop this disciplinary hearing. It says, why are you not controlling your department? Why is this matter still continuing? Whereas I've stopped it. You're not managing your department. Hence I'm saying it becomes complex. It wasn't just, it says stop this hearing, but also manage your department. So I wanted to give that context that there was clear that you must stop this hearing.
Mrs. Gxasheka, as observed by Commissioner Baloyi, from yesterday to today, you have repeatedly said that the instructions of Dr. Mkhwanazi or the accounting officer must be complied with. Can that be said appropriately by an HR practitioner, especially one at the highest level like you?
Chair, let me also remind you what I said yesterday. When discussions are taking place and instructions are made, we deliberate. And I've said yesterday, majority of the time, I find that she already has a legal position. I'm not sure where she gets to be capacitated. We debate on issues. Ultimately, once I could see that she has her point and it's taken, you can't move. I'm going to make a sensitive example just to give another context. When the matter of a chief came, for instance, saying let's settle it, I still went. And I said, from the humanitarian point of view, he's left with less than a year. I spoke to the lady who was involved in the matter, she agreed. I go to Dr. Mkhwanazi and I said, let's settle this matter. She agrees. 30 minutes, 40 minutes later, I'm called again. We are not settling because she now has a different view from the legal side of things. I think that's the complexity I'm trying to explain, that from HR side of things, we'll do things in a particular manner. I will advise in a particular manner. And I've said yesterday consistently that there's HR who will advise. After HR, there's legal. And ultimately, once legal has made a decision for that institution, it's binding and it's got its own risk, and one person can account its legal and the accounting officer. And I'm appealing to the Commission that you hear where I'm coming from. I do advise. I think if you haven't seen my character today, I don't know. I'm a person who will be persistent, who will be advising. But ultimately, when a person has made a decision and is your boss, there's legal you can do. An example that would have happened, maybe it would have been better than coming here. Let's say my report says, investigate why the DC of Mr. Mkhwanazi has not happened, but we had a meeting. I won't be here. Maybe it would have been a blessing. I can guarantee you, she would have instituted a DC on me. Maybe it would have been better than coming here.
I'm beyond the stage of you giving advice. I'm at the stage of an instruction. Let's assume that this is after the advice that you keep referring to. Then there is an instruction. What you say is, once an instruction, I will refer you in a different context, but it still makes the same point. Different in the sense that it's not in the context of what Commissioner Baloyi was engaging you on. I'll take you to page 22 of your latest statement, paragraph 65, fourth line. There you say, when instructions are given, I will say by, you say at, I'll say by, given by the accounting officer, one has to comply. So my question is a simple one, and I hope you will give a very brief answer. My question is, can something like this be appropriately said by an HR practitioner, especially one at the highest level like you? Can you say that? Once the accounting officer gives an instruction, I just must comply. Can you say that? As a senior HR practitioner?
Thank you, Chair. Chair, I've given a context. I think when you write the statement, you won't necessarily put everything with the hope that other things will come and talk to it. I will rephrase my statement, Chair. What I was trying to say is when a reasonable instruction is provided, you must comply. I would like to revise that. And number two, Chair, if we're to talk about the character of Dr. Mkhwanazi, I would like you to even, for instance, call the highest authority here. Call the executive.
I'm not sure that we want to go there. You've just said what you meant to say, and you are now seeking to revise, is that what must be complied with is a reasonable instruction. I think that's enough.
Yes, a reasonable instruction. But, Chair, I wanted to say where we didn't do right, the character as well, you might need to call one of the senior people who are beyond here to come and speak about the character itself and the complexity I was talking about. Thank you, Chair.
But I will not let you avoid this that easily. How you phrased it appears to have been quite conscious and deliberate. You see, it actually does make reference to reasonable. It's not as if you did not think about reasonable. Let me read the full thing. I stopped midway. You say, when instructions are given by the accounting officer, one has to comply, comma. That's a standalone clause in that entire statement, and it's full and complete in and of itself. And it suggests that you are saying, In fact, it's not even suggesting. It is actually saying that you just must comply under any circumstances, reasonable or unreasonable. Do you agree that that is what that means? Before this idea of you wanting to change this comes in, do you accept that that's the meaning of this up to the comma, comply, comma?
Chair, I've requested that my statement be amended, Chair, to talk to reasonable. As you say, HR person.
Yeah, I've said I'm going to take you up. In fact, I'm going to engage you quite seriously on that you cannot easily seek to change the statement in accordance with what you are saying now. And for now, I just want you to agree that that part up to comply, comma, means exactly what I've said to you. Do you agree, yes or no?
Chair, you said I've intentionally wrote that.
I'm coming to that.
Okay.
I'm coming to that.
Okay.
Do you agree with what I've just said now? Up to comply, comma. Do you agree
Yes.
that it means what I've said? You
It
agree?
means what, Chair?
What I have said to you, I have said, when you say, when instructions are given at the by the accounting officer, one has to comply. So I say to you, I read that to mean you just must comply whether the instruction is reasonable or not reasonable. At this stage, you are not where you want to change that to bring in the idea of reasonableness. But do you agree that as it stands, it means you just must comply whether reasonable or unreasonable? That's my question now.
Chair, I've requested that the
Yes, I
statement-
I get your request to change and bring in reasonable, but do you agree that
No,
it
I
means...
don't agree, Chair.
What does it mean?
Chair, I'm saying there's an error that happened, and I want to take full responsibility of the error.
Before the error and wanting to change, do you agree that it means what I've just put to you?
The way it's written
Yes,
currently.
the way it's written.
Yes, Chair.
Yes, thank you. Now, my point is, you said what you said here consciously and deliberately because it's not as if the idea of reasonableness was lost to you. You actually do refer to quote-unquote reasonable in this same sentence. You say after the comma, especially if they seem reasonable. So it's not as if you did not think of reasonableness. So first part, you say you must comply under whatever circumstances. But then you make the emphasis that, but you must especially do so if the instruction is reasonable. But you're basically saying otherwise, once an instruction comes from the accounting officer, you comply.
Chair, I don't agree with that, Chair. I think, hence I said earlier on, is the interpretation. And I don't like the statement that I'm going to use. I've seen people using it, and it's probably going to be the first time I use it.
Yes.
I think in the law space, you will probably have to do communications and English as part of your curriculum. In other areas, Chair, we really struggle with English. And what we're learning from this commission and other places, we learn every day, Chair, that we need to continuously improve on business English or language or legal language. And I'm glad, Chair, that you do mention it, that after the comma, you do talk about reasonable. And I've learned from that. I had an example where we had a legal opinion on the appointment of the CFO Ekurhuleni. When we met with the lawyers in a particular prescriptive clause that was written, they taught us that where a comma, just putting a comma, it means it changes the whole definition. Where there's a full stop and then there's a continuity, it changes the whole definition. Hence, I say, Chair, we learn every day. But I'm glad you raised it, that I did put reasonable. It could have been the way it was said. And as an HR practitioner, I can do better. I'm not undermining my English, but as I say, legally, in terms of how we write, we can learn from that. But I'm glad you mentioned it, Chair, that there is reasonable. And hence I said yesterday, I do debate with the accounting officer. but majority of the time, you realize that they tend to incline on the legal opinion than an HR opinion. In majority of issues, I would have advised, we agree, the following day you are told, no, because legal has spoken. Thank you, Chair.
Oh, I thought it was my English that you were suggesting is lacking. So towards the end, I see that you are saying it is yours. I wanted to also, when I said you deliberately and consciously said what you say in paragraph 65, you actually do say the same thing, exactly the same thing in paragraph 30. So there as well, you are basically saying, once an instruction comes from the accounting officer, you just must comply. Reasonable or not reasonable. Is it paragraph 30? I hope it is. Sorry. Yes.
Chair, paragraph 30 reads, based on the instruction of the accounting officer, my advice and guidance would have been based on that. If the charge sheet is ready to be served and the investigation concludes, there is no need to redeploy the employee to any other position. If you remember, I said yesterday, when we started with this conversation, she spoke about
Sorry,
the...
Ms. Gxasheka, you're reading 30 from your old statement.
Oh, sorry.
So maybe let's find it in there, because we've been working off the new statement. Let's find it there. Paragraph 65? 65.
Oh, 65.
Yeah.
Based on the instructions of the accounting officer, the letter sought to advise and guide where, based on that, if charge sheet is already served and the investigation is concluded, there is no reason to deploy to another position unless dealing with financial related issues. Again, when instructions are given, one has to comply, especially if they seem reasonable. And I think we're repeating ourselves, Chair. As I said that, I would like to rephrase that, to read that just a reasonable instruction. And again, my paragraph, it ends by saying once more, one has to emphasize that my guidance was never directed anyone to stop the proceedings. So even that sentence, Chair, it talks about the procedure, its fairness, and how HR operates. But I will rewrite the issue of the legal instructions or lawful instruction.
I will leave it at that.
Thank you, Chair.
I will just refer you to the paragraph I wanted to refer to in the old statement is paragraph 31. Yes, old statement or first statement. It says exactly the same thing about complying with an instruction from the accounting officer. And it's on that basis there that I say you are quite consistent on this, and that therefore you made a conscious and deliberate decision to say that you must comply with what the accounting officer says. I will leave it at that.
Can I just say something, just one? Having looked at the charge sheet, and based on what you say here, that if the accounting officer gives reasonable instructions, they must be complied with. Do you accept that it would have been an unreasonable instruction to say don't proceed with the charges, especially bearing in mind how serious the 5 charges are?
Thank you, Chair. I accept it will be unreasonable. Hence now, after there's a new accounting officer, the DC is commencing. It has commenced again.
But that creates the impression that you were not willing to act until there was a new accounting officer, that you were prepared to wait for 3 years. And if Dr. Mkhwanazi was still there, you would not have done anything because you were scared of her. That's the impression you are creating now. Because you are saying in November 2025, because there was a new accounting officer, we could proceed. But these things date back, the allegations against Mkhwanazi. They are February 2023 allegations. We are now in 2026. Just wanted to make that point. Thank you, Mr. Chaskalson.
Thank you. We've discussed the failure to proceed with the charges. I just want to clarify two earlier decisions that you were involved in, and I'm hoping to be brief. The first is the decision to uplift the suspension. That is a decision that is communicated in a letter that is sent by you. I understood your evidence to be that that was done on instruction of Dr. Mkhwanazi. Is that correct? Did I understand it correctly?
I didn't hear the part of the letter that was signed by
That
me.
the withdrawal of the upliftment of the suspension
Yes.
was done on the instruction of Dr. Mkhwanazi.
Yes, remember I spoke to that evidence leader.
No,
and he said-
I just wanted to clarify that I hadn't confused more than one, but I don't need you to
okay.
go further there. But what I do want to do, because there's a direct conflict between what your evidence is in that regard and Dr. Mkhwanazi's, and I need to put to you what Dr. Mkhwanazi says. So if one goes to page 31 of Supplementary Bundle 2, there is an exchange between Commissioner Baloyi and Dr. Mkhwanazi. Do you have page 31? Sorry, yes, it's Supplementary Bundle 1, not Supplementary Bundle 2. I apologize.
Okay.
Do you have it?
Yes.
So if you see roundabouts page line 11, the line numbers are on the left-hand side. Commissioner Baloyi says there is also testimony that you were involved in the discussion or in the decision ultimately of Ms. Gxasheka to uplift his suspension and have him return to work. That is why the interest in my questions, at least, that you're copied on an HR matter that involves a junior employee. And there are these allegations that we've had that you had a direct involvement in how the disciplinary process against him eventually was aborted and scuppered. Her response there is, I want to state categorically that I did not participate in the suspension nor the upliftment of the suspension. I deny all the facts that they indicated that I participated. So she is saying she had nothing to do with the decision to uplift the suspension. And that passage should also be read with a passage on paragraph on page 22 of the same file. There at the top of the page, Advocate Selo says, your response to that question is reflected in paragraphs 85 and 86. You may summarize for the record what your response is. Dr. Mkhwanazi says, my response is that I did not get involved in this because Julius at that point was a junior official. I have no knowledge of this and therefore I cannot make further comments because it was done at the departmental level, at the level of Julius being a director in the department and being a level like a lower level that reports to the accounting office. So the redeployment and the withdrawal and so forth, I was not part of the process. So she is washing her hands of the suspension, of the decision to uplift the suspension and of the decision to direct that his redeployment should be back to his initial position. What is your response to that? I mean, there is a direct conflict between your evidence and her evidence. Are you standing by your evidence? Are you saying that she has testified falsely to this commission?
Thank you, Chairperson. I think on the initial transcript, the first page you read, I can't
31.
get to it.
31.
Yeah, page 29. there's where she talks about they. What I would like to put to the commission, then I'm going to answer. If anybody has been following up all our statements here, one way or the other, Chief of Police, Nhlanhla and Advocate Kemi, if I'm not mistaken, there's some consistency of Dr. Mkhwanazi being involved. And I don't think all of us, we can just throw her name and say she was not involved. I also don't think all of us, we can just say we want to protect Julius Mkhwanazi. All of us, and put ourselves in this situation. And I've even said yesterday that we got involved when, in fact, Chief of Police Ekurhuleni started bringing this thing to Dr. Mkhwanazi, where they met in some place, I can't remember now. And then she said also involved HOD, or I was acting at the time. In our statements, we further say that at some point, she had a meeting. I even said yesterday, sometimes it was telephonically. I'm saying it was in person. This is our evidence, most of us. And up to the end, Chair, to the end of the DC, the last evidence in all of our files, people that are involved here, when it was decided to stop the process, whereby in one of the evidences said herself, Advocate Kemi, and Chief sat and have this discussion. It would be very strange that all of us were turning against Dr. Mkhwanazi. And I think on balance of probabilities...
Sorry, Mrs. Gxasheka, I don't need you to justify it. I just needed to put it to you. And I have seen all of the evidence, and you're right, it is consistent. But I just needed you to know clearly that she is saying something else, and I just needed you to confirm that notwithstanding what she says, you stand by what you say, and what is independently confirmed by several other people.
I stand by what I said. Instructions were given. Sorry, Chair. I think majority of the time were lawful, and we had to abide. Thank you.
Thank you.
The last one, Mr. Chaskalson, sorry, on the same transcript, the end of page 24, continuing up to 25, line 10, where Dr. Mkhwanazi is even more explicit because she says both the upliftment of the suspension and his redeployment were done on the advice of HOD Gxasheka. Do you see that, Mrs. Gxasheka? It starts from page 24, the very last line. She's being asked whether you were advising or you were instructing, and she says, as if she was instructing, because it was emails back and forth between the two HODs. If she was instructive in nature, I was actually going to intervene. But now it was between the two of them, and subsequent to the emails between the two of them, the chief himself uplifted the suspension and redeployed Mkhwanazi to how he was advised by the HOD. And then he says, that's you.
Chair, in my letter of suspension, I think the first paragraph, second sentence or the first sentence, it says, it came to my attention. And I said when I was referring to that yesterday that the attention I got to be told by the accounting officer. And another way of trying to support what I'm saying, I think majority of the time when I communicate, even with chief of police or anybody, I CC her. And the CCing, it shows that whatever we discussed and she said we must do, it's done. It's going to be difficult and it's a bit disappointing where we are in this situation because of the instructions of the accounting officer, and then she feels she must exonerate herself, and all of us must take the brunt. It's a very disappointing situation, Chair, but I'm sticking by what I said. The instructions were given by her, and all of us were confirmed. the people who brought statements here. Thank you so much, Chair.
Mr. Gxasheka, in your discussion with the chairperson, you were talking about complying with, and you comply if it's a reasonable instruction. If the city manager gave you, as you say, she gave you the instruction to uplift the suspension, why did you consider that to be a reasonable instruction to comply with?
Thank you, Chair. I read yesterday the DPCA 16.4, and I said it gives you either or. And because it at least allows, remember it does say 3 months, in exceptional cases you can extend. So she's covered in that 3 months. And in the debate you'll have with her, when I'm saying, but we can extend, she will say, no, it says 3 months and therefore it must happen. And as I say, the mere fact even Mr. Nhlanhla drafted the letter and I signed it. There was a leeway for her, for us to continue with that process.
You agreed to extend the suspension, so you obviously would have applied your mind to the request to extend the extension, and you considered it appropriate and within the prescripts. You now get a call from the city manager, who is not an HR person. She's not an HR. You are the HR boss in Ekurhuleni. She's not that. She's your client when it comes to matters of HR, right? You're nodding, yes. You've considered and you found there is merit to extend. That's what you agree with Mr. Nhlanhla. You were prepared to do it. The city manager who is a layperson on issues like this, gives you an instruction to not to extend, to actually uplift the extension. You do not even let it lapse. You write a letter, you say it's not being extended. You change your mind because you get an instruction. And my question is, and DPSA has nothing to do with it. She hasn't told us that she looked at the DPSA, as Mr. Chaskalson says. She says she relied on your advice. And I accept that you say that's not true. So we know from what she said in testimony that she didn't apply her mind to it at all. According to her, she depended on your advice. What did you consider to make her instruction to be reasonable, that you comply with it?
It was the first part of, as I say, our debate and discussion was on the first part of 16.4, that the disciplinary process must take place within 3 months. And at that time...
Did you, let me short circuit this. Did you advise the city manager not to extend? Because that's what she says.
No.
Right, so it can be both. You have to choose that, yes, I advise her that it's okay not to extend, or I was acting on instruction. She ordered me that we will not extend. It's one of the two.
Respectfully, Commissioner, I don't think there will be two possibilities in this situation. And I appeal for your indulgence to hear what I'm getting at. I'm saying let's extend and conclude so that EMPD can conclude the matter. She says, and I was consistent yesterday, she says, why did HR not complete this process? You've concluded the investigation. You are it is at an advanced stage. That's what my statement says. Therefore, there is no need for you, HR, to extend the suspension. Mr. Mkhwanazi must come back to work. This is where things went.
Which then makes me ask, and again, it's about, I'm going to use the word competence because I can't think of another word now. It then raises questions about your own competence then, that you initially agreed. So you would have considered those things that you now say came from the city manager. You would have considered them, otherwise you're incompetent, that you didn't think oh, they have conducted the investigation, they are close to finishing, it's actually not necessary to keep the extension, the suspension in place. If you did not consider those factors, then it says something about your competence. If you considered them, and then the city manager simply repeats them to you, you still have to say, why did you consider her to be superior to you in terms of reasoning or factors to be taken into account? And so, yeah, I'm back to, it's one or the other. You considered them and you satisfied yourself that this can be extended. That's why you agreed with Mr. Ngqiza. Something else happens and it cannot be the city manager repeated the same things to you. Something else happened that made you change your mind because you already had a view. She can't repeat the same thing and then you say, yeah, because it comes from the city manager, it's reasonable.
Chair, through you, I'm saying there are discussions that are taking place. Initially, I satisfied myself. We do it. We do extend, sometimes we don't extend. That's how it is, based on how far the investigation is.
So there was no instruction from the city manager. You had a debate and she persuaded you differently. There was no instruction from her.
I think you're battling to hear me. That's why I'm really trying to.
I'm not. No, I'm not. No, I'm not. I'm not battling to hear you. I understand you are here and I understand you perfectly. You either had an instruction from the city manager or you did not. You now speak about a debate and I say, well, you either acted because of an instruction, which you say I must comply with, or you debated. You had formed a view, you debated, and she persuaded you differently. In the latter case, it's not an instruction. If the latter happened, then there was no instruction from the city manager, then she's right when she says, I never gave an instruction. Or she did give you an instruction. And it takes us back to, well, why did you think this was a reasonable instruction? But forget that second part of why do you think it's a reasonable instruction is I'm saying to you, you either were persuaded different, and there's nothing wrong. If you had started with that, without saying she instructed me, if you had started with, yes, I formed a view, but when I had a conversation with the city manager, I actually saw things differently. I think that would have been the end of this debate with you. But that's not what you say. You say you got an instruction and she's not telling the truth when she said she never instructed you.
Thank you, Chair. I've said from yesterday, I'm really trying to be slow because I think maybe yesterday I was rushing and I was not heard properly. You will debate issues with her. She will give you any instruction. And if I was not competent, I'll just say, yes, boss, and then move with it. I will advise against the instruction where I'm uncomfortable. We'll engage, and I've said most of the time you find out that legally she's equipped. After the debate, she will still say, I am saying to you, do this and that. And I wanted to talk to the competence issue because now you've raised it. And hence yesterday I've said, before and after the instruction has been given, I engage on issues because you cannot be at my level where you are told, do this, you say yes, but I've been very consistent on that. Instructions are given, I debate, and I'm still told you're gonna go and do it this way. And I wasn't trying to be disrespectful when I was saying you can test her character to the highest level. She will allow you to debate, but after debate, what she has said must happen, must happen. I don't think, I'm finishing, between me, Chief of Police, Xolani, Advocate Kemi, we don't even know, I don't know Mkhwanazi. I started knowing Mkhwanazi during this case. I don't think all of us would want to shield Mkhwanazi, and I don't think we had any reason to shield Mkhwanazi.
The suggestion is you were shielding him to please the city manager. That's the evidence. That's a complaint against you. It is, you may not have known him. Maybe you met him for the first time at the city of Ekurhuleni. That's not even the conversation. The complaint against you is you did not, firstly, you uplifted his suspension because you were pleasing the city manager and you were rewarded for it financially. 2, you did not do anything. You frustrated or contributed to the frustration of the disciplinary process against him because you were doing the city manager's bidding and you were rewarded for it. That's the accusation against you. So it doesn't help for you to say, I didn't know him. We're looking at your conduct where there's a clear case of serious misconduct, serious, which in another forum should see Commissioner Mkhwanazi go to jail. You become aware of it. You see the charge sheet, it's serious matter. You say, well, they made an agreement, I wasn't involved with it. You say I was instructed. You say I did a forensic investigation, which has nothing to do with the charges. And the explanation from your colleagues who have testified is your role in all of this is explained by you were working with a city manager who was protecting, they say. She was protecting Mkhwanazi. You helped her and you got rewarded for it. Those are the allegations against you.
Let me give you an example that is sensitive. Beyond this, I won't say much. Today, in 2023, I think that was the first month we suspended Mkhwanazi. My mom passed on. The following weekend, she was buried. Sunday. Monday, I was called to come back to work. And I said, on Mondays, since Nhlanhla Beki, because we bury on Sunday, I was told if I'm not back at work the following day, I'll be dealt with. That was around 4 o'clock on Monday, that conversation. I had to drive from Queenstown to here, to Joburg. Didn't sleep, I'm a firstborn at home. Never slept. When we were driving, my husband had to stop me while he was sleeping at Bloemfontein. Because you are tired and the car keeps on getting out of the road. The following day, I was in the office doing interviews. I've never mourned my mom. On top of that, 5 days were deducted from my salary for burying my mother. So in that period, between February and up to the end of 2023, why would I be loyal to such a person? So I really want this misperception that says some of us were loyal to Dr. Mkhwanazi to be seen differently. It wasn't about loyalty. It was about how we advise and if our advice is taken or not taken. And I thought yesterday I was assisting myself and the commission when I said there's an executive authority, Ekurhuleni. And ultimately, she's fully accountable in everything that is done. And I'm refuting anything that says, in that year, I was loyal to Dr. Mkhwanazi, whereas I went through what I went through. What I'm saying to the commission, we debated on matters. We debated on instructions. Ultimately, she will hear you. Hence, I'm saying, get somebody who's not involved. Leave all of us. Bring another witness who's going to tell you that after debate, she will still have her word done. I really, hence I said yesterday, even on the issue of our increases, she came to me and said, why is Mayoral supporting you? You know, she pushed it because maybe she had no choice. We did a motivation. It went to the remuneration committee. It went to Mayoral. That is the loyalty issue. Maybe we're loyal to the authority, the position, not the individual. And lastly, Commissioner, I want to leave here with a clear tone. Instructions are given. I advise. After advising, if there's an ultimate instruction given, you have to comply. And it's 4 of us, against her or against Julius Mkhwanazi. You know, you have to understand the complexity, and the only way you're going to be assisted is to bring somebody else who is not involved in matter to deal with it.
I
Thank
think,
you, Chair.
I think the issue, the Chair earlier on raised it as someone at your level of seniority, that you're executing instructions like this. And hence my question earlier to you, what is reasonable about the instruction? Because you say, I comply with reasonable instructions. Now, if an instruction is unreasonable and you still comply with it, it makes us ask questions about you and why you would do that which you did. So that's the context or the prism within which you should look at this, that you are employed, you're a Section 56 employee, as I understand. The decision to employ you is not the city manager's decision, as I understand these things. You can correct me if I'm wrong. The decision to fire you is not the city manager's decision. Ultimately, she can lay a complaint against you and you get disciplined, but it's not her decision. And then you are making these decisions, you become party to decisions that do not make sense, because it does not make sense that you ordered the upliftment, and you ordered it because it's in your letter, it's in your handwriting, in the same way that you keep saying, well, Chief Mapia wrote the letter, and therefore it's him. It applies to you too. You wrote the letter uplifting the suspension. It's not good enough, is the point at least that I'm making. For someone of your seniority, it's not good enough to say, I acted on instruction. It's not. You're supposed to bring to bear your professional guidance on matters like this. Nowhere does it record you disagreed with the city manager. Nowhere. Nowhere does it say, you don't give us an email, you don't give us a memorandum, you don't give us a WhatsApp message that says, I disagreed and I told her that I disagree with this, but I implemented because she instructed me and said she'll deal with me if I don't. What we have is her saying she acted on your advice. That's what's on record. With you, we do have a footprint of your letter uplifting the suspension. So it's you who uplifted the suspension. And you must take accountability. And in the same way that you say Chief Mapia should take accountability for his letter, even if he says I was pressured, he must take accountability because he wrote that letter and signed it off, stopping the disciplinary process. Same applies to you. Take accountability for, yes, I uplifted the suspension. Yes, I was wrong to follow that instruction because it was an unreasonable instruction. Not trying to justify it as we beat it. And then she then at the end of it said, I'm instructing you. Say she instructed me and I should not have followed that instruction. That's all we are asking you to do, is accept it's a wrong instruction to uplift the suspension where the city manager overrides your position. It was a wrong instruction for her to give you. And you should not have followed it. You did follow it, but do at least own up to it and say, I should not have followed that instruction.
Chair, through you, I think it becomes very difficult when we have to concede on issues when you contemplate them differently. And while you put your statement here, I've been very consistent that instructions are given, I do advise, and I do debate on issues. Ultimately, if it's reasonable, and the reason I'm saying it's reasonable to me, extending for 6 months, it's the right thing to do. But where the problem is with that clause, it says 3 months, within 3 months, finish the disciplinary process. And if you don't finish it within 3 months, the employee must come back to work. In exceptional circumstances, you can extend it. When I signed the first one, I agreed to sign the extension. It was based that at least you can stay up to 6 months. And there are circumstances where we say employees come back because the process has advanced. And I've said yesterday, I want the context. I will accede where I have to accede, but I really want the context to be given. a chairperson, in the sense that 3 months was concluded. And HR did, in our space, have irregularities. Chair. I'm taking that Dr. Mkhwanazi is wrong. If you want me to say I could have done things better, I will do so. But we also played a critical role on that process not being concluded. And I'm not sure then when I was testifying here if all this will be integrated and before decisions are made. But I'm appealing to the Commission that when utterances are made, can we at least also talk to the context of how the matters have been discussed? You know, the process was frustrated, I get that. And I'm saying we could have done things better. And it's really a pity, I'm gonna repeat before I concede to this, that Dr. Mkhwanazi wouldn't know all these things. As we decide to wake up and protect Julius, what for? What for? And I wouldn't want to get to a situation where my competencies are being challenged without me trying to put a context on my side, Chairperson. I wouldn't want to. Hence, I keep on saying, whereas instructions are made, are discussed, a person is advised, but ultimately, if you are a decision maker, you can even override what I'm saying and write your own letter, or I assist and write the letter. Kolani drafted the upliftment, and I signed it, and 3 months have passed. Kolani decided when the 3 months have passed to still think, do I discipline or I don't discipline? Those things must be taken into context.
Thank you.
I'm appealing with you.
Thank you, Mr. Sheka.
Can I just ask one follow-up question? I mean, you know the prescripts that apply in the municipality. You've told us you spent many years in the city of Joburg. You are now in the city of Ekurhuleni. Is it lawful and appropriate for a city manager to involve herself in issues of suspension and discipline of an employee at a level where Julius Mkhwanazi was in May and June 2023? Is it appropriate and lawful for her to be involved?
Chair, according to the delegations, as much as, remember, ultimately delegations are hers, accountabilities, she's the ultimate authority here. There's sub-delegations into these matters. But it doesn't mean because there's sub-delegations, she cannot still assume her delegations. I've said earlier on in my statement, this matter is the Chief of Police and Nhlanhla who brought her into it. If in the beginning they wouldn't have said, okay, this one has got proximity to the accounting officer, let's go and consult her. That's where this whole thing started. And then she started following it up. Remember, if you read their statement between Heni and Kolani, while Kolani has not yet disciplined, is still contemplating, they might go to jail, they might not go to jail, let me not discipline. Heni sensitized them that the time is moving. And by the 23rd, when he sensitized them, the 24th is the last day of the 90 days. You know, what do they do there? If you read their statement, I want to finish, Chair. I really want to, Chair. I'm going to come to it.
Is it appropriate? Yes, it is appropriate. No, it's not appropriate. I don't want to hear about what Kemi did or what Nisa did. I just ask a simple question. Is it appropriate for a municipal manager to involve themselves at that level with the suspensions of employees at that level? If it is appropriate, you can say, yes, it is. If it's not appropriate, you can say, no, it's not. And that's what I'm asking you to do. Assume we've read these laws, assume we've read the records, assume we've heard your statement, assume we've heard what you said yesterday. All I want for now is it appropriate, yes, or it's not appropriate?
Ideally, Chair, a city manager should have said when they said, we want to discipline Mkhwanazi, and say, it's your role, deal with it, don't involve me. Therefore, it doesn't look good. It's not appropriate because those are lower level. And the contradiction, remember, when we're discussing recruitment, chief complaining, she says to Chief, below this level, don't be involved because you are dealing with a higher level. It's the same as her.
Exactly.
But all I'm saying, Chair, I know even my legal team, I'm sure they're going to reprimand me. I'm not trying to over-explain myself as if I'm hiding something, but I'm trying to refute the statements and the allegations Dr. Mashaz is doing against all of us, that she should not have involved herself from the beginning.
You see, now you've answered me. You didn't have to take that long route. Thank you.
Let's adjourn and come back at 22. May we see council outside, please? Yes, Mr. Chaskalson.
Chair, the next topic that I want to move to is the promotion of Brigadier Mkhwanazi. And it's an issue that we traversed briefly yesterday with Mrs. Gxasheka with reference to documents that are attached to the Mashiza bundle. And the promotion documents are, they start at page 59 of, well actually 58 of the annexure bundle, to Dr. Mkhwanazi. I had merged two witnesses. It's late in the day and in the week. I apologize. So it's page 58 of the Mkhwanazi bundle, and through to pages, and then the next document is 59 to 62. And 58 is the... Certainly, sorry.
May the attorneys please assist Mrs. Gxasheka. You, Mr. Chaskalson, you'll you'll please take us through what you want to. Oh yeah. Oh, yeah.
Thank you. It is a document dated 24 October 2023. I'll come back to the date a little later. It's an interview summary and recommendation for a panel for the appointment of Deputy Chief of Police Operations and Specialized Services. The date is 24 October 2023. So that is after the restructuring of disciplinary matters, and it's after the instruction in relation to the forensic report. And in that context, Brigadier Mkhwanazi applies for promotion. And can you take us through this document, because it's not clear to me. I see you were on the panel, I see Chief Mapie was on the panel. There's a Ms. Zanele Katembo, who also appears to have been on the panel. Who is she?
Your mic, please.
Zanele Katembo was an HOD for Shadrack, that it's sports, recreation, arts and culture. That was her role, I think, at that time. Thank you, Chair.
And Advocate Behari was also on the panel, although it seems that he wasn't present at the interview. Is that correct?
That's correct.
And there was someone from HR Secretariat, but she didn't play a role in the interviews. The upshot of the interview was that a recommendation was made that Brigadier Mkhwanazi should be promoted to the post of Deputy Chief of Police Specialized Services. Is that correct?
That's correct.
Now, I simply want to ask you, in a context where charges of the nature that had been laid against Brigadier Mkhwanazi were still out there, hadn't been resolved, why did you see fit to recommend him for promotion to a more senior position?
As I say, by that time, Chair, it was clear that the process of the DC is not going to continue. And obviously the employee has been exonerated, given a letter that the process is not continuing.
Sorry,
And
can I interrupt there? The employee was never exonerated. No one ever said you have been found not guilty of any of these charges. At best, what happened was that the process of proceeding with the charges was frustrated through a series of, well, at best, gross inefficiencies, at worst, deliberate sabotage. There was no exoneration.
I'll rephrase. Remember, this is an employee who's sitting with a letter that says we're no longer continuing with the investigation process and whatever and whatever.
But
And
sorry,
he
can
has
I
applied
take
for
you
the
up? Sorry, can I
position.
come in there as well? Because that letter says we're no longer continuing with the investigation process. But in fact, the investigation process had been finished by then. There was the investigation was over. What was now needing to happen was a disciplinary hearing. There's no need for further investigation, just for a hearing to take place.
Yes, he was also told, go back to your substantive post, continue with your work. So firstly, for the employee to apply the position, the understanding is that this DC is not continuing. And at that time, there was no disciplinary hearing that is continuing. As I say, based on my initial testimony, my earlier testimony, and the legal opinion, if it was then done by then, I can't recall. So we could not prejudice the employee in this particular time. Hence, he applied as well, like everybody else.
Sorry, which legal opinion said that you could not proceed in, I think it was October 2023?
As I say, if I recall events, there was a legal opinion, I think we discussed it, that said there are no fraud issues against him. Maybe it's the way I'm putting it. So at this point in time, the mere fact that we continue, there was no disciplinary process that is continuing. Check. Thank you.
You see, whether or not there was a disciplinary process pending is a separate question from whether this applicant is a fit and proper person for this promotion. And I struggle with the notion that someone against whom allegations of that nature have been leveled and have reached the point of proceeding to a hearing only for a charge sheet not to be served is fit and proper to be a deputy head of police. So what's your response to that?
I hear the inference on your side. On my side, in terms of the procedure, there was no DC that was happening, and therefore there will be no reason to say we are not shortlisting you because you are not meeting. I mean, there's a pending DC, because clearly there was no pending DC.
There was a directive by IPID that he should be charged. And that directive is binding on the city of Ekurhuleni.
I didn't see it that time.
But you say the opinion exonerated him. That opinion is the opinion that said IPID must be disregarded. Which other opinion are you referring to?
That's what I'm talking about.
Yes, so that's why I'm saying there was a directive by IPID. and that opinion was responding to the directive. So you cannot say there was nothing pending. There was a pending directive by IPID. The fact that Ekurhuleni did not comply with it does not mean there was no pending directive by IPID that Mkhwanazi should be disciplined.
I hear you, Chair. Thank you.
Yes, Mr. Gxasheka, the question still, Mr. Chaskalson's question still stands, that the disciplinary process is not complete, it's not shut down, not by the letter from Chief Mapia, because he as Mr. Chaskalson says, he speaks of an investigation. You then recommend the candidate, and the question is how in your judgment is it appropriate for you in particular to recommend such a candidate for a promotion to Deputy Chief of Police on such serious charges?
Chair, thank you. I'm still saying that at that point in time, halted or suspended the DC, it would have been a prejudice not to give him an opportunity to complete with other candidates.
The issue is not why did you interview him, because competing with other candidates is at interview stage. I mean, even the worst of, we've got a list, so I need to explain what I'm going to say next. We know from your vetting results, that some people were found to be rapists, but they're in the employ of the city. So even that person who is found to be a rapist, when they apply, you would have looked at, do they meet the requirements for shortlisting, right? And then you would shortlist them. And that's a fair for them to come and justify to the panel why they are suitable for appointment. So we are past that. You've shortlisted. You, head of HR, are aware that there are these unresolved charges, serious charges against this individual. How do you make the judgment that it's appropriate to recommend him for appointment?
My judgment, Chair, was based on procedurally. I thought it's fair to give, if there's a halt or stopped DC, you give a candidate an opportunity like everybody else. If indeed at some point you are found guilty, you will always be dismissed.
No, he was never going to be found guilty because the city manager has given you an instruction. Remember that earlier conversation? Yes. So you say the city manager gave an instruction, and that's why that explains your inactivity about further disciplinary steps. So that has ended, but he's never been exonerated of these serious charges. He's never been. Here's the HOD of Human Resources. Basically, what do you call it? The one who gives direction, supposedly, on matters of discipline and how people should behave and what is tolerable behavior. You recommend his promotion. That is a problem. Do you accept that?
I said, Chair, that it is an oversight. We could have done better. I advise on the other side that procedural. In fact, it's just that the reason I don't want even to talk to it because it was not recorded. I said after the shortlisting, because no employee at EMPD met the requirements, it was only these two. I then said, let's not proceed, let's re-advertise. And because we already didn't extend the contract of Mr. Mzolo, the chief pushed that we do interviews. And I think when you go for interviews, you might anticipate a particular outcome if you want to. But interviews will always surprise you. And then once it's recorded and we made this recommendation, it's difficult to go back. If we could have restarted the process, maybe we won't be here. But I'm taking full accountability that I should have stopped the process when I said, let's stop the process.
Yeah. Well, we're at a point where you did not stop the process.
Yes.
you interview, you know the problem about this candidate, you recommend, you do a positive act. You're saying he's suitable for the position. That's what this conversation is about. So
Yes.
it's not oversight at all. It doesn't fall in the category of oversight. It would be oversight if you didn't know that there were these accusations against him, or you were mistaken about something, right? Here, you know this is unresolved. There's serious allegations against him. And we do have evidence here where EMPD conducted an investigation, and you would have seen that. You know that, as Commissioner Khumalo says, you know that IPID has directed that he should be disciplined. You have testified that, well, it was frustrated / there were instructions. Now we come to you personally. Why do you recommend such a defective candidate whose defects are known to you, are recorded in a charge sheet? How do you, head of HR,
The process
say, oh, he can be promoted, he's suitable for the position?
The process was halt, and the employee competed with other candidates. And we shortlisted, we interviewed, and he did well on that interview. I agree that in terms of the character, we could have done better. And I'm taking full accountability that we could have done better. But the process is on its own. It's not even a process that is made only by myself. It's a process that is made by the panel. As much as I've advised, and I'm taking full responsibility, I'm not going to say I'm instructed in this one. If there were instructions, they were not given to me. The only thing that we did was to score, and the person who scored him higher, and therefore was recommended.
So is it fair to say that you saw nothing wrong? The short answer, at that time, now with hindsight, maybe you say, well, yeah, I shouldn't have done that. Maybe that's what you're saying. I don't know if that's what you're saying, but I'm asking, in the moment when you recommend that he's suitable for promotion, you did not see any problem with that? You considered him...
It was a red flag. It was a red flag. And as I say, I think what was left is how you debate it. Remember, at the time, as much as I can recall, there was not even a criminal record against him, but there were pending allegations against him. And unfortunately, we didn't get to test them to the end.
No, you may not have tested them as a panel. And the conversation really... We've had the same conversation with Chief Mapie and raised our concerns about his own conduct with this interview, rather with recommending Commissioner Mkhwanazi. It's exactly the same concern with you. And this is not a panel concern, it's a concern about you individually, you as a person who knows the problems that have been raised about this candidate, who knows that there's either an aborted disciplinary process or suspended disciplinary process, whatever language you choose for it. He's never been exonerated, and you have to accept that. I think you've accepted that yes. He was never exonerated of these serious charges. You sit there and you determine he's fit and proper, notwithstanding he's fit and proper to be promoted to the position. That's a difficulty I have with you about either it's a sign of poor judgment on your part, at least from where I'm sitting, or it's something more serious, that you were prepared, because it's Mkhwanazi, you were prepared to overlook the problems, the red flags, to use your language, about him. You overlooked them because it is Mkhwanazi, or you simply failed in your job to properly assess a candidate.
Chair, I think the inferences sometimes are biased, and because it's based on a particular situation at a given point. My judgment would have been based on that the allegations have not been fully tested. and until found guilty, you are innocent. I think where Ekurhuleni we failed, I'm still going to agree, is how poorly we managed the matter of Mr. Mkhwanazi. If it was well managed, again, won't be here. If the DC continued timelessly and charges were served, maybe even he could have been exonerated and won't be here still, or will be here for a different narrative.
Aren't you being unfair to the other people, considering that you explain your inaction to pursue this disciplinary process on the basis that you were given an instruction? And when it suits you, you say it's the fault of the other people. It can't be both. It's you were given an instruction, you have told us, and you've tried to explain it by saying the atmosphere in the room was clear that the city manager doesn't want this disciplinary hearing to proceed, and your position was informed by that. So you acted, you explain your inaction in this aborted disciplinary process by saying there was an instruction from the city manager, and then when it comes to the others, you say, had they done things on time, it would have happened. But if we go with your version, this DC was never going to happen because there was an instruction.
Thank you, Chair. Chair, if you follow events, if we acted within the 3 months, we might have a different narrative. Chief of Police submit a tribunal, request for a tribunal to take place in March already, I think around the 23rd of March. HRER division says, I'm applying my mind. IPD says, we can get these people arrested, so I don't want to spend money on attorneys. Come now while we're waiting. 24th of May is there. This matter is taken again by HR and EMPD, HRER division, to the accounting officer, and the accounting officer says, all of you put this thing to rest. Now, what I'm saying, Chair, is the charges remained not fully tested. It remained allegations because they were not fully tested in the sense that go to the DC and have the outcome. And I thought the principle of law, but if I'm wrong, I'm learning today. You are innocent until you are found guilty. I think I was fearful of the fact that now that we continued, if we don't appoint him, he might take us on. Ekurhuleni, Chair, you hide documents, they find them. I'm telling you, if Mr. Mkhwanazi found this document, let's say we withdraw that, we didn't see he's going to perform in this interview, we say let's withhold and not fill the position, and he get hold of this document. I don't know if we went to courts how it was going to be. I might have not understand the principles of law, but I've learned a lot from this commission. And I think the person will continuously improve themselves and improve myself wherever I'm going. I've learned a lot. That my judgment, Chair, I'm saying the red flag is there. But when I'm thinking of the rule that says you are innocent until you are proven guilty, I could have done and consolidated those two statements or notions and come with a better judgment.
I want to suggest to you that it's not available to you or open to you to rely on that principle of innocent until proven guilty if you contributed to the disciplinary hearing not happening. It's not open to you. You can't have it both ways. You can't agree with the frustration of a disciplinary process and then later on rely on that it didn't happen and say, well, I couldn't hold it against him. It's a correct principle of law that you are quoting, but it's not available to you.
Chair, if you can clarify when you say I contributed to the disciplinary hearing not taking place, so that I can able to answer in terms of my role.
On your version, you followed Dr. Mkhwanazi's unreasonable instruction not to discipline Commissioner Mkhwanazi. You followed that instruction, and it's unreasonable because the charges are serious. A charge sheet has been prepared. Things are at a point there may have been delays, but you are aware there's a charge sheet. It was at a point of being issued. It didn't get issued. You've seen the content of it. You know that IPID has directed that there should be a disciplinary, and you know that if you've seen the opinion that you're seeking to rely on, which we say doesn't say what you wanted it to say. If you've seen that opinion, because it does say what IPID has said. So if you read that opinion, you know that IPID has directed disciplinary proceedings, right? So you know all of that. You follow, and notwithstanding, you follow an instruction from the city manager that says, don't discipline. You follow an unreasonable instruction. So when I say you contributed, I'm saying your inaction or your readiness to follow an unreasonable, maybe even unlawful instruction from the city manager, you contributed to the DC not running. And so you can't say, well, now when it's time for interviews, I thought the DC, there was no DC against him when you had a hand in it not happening.
Chair, I get your context, Commissioner, that when I got to find out about this matter in August 2023, the way I think the report is being written, read, the one of the forensic report, and I don't want, I'm not sure if we must go there. I'll still stand by my conviction that in my report, if it's read in its entirety, I will never agree that I fully complied with the instruction. If the instruction says you stop this DC, you don't continue on anything. And I get the notion and the premise that says, no, you guys were looking at labor cost. But I'm still appealing to the Commission that maybe the report is read once more. And as I say, my intention in the reports and some of the allegations in that report should be read the way I intended to have this matter dealt with. I get the situation where we speak about the comma and the full stop. But I'm still saying when you read allegation 4, where it says disciplinary matter relating to Julius Mkhwanazi was not properly managed by the city, it has a comma. After that comma, it goes and says, then it also resulted to unnecessary legal cost. I'm taking that. While I'm taking the brunt that we shouldn't have been here, but I still appeal to the Commission that the notion, you will make your determination, but the notion that says we're trying to protect Mkhwanazi, I don't think it was necessarily the case. We could have done things better. And you are right when you say the instruction could have been done, not observed, and done differently. And I thought my approach to perpetually seek information about this matter and my intuition that says you cannot let this matter rest. And the latest where I've never, well, everybody stopped. My last acting on this matter, it was in October 2025. Nonetheless, decisions are made, Chair, by those who are listening and how they hear matters. I hear you, Commissioner, that I contributed for not having the matter to sit. It only said when Dr. Mkhwanazi is gone. I take that. Nonetheless, again, I'm going to say during the time I was dealing with the matter, my notion on the events is Ekurhuleni have not tested the allegations. Therefore, it's difficult to say the employee is not going to compete, and we could have still done better. I'm taking that, but I'm still appealing that hopefully when you look at this matter in its entirety, we will see how the outcomes come out. And also, one can say that this is a process where continuous improvement are going to be taken seriously, and we can do better next time. It's just difficult to agree that you just fully contributed, you had an intention not to discipline. It might look that way, but I want to say it was never my intention. Thank you.
And it's not a case of just Julius Mkhwanazi being protected. It's a case of him also being advanced because he was promoted. And with that promotion, there was you motivating that his salary be increased by 200,000 rands. So it wasn't just being protected at the position where he was. It was a case of you knowing that there were serious allegations because the forensic people who conducted the forensic investigation, they say one of the documents given to them is the charge sheet, which means by August you knew what the charges were against Julius Mkhwanazi. In October, when you support his promotion, you are aware that IPID independently has found that he's guilty of fraud and corruption and must be charged internally. And knowing those things, you still say this person is suitable for promotion to Deputy Chief of Police and an even better salary, some 200 plus over and above what he earned before. Now that is serious.
Let me make a correction. I'm not sure when I got to know about the IPID reports and the legal opinion. I said earlier on I didn't have the dates. But one thing that came to my attention in August, it was obviously the charges and the stopping of the DC. And I said already, I'm taking brunt of that. We could have made better judgment. Despite that there were instructions that were made, we could still have made better judgment. On the promotion, I'm still going to say that when the charges are not proven, it becomes difficult if you already shortlisted and recommended the person for promotion. On the issue of the salary, on the issue of the salary review, when an employee is a permanent employee, has got certain benefits, employer contribution. So when you count the breakdown, it becomes different. And when you now put them on a total cost, when you FTC, you are putting a total cost. And number two, what we normally consider is the issue of the risk embedded, that now you are on a 5-year contract. Deputy Chief of Police Mkhwanazi was not the only person who has requested his salary to be looked at when he becomes a divisional head, convert from permanent to be divisional head. Majority of divisional heads, if I'm not mistaken, they do make that submission. And it does get considered, I'm sure 99% of them. And one thing we've picked up as an anomaly in the city is that the gap between the senior executive manager and the divisional head, the salary, in fact, in other instances, the senior executive manager will earn more than a divisional head. It's an anomaly that we're dealing with right now. So his salary review, it goes with a promotion that we could have done better. But again, you could not prejudice him in terms of the salary review. As I say that, even Rivers Peace got a salary review. Xolani Ngceza got a salary review. I got a salary review, and so many people. And I say main issue, it must be noted, is because of the overlap in the salaries between that lower level and the divisional head. What I remain with, allegations, I got to know about them in August. October, we did interview, but they were not concluded. And we're learning from that we shouldn't have even shortlisted, we should not even interviewed I did say let's re-advertise. But because Chief didn't want to extend Mzolo, if you check the events, the way I was trying to assist, I'm saying in November, I think we shortlisted in September, we interviewed in October, I can't remember now the dates. In November, I'm saying, Chief, let's extend. Because there's so many processes to be followed. Even the forensic process, Chair, I wouldn't have known it will take that long. So I have this thing that if maybe we did extend the contract of Mr. Mzolo, maybe again we won't be here, Chair.
Can I stop you there, because I think the question was limited. Now you are dealing with issues you've already dealt with. My last point on this issue is that you will recall that there was that meeting of 18 August 2023, and arising from that meeting was that document that you prepared, which now conferred upon you the power to institute disciplinary proceedings, because it was no longer Nisa. The city manager had said, you're not managing your department properly, these cases are not managed correctly. The power was now yours to say, I've looked at this charge sheet, these charges are serious. I know they were withdrawn before, but I think these charges should be pursued. It was within your powers to start that process, and you did not do so. Am I correct?
Chair, I'm going to repeat what I said. Despite that, instructions were made, and it's a pity that we're not understanding each other, and I'm taking that. I've never not continue pursuing this matter, despite how it sounds like I pursued it. And I'm not going to go again and read that allegation that I read with a comma, that surely I was talking to Mkhwanazi. While talking to Mkhwanazi, I also talked to the legal costs. Chair, I still want to convince the Commission that I've never stopped. Until 2015.
Let me ask you a simple question. What stopped you in September 2023? You were looking at the charge sheet, you had it. What stopped you from serving it on Julius Mkhwanazi and saying, Julius, these charges are serious, you must answer them? What stopped you?
I've answered that, Chair, where I've said that based on the instruction that was given, it stopped.
You followed the instruction.
And when after that, I've said, Chair, when we changed the delegations, I knew that this cannot end here. Now I'm fully responsible for it. Hence, I instituted a investigation, a forensic investigation. I'm really trying to be as slow as possible. They said yesterday I was on 220 kilometers.
Mrs.
I think I'm at 10 now.
Can I stop you there? There's no need to be slow. You have now actually, in giving the answer, accepted that in terms of the delegation, after August, you could charge Julius Mkhwanazi. You didn't need a forensic investigation for that. You had the charge sheet in front of you. There was an investigation report. You did not need a forensic investigation that takes a year to conclude. You could say, these charges are serious, Julius Mkhwanazi. They were withdrawn because Mapiea said he was pressured. I now have the power in terms of this delegation. I'm serving you this charge sheet. I want you to answer to these charges, because this is an HR matter that falls within my jurisdiction.
The engagement of August, Chair, I've said that instructions were given, the appetite was very clear. Despite that, there was an instruction and the appetite that we will stop this process. I still went and said, let's look at what actually happened on this matter. And while that was happening, recommendations were made, and the recommendations that were made are putting us to be here now. Saying I didn't act, I might not have expected the way Commission expected the standard of an HOD, HR would have happened. But on my competency and how I know myself, I did the best of my ability. And it could still be done better. I don't think anybody is perfect in any world. And hence I've said, we all taking blame that we could have done better here. All I'm saying, Chair, while everybody else stopped, that must be noted, I never stopped. How the report is read, I'm still appealing, let's read it in its entirety before you make a final discussion on this matter. Thank you so much.
Thank you. Thank you, Mr.
Mrs. Gxasheka, I want to raise a slightly different take on this issue. When I look at that promotion panel and their recommendations, and particularly the fact that both you and Chief Mapiyeri recommended the promotion, it seems to me that part of what was tainting that process was fear. And it seems to me that there were two possible fears that members of that panel confronted. The one was the fear of Brigadier Mkhwanazi, and you've spoken about that in your statement. You mentioned that when the issue was first raised with you in February, the chief said to you very quickly, you were wanting to discuss the evidence, and all he could talk about was how dangerous Brigadier Mkhwanazi is, and you got scared, and you wanted a threat and risk assessment, and he didn't give you the threat and risk assessment. So it seems to me that if you were scared in February, you would have been scared in in October. Is that a fair proposition to put to you?
I'm not sure if I hear you properly, Evidence Leader. You're saying if I wasn't scared in February, I wouldn't be scared in August?
No. If you were scared in February when you were first told about Brigadier Mkhwanazi, there's no reason to believe that you would have stopped being scared by the time you were on the panel, not in August, in October. Were you still afraid of this man in October?
Not really, Chair. If you remember how the process ran, in the shortlisting, the candidate doesn't even know that he's going to be shortlisted. And he never contacted me and say, shortlist me, if you don't, I'm going to have issues. I really, on this one, I'm not even going to blame certain circumstances beyond that. My judgment would have been poor. I've never had a discussion with Mkhwanazi on this particular process. The only person I had a discussion with...
Gxasheka, can you please try to be brief, at least with some of your answers? As I understand the question, as at October, were you still afraid of Brigadier Mkhwanazi?
Okay. Chair, the risk assessment was never done. So I didn't know if I'm safe or I'm not safe. As much as I don't recall when we're shortlisting there, I thought of that. Maybe let me put it that. But the most important thing to be known, to date, there's never been a risk assessment done to my life. I'm still waiting for that. Maybe one day I will find it, and we're hoping that will live longer. But I don't remember considering that part. Probably subconsciously, I could have thought of if we don't shortlist him, what is going to happen. But at the shortlisting level, one thing I remember was to say, let's re-advertise. And in November, again, I said, why don't we extend Mr. Mzolo's contract? Subconsciously, it can happen, Chair, and you make decisions because subconsciously your mind is thinking of something else. Thank you.
I won't push that further, but the last issue that I have to put to you is that this afternoon, this morning, Makosi Makamba saw your testimony, and she's given us an affidavit this afternoon that I have to put to you. So can I get you copies, and can I get copies for the Commission.
Sorry, Mr.
Has it been?
Chairperson. No, it hasn't, and I was about to raise an objection to the document that the evidence leader is about to show it to the witness.
You've not had sight of it?
I've never had sight of it. It's for the first time that I hear about this document as he is busy leading now.
How many pages is it, Mr. Shadrack?
It's 4 pages.
4 pages. And you say it's the last issue you're going to raise?
It is the last issue I'm going to raise. It's a very simple proposition. It relates to the tender, and Ms. Makamba, whose name is on the whose name was on the bid document as the contact point, said that the witness removed her from any role in the tender and took charge of the tender herself, essentially. I mean, it's that proposition.
Thank you, Mr. If it's only 4 pages, what, 10 minutes would be enough, Ms. Mabula?
Yes, 10 minutes will be fine, Mr. Chair.
Yes. Let's adjourn for 10 minutes.
Honestly, to be used. As for now, I would like to highlight some few aspects. Why do I have an objection in using this document? This document that was just given to us now, and we're told that it's in a form of an affidavit. It's not a proper affidavit. The reason why I say so, Your Worship, Mr. Chairperson, it's fine. The reason why I say so, it is because we don't know the author of this document.
What do you mean by that?
The reason what I mean by that is that, Mr. Chairperson, it doesn't, at page 5, at the end of this document, it's the page 5 is the last document, is the last page. There is nowhere where the deponent of this statement has taken an oath or an affirmation to prove that these contents, or he is the author of the document. That is point number 1.
Would you have any problem if it was a statement that's not necessarily an affidavit?
Even if
We have used such statements in this commission, especially right at the beginning. We used to have statements that were not affidavits. So what difficulty would you have?
my difficulty is also that
Before the also, would you have any difficulty with a statement that is not an affidavit?
it is a typed document. It's not handwritten, and
I honestly don't understand your point. What's the point about the difference between a typed and a handwritten document?
if it was a proper affidavit or statement, it was supposed, whether it was typed or written, it wouldn't make any difference, but at least it should have
Let me ask my question again. If it was a statement that is not an affidavit and that does not purport to be an affidavit, would you have any difficulty with it being used in this commission? If you would, what would the basis of the problem be?
Yes, I would, because it was supposed to have long form part of evidence, or as
That's a different point altogether. That's a different point altogether. You know, the issue of how much time have you had to peruse the document and possibly even consult with your client on it. That's a different point altogether. The point now, as I understand you, is that there is an issue or problem with this document because of its nature. Do I understand you correctly?
yes.
Yes. Now, the issue that you raised in support of your point is that there's something, if I understand you correctly, with the attestation. And then to try to cut across that, I'm saying to you, in this commission, we have used statements that are not affidavits. And that was especially so at the beginning. We never had any problems with that. So I want to understand you, and I asked you the direct question. What problem do you have with a statement that is not an affidavit? What's your problem with that? Especially in the context of what I'm telling you, which is that we have used statements in this commission that are not affidavits. So what would your problem be with a statement that is not an affidavit?
when I read through this document, I realized that there are annexures that are being spoken to in this and they are not attached. That is also my problem.
Please take me to the relevant paragraphs. I read the document very quickly outside just now, but I don't remember any reference to annexures in it. But even if you are correct, what always happens between legal practitioners is for legal practitioners to say that you refer to such and such an annexure. Can you please share that? And then you decide whether you are able to proceed or not after you've been finished with the annexure. But it cannot be, or at least I do not think so, it cannot be a basis for saying, I object to this affidavit because I've not been finished with the annexure referred to. Of course, it's something that I say all the time, and people who watch proceedings before this commission, I have repeatedly said that is the last thing that I would want to see, that is to prejudice any one of the participants before this commission. So if an issue is with annexures, the annexure must be shared with you. You must get sufficient opportunity to peruse the annexure and also to consult with your client on it. That I will definitely give you time for. So, but now, please take me to the paragraph that refers to annexures.
Just a minute, Mr. Jackson. Oh, okay. Okay. If I may,
Yes,
Mr.
Ms. Magula.
If I read through paragraph 9.5 and it's 9.5 and 9.6, the deponent of this document is talking about a letter, and the contents of that letter are not attached to this document. Then if I speak of an annexure, I was speaking about the said letter that maybe it was supposed to be attached to this document.
No, not that it's an annexure. It's a document that you feel should have been shared with you.
Yes,
So you misspoke when you said it refers to an annexure.
I concede.
Yes. Mr. Shadrack?
Chair, I haven't consulted with Mkhwanazi Makamba. I got
Yes.
this arrived unsolicited this afternoon.
Yes.
But if one looks at paragraph 10, she says, I left the services of the municipality in November 2023 due to irreconcilable differences with Mrs. Gxasheka's management style and interests. So she has not, she's no longer, he hasn't been employed at the council for over 2 years. An instruction issued from her superior to her would be, if it still exists, it will be in the email archives of the council. If Mrs. Gxasheka can still access her email, I don't know if she can, it will be there. We will try and obtain it from the council, but we have no way of obtaining it through any other means. All I propose to do is to ask Mrs. Gxasheka to respond to what the witness to this statement says in paragraphs 9.1 to 9.9, just to understand whether there's a dispute or not.
Thank you, Mr. Jackson. Ms. Magula, I direct that Mr. Shaskalson should put the questions that he's minded to put to Mrs. Gxasheka. All endeavors must please be made to source the letter, is it one letter or letters referred to, and to furnish.
We will.
Yes. Thank you. Thank you.
Mrs. Gxasheka, if you go to paragraph 9 on page 3 of this document, there Ms. Makamba makes a number of specific allegations. The first one is that she raised the challenges that existed with regard to the training tender coming to an end during the departmental senior management team meetings. And then she says, I had several engagements with Ms. Gxasheka during the period leading up to December 2022 for her to approve the bid specifications in order for the HR department to commence the process of issuing the tender. Is there anything there that you would dispute?
Apologies, Chair. I can't recall these events. It could have happened, it could not have happened in terms of the time frames. But where I might want to agree is where I said, look beyond the unit standards, add degree, honors degree, and so forth. That I think from what she's saying, we could be also talking about the same thing where I said there must be additions to the tender document. Thank you, Chair.
Then in paragraph 9.3, she says, my unit submitted the bid specifications to Ms. Gxasheka already in 2022. She took more than 3 months to approve the process. Do you have a response to that?
I think it's similar to 9.2, where I'm saying, if possible, if we're discussing the issue that they must add additional formal qualifications, she might be talking about that. One thing I wouldn't understand, why must that take 3 months or take 6 months? But I did engage, and I've said it earlier, that they must increase the bid specification. Thank you, Chair.
Then she says, the item was eventually submitted to the bid specification committee on or about 26 May 2023. I represented the department at the BSC as the project manager and responsible for the training function of the municipality. Is that correct?
Chair, I think it's similar to what I said earlier on, that I was not involved in the BSC, the bid specification committee, same as the bid evaluation committee and the bid education committee. Thank you, Chair.
And then she says, soon thereafter, Mrs. Gxasheka wrote me an instruction appointing Mr. Joseph Moropa and Ms. Lebogang Motai, who were not in my unit. She also appointed Ms. Zamamia Dibuo Nwendamunsu and Ms. Ntabiseng Kunyamani to run with the tender. Is that correct?
I'm not 100% sure, Chair, what does she mean to run with the tender? Because if it means after it was awarded, maybe she should be saying something else. I can't recall there what would have happened. But my testimony earlier on, I did say that I got people involved in the allocation of the scope and to ensure equitable share. So I'm not 100% sure she's talking about that or what exactly she's talking about. I'm not 100% sure. It's difficult to answer on that one, Chair.
In 9.6, she says in the same letter of instruction,
just before that, but what role would she have played had you not introduced, if she's correct, had you not introduced the people that she mentions here? What role would she have continued to play in the process?
It will be more to ensure that the allocation is done fairly, more than anything. And as I said, I was not happy with how the the allocation was done, and I left it to the commission that I think City of Ekurhuleni will assist better to provide how all these service providers were paid.
Did you remove her from that process
I can't recall.
and replace her with other people?
I can't recall, Chair, if when she left the city, because all I know at some point she left the city. What I said, the support department must do, they must manage all the tenders for the city, for the for
She
HR.
she can't be referring to a period when she had left the city. When she says she was no longer to be involved, she must be referring to a period when she was with the municipality. So did you cause her no longer to participate in the process and replace her with other people? So please do not make reference to her possibly having left the municipality.
Chair, what I know, I've said the management of tenders must be done by the division and support. And the reason I made that decision, support remains independent because they are not the ones that will do the tender, and they are also not the ones that are going to instruct the service providers. So I did say earlier on that I made different improvement in the system, and highly possible she's correct when I say I included support services. But my understanding, Zama and Tabi saying they are also in that division of Makosi. So on adding Lebu and Joseph, I think she will be correct. I said we need an independent person because of a lot of things that were happening at the divisional head level, where you will run with a tender, you are a referee and a player, you run with a tender, you adjudicate, after adjudicating with the BAC, you still go and appoint who should do what when. So the responsibility of support services was to guide against that, also ensure that equitable share is happening and the quarterly reports are submitted to finance. Thank you, Chair.
You see, I don't think she can be referring to a process after award of the tender, because she says she left the services of the municipality in November 2023. And we know that the tender was only awarded in November 2023. So these processes that she's describing must relate to a period sometime between May 2023, when the bid specification committee got the specifications, and when she thereafter represented the department at the BSC, and November 2023, when two things happened: she left and the tender was awarded. So I think that what she is talking to in 9.5 would appear to be matters relating to the processing of the tender after it left the bid specification committee.
Look at 9.4 and 9.5. There's the submission to the bid specification committee, and then she says, soon thereafter, you effectively replace her with the people that she mentions. So this is at a stage, as Mr. Shaskalson says, leading up to the award.
Thank you, Chair. Chair, it's difficult to really speak to all these issues, especially without proper evidence, firstly. I mean, I didn't know that the tender was awarded in November 2023. I could have missed that. And now it's being raised. It's really become difficult. I think if there were documents in front of me, I would respond better on this matter. I'm really grappling with this one.
Can I, in relation to November, can I refer you again to the document that we touched on earlier, which is at pages 128 and 129 of Supplementary Bundle 2, where it's a list of bids that were awarded in November 2023, and this bid and the award to Buena Vista. is noted at at page 130, second last item. Appointment of a panel of accredited skills development providers to implement various qualifications and skills programs, November 2023, Buena Vista Learning Academy. What she does say in 9.6 and 9.7 is in this letter to which she refers, she says that you categorically removed her involvement in the training tender, albeit same being in her unit, and the handling of the training tender was thus moved, she says, from my functional ambit and located in the office of the head of department, Ms. Gxasheka. She had absolute control over all HR processes that ensued. Would that be correct?
It's not correct, Chair. I'm going to reiterate. I was not involved in the BAC, in the BSc, and the BEC. That cannot be. In fact, she's bluntly lying here. I've said earlier on, I haven't seen an HOD who go and present his or her tender at BSc, at BEC, and BAC. I'm refusing this. I'm refusing this. I think we are just being implicated here unnecessarily. It doesn't make sense what she's saying to me. And if the tender was only awarded in November and she left, how would then been taken away from her? Because between, until November, it would have gone to BSc, it then go to BEC, after BEC go to BAC. It only comes back now to me to start having a control in terms of the shared, equitable share after November. So I'm refusing, Chair, what she's saying here. I think we are just being played with here. Thank you, Chair.
Well, can I ask you this question? In paragraph 9.5, there are 4 people who she says you designated to run with the tender. Do you recognize those 4 people?
I do.
And are they in the office of the head of department or in the training department, in the office that was run by Ms. Makamba?
They are under, 2 of them are under training department, and then 2 of them are in the service department. Service division. So they are also in another division. That's the division that deals with budget, finance, contract management, and even when you are tendering, they will vet the document. They support you from you starting the tender to its completion. Hence it's called support services. So they will always be involved, not specifically for the tender for training, that is the wife of Matlala, but they will be involved in all these other tenders.
And would the department not have some representation in the BEC and the BAC, even if it's not you?
They would.
So when she says that the training tender was moved from her functional ambit and located in the office of the head of department, it's quite possible that that would be the case if the people from the department who were designated to the BEC and the BAC were people who reported to you and not to her.
Chair, in other processes that, other tender processes in HR, those 2 people he has mentioned from support are always there. One thing she has said that is correct, she is a project manager. But on top of that, there's other people that you work with to assist you to conclude this process. And they've always been in any tender process, you will find the support people in that space. Those 2 people she mentioned, they were very good in handling of how the tenders are done. When I arrived at Ekurhuleni, in any tender process that I was involved on before I became an HOD, Joseph Marupa will sign off the spec, will assist you with the budget, she makes it sound as if they are single-handedly now dealing with the tender, and she's not. What she would probably have done on her side is to try and sideline them. But she remained a project manager, and those guys were there to support her as far as to my knowledge. Thank you, Chair.
Well, that's certainly not her version. She says in your letter to her, you categorically removed her involvement in the training tender.
I can't recall that letter, Chair. It's very difficult to deal with it.
When you say you can't recall, does that mean you could possibly have written it?
I don't know, Chair. I don't know. All I know that I can align with is that Joseph Maripa was support services, no longer working at Ekurhuleni, and there's no tender. Ever since I arrived at Ekurhuleni, there was no tender he was not involved on. But the removal part, I won't know. I can't talk to it. I can only comment maybe when I see it, if indeed happened. There could be something that says, don't sideline, work with them. But I don't know, Chair. I sincerely don't know this one. Thank you.
Can I ask, did you appoint any of these people to the, you know, in a bid process, there's the admin stage where all they are doing is to check whether you have the correct documents, like tax documents, registration documents, and then it moves to the proper evaluation where you apply whatever you apply, then it moves to the adjudication. Did you appoint any of these people to any of those processes in the tender process?
Chair, what normally happens in the tender process, there's a project manager. Then the project manager will work with the team where, as I say, that they run with the bid specification. They also run to support the evaluation, but all that work is done under finance. And Joseph has always been the person who is running with these processes. So appointing, I'm not 100% sure, but it's always been people who are assisting with tender processes.
And then in paragraph 9.8 and 9.9, she says it's factually incorrect for Ms. Gxasheka to attempt to dissociate herself from processes that involve the training tender and its award. Ms. Gxasheka was the process owner and thus accountable for the tender. What's your response to that?
Chair, I'm going to repeat what I said. I don't see it in the bid specification. I've said my role was to say add formal education, mostly degree, masters and so forth. That was my comment. BSc, I've never went there. Bid evaluation, I was not there. Hence I said maybe get attendance registers, if possible, also get minutes of what transpired in those processes, Chair. I doubt you will not see my name. You will not see my name. I doubt that. I was not involved. Clearly, this is somebody who just wants to leave everything to me instead of allowing that the key stakeholders who ran with the tender must account. I don't agree with what she's saying. I was not fully involved, and I didn't award the tender. It will be irregular for me.
Just to clarify what she's saying and what she's not saying, I don't think she's ever suggesting that you sat on the BEC or the BAC. But what she is saying is that the people in the department who sat on the BAC and the BEC reported to you, not to her. What's your response to that?
I've already responded, Chair. There's 5 divisions at that time, if I can recall, in HR. It was the support services, it was her division, strategic HR, and talent management. And it was HRBP, and it was LER and others. And those people are coming from those divisions. If you see the structure of HR, the only people that are reporting to me is the divisional heads and the PA and the coordinator. So it's not proper what she's saying that those people were reporting to me. It's not true reflection of what is happening in the city of Ekurhuleni.
Thank you very much. I don't have any further questions.
Mr. Chaskalson, you moved too quickly for me and left the promotion topic to deal with this statement. I don't have the document that you shared with us, the promotion, the interview panel.
The interview panel.
If you would, please.
It's pages 58 onwards of the
Mr. Mashazi.
Mashazi bundle.
We don't have
You don't have
Mashazi
it?
file, no.
Oh, can we display it?
Yes, please.
Oh, thank you. Mr. Gxasheka, you have in front of you there that summary that we discussed earlier. And the panel, you went through who comprised the panel, and there's 3 people eventually, because you confirmed that Mr. Behari did not partake. So instead of 4, you now had 3 people. Now, can you just explain what it means that the HOD SRAC does not indicate whether she approves or disagrees, and what is the consequence of that?
Chair, again, it's part of continuous improvement. You will realize in majority of documents that will have, sometimes a person won't tick. Sometimes you will find out it ticks, doesn't even put a signature. But sometimes when we audit, we follow those things up. But one thing I can tell you, it didn't mean that she was not recommending the candidate.
Does it mean she recommended the candidate?
Yes.
Why do you say that from this document?
Because we'll elaborate. Remember, before we decide that the first choice is Mr. Mkhwanazi. For instance, if we said its first choice is Mr. Mkhwanazi, the second choice is Mr. du Plessis, it would have been a collective decision of the panel.
And where do we see that in this document? I mean, there's a reason you've got this document as a record of what happened. Now, it doesn't tell us on this record what her position was on either candidate.
Chair, I think because she signed and it said their first choice, probably she agreed. Yes, it was an oversight on her not to approve and not to put the telephone number. But she signed there, and it means she agreed with the appointment of the candidate. I don't recall.
If she didn't agree with it, would she not have signed? If she had ticked not approved, are you saying with that explanation that therefore she would not have signed this?
I get what you're saying, that she should have put approved or not approved.
No, she didn't put that.
Yes.
You say her signature signifies that she approved. And I'm saying the inverse, if you're correct, then the inverse would be true, which is if she had disapproved, she would not have signed. Is that what you're saying?
Chair, remembering the events, we all agreed on the recommendation of Mr. Julius Mkhwanazi, according to that document. If why she didn't tick, I think, and not put her date, it's one of those sometimes errors that people will make. And in the inferences on balance of probabilities, I'm talking on the probability, Chair, that Julius's name is there. And if you check the scoring, Chair, Isaac Mapia scored Mr. Mkhwanazi 21, Ms. Zanele Katembo scored Mkhwanazi 20, I scored Mkhwanazi 21.
Okay.
So you can see there, and then du Plessis, Zanele scored du Plessis 17.
Yes.
So on balance of probability,
Okay.
she would have agreed here.
I think that does answer me, your reference to the scoring. Now, a different question relating to this promotion. Brigadier Mkhwanazi was being promoted to a obviously a senior position with different responsibilities. You're nodding?
Yes, it will be.
Okay. And do you not, when I say you, I mean the city, does it not conduct competency assessments for now he's moving to a completely different position? Is that not part of what you do?
For the divisional heads, and the deputy chief of police is also at a divisional head, Chair. And we do conduct psychometric assessments, and they were also conducted for Julius Mkhwanazi.
Okay. The evidence that we have is none was conducted.
Chair, I did see that. I think in the chief statement or
Yes.
one of the statements, they did say that.
And you don't address it in your statement because it's quite a serious thing to say, because effectively it says the appointment was the promotion was an irregularity. That's the effect of it, that it was an incomplete process. In fact, let me remind you what Chief Mapiaye said in his evidence. He said, the panel conducted this interview, you scored the candidates, there was the next step, which is a competency assessment, which you've just confirmed would happen. And according to him, once the results are out, then the panel finally makes its determination depending on the results, because the competency result may well say is unsuitable for the position. And that whole step of a competency assessment and further process did not happen. And yet, you wrote and recommended his appointment to the city manager.
Chair, there's so many articulations that the chief made in his statement, and if I didn't address this part, it must have been on different versions that we keep on changing. I should have addressed it. Chief, he even says he's the only appointing officer. I couldn't understand what he says that, because with different documents that the city has, that's not true. In this instance as well, Chair, once we have made this recommendation, the issue of psychometric assessments, it becomes, it's quite a clinical process, Commissioner Baloyi. I think you will know from the psychological point of view that it's quite a sensitive process. When you go there for assessments, the psychometrists there, they tell you, the candidate itself, don't ask HR, don't ask anyone, come back to us. Successful or not successful, once the appointment has been made, you speak to us. That's the first issue. And the second issue, as much as I'll share documents, I think it's one of the documents I was very skeptical to share, because I don't share this document even with council in the council meetings. It's between myself and the psychometrist in the city. I think we've got 3 psychometrists, but I share with one psychometrist because she has to do a talent management and plotting process. So she's the only person who gets this process, this document. I don't know any HOD who can attest and say they've ever seen this document. Nobody sees those documents. And majority of time, it's meant for to identify the gaps and see how you can sort them, and for HODs, even for remuneration purposes. So I don't want to agree when Chief says he expected to see this document.
No, he didn't. I didn't say he said he expected. I said he says that Commissioner Mkhwanazi was supposed to undergo an assessment, a competency assessment. That didn't happen. In fact, what he says in his statement, let me read it for you. He says, the HOD, so what he says, at the conclusion of the interviews, both candidates, as is the norm for appointments at that level, were to undertake competency assessments, at the conclusion of which the panel would reconvene and make a final evaluation based on the interview scores and the competency assessment results, and thereafter recommend the successful candidate for appointment. The HOD HR never reconvened, this is paragraph 67, never reconvened the panel for the purpose stated above. And of course, he does say, I have never seen the competency assessment result of either candidate and do not know if either undertook such assessment. I can confirm that the interview panel thus never completed its task and never did it recommend the appointment of any of the two candidates to the post. So first, let me correct myself where I said to you, he never said that he did not see he has not seen the competency assessment results. He does say that. But the more important part is he says you never reconvened, one, and then two, he says the panel would have taken into account the interview scores and the competency assessments, and then on the basis of both, a recommendation would then be made whether to appoint the person to the position or not, and that never happened in this case.
Thank you. We're looking at this document. If you see in this document, there is no first and second choice. There's only one choice. And if the intention was to recommend both candidates, would normally, sometimes you recommend even 4 to go for assessments, depending for whatever reason, if they scored the same. In this instance, one person is recommended, Julius Mkhwanazi. There is no second choice. And number two, I'm still reiterating.
In the document, there's no recommendation. Let's represent it properly. All that the document contains is the scores of the candidates. It doesn't say any one of them unless I'm not seeing it.
Chair, this is the document.
You say first choice. You say your first choice is Mr. Mkhwanazi, yes. That's what you say?
Chair, if you read the document from top, it says interview summary and recommendation.
Yes.
Then just before first choice, Chair, it says recommended candidates or applicant's name, okay. Right? Then below that table, then it's the reason it's there is to ensure that whoever you recommend, let's say they scored the same, you then put them there. Then from the psychometric assessment, you can make a decision that based on these two candidates who got the same, who do you take?
Yes.
In this instance,
and who makes the decision about finally taking into account the psychometric? You've just said you would take into account the psychometric results, right? The competency assessment results, and then you would say we appoint. Who makes that decision?
Chair, the decision is made through this process. This process is concluded, right? Then you say you take the candidates for psychometric assessments. And the reason for that is, I'm saying, if there's two that's got the same, you can recommend and say, this is your first choice, this is your second choice. And then from the results of the psychometric assessment, then you are able to look at the gaps. But we never reconvene. It's the decision that is made based on this. Appointment is based on this.
So maybe let me ask more directly. If General Mkhwanazi, Commissioner Mkhwanazi, scored 0, I don't know what are the scores of psychometric testing. I think we know from another forum, discussion in other forum, not City of Ekurhuleni, that there is a negative and a positive outcome, and flippantly referred to as pass or fail. Now, if the psychometric assessment of Commissioner Mkhwanazi, which you say is known only by you, not the other members of the panel, if it comes back and it's negative, which means it's not supportive of his elevation to this new position, what happens in that case?
We hardly get to a situation. I think the metrics we use in terms of assessment is got basic, advanced, superior, and competent. When you score basic, majority, they are. I've spoken to this matter even at the mayoral level. You do get candidates, even at an HOD level, who score basic. But what we do, we check your strength and we check your weaknesses. And then the reason I transfer this document to the psychometrist lady, she's the one who will then develop your individual development plan so that it's aligned. So we do appoint people out of all those 4 categories. It's just that
Even when they have scored basic.
Yes, it's just that when they score basic, that's where you must force that the IDP, the development plan of that individual must be aligned now with this. If you score competent, you then do your own development plan. We don't
So
focus on it.
whether Commissioner Mkhwanazi scored basic, which you say is the lowest, or not, only you would know.
Only
That's
me
what
and
you're
the
saying.
psychometrist will know.
No, I'm saying for purposes
Here,
of
it's me.
recommending
Yes.
a promotion.
Yes.
So we would have to rely on you having been satisfied
Yes.
that he should be promoted, whatever the outcome of that score
Yes.
is. Okay, that's fine. So you deny that he never went for an assessment?
Chair, as I say, it's a sensitive document. I can just show you the first page and the second page. That's all I can show you.
And
they
that's the
should-
result of his assessment?
Yes,
Is that
and
what you're
the
saying?
psychometric house, I don't know if they will still have it or they can even release it, but it's really not true. Hence, I'm saying no HOD I give this to. Hence, I didn't even put it in the pack.
Okay. And that is part of the documents before us?
No.
I think it has to be, because serious allegations have been made. We do have a system of redacting the information, but I'm going to ask the evidence leaders to get a copy of that document so that we have it in our records.
Chair, on that, because as I say, we don't share this document even with council, what I normally do, I will share with you the certain pages, not the ones that, for instance, describe the employees' certain assessments, but page 1 and page 2 I will share. Also the page, I hope I won't get into trouble on this, and then also the page on the competency.
Ms. Gxasheka,
Profile.
let me try and be helpful to cut it short. You will have to provide the full document because allegations have been made that he never underwent the test. Your defense or your answer is it was done, and here we have a record of it. It has to be provided. I think there can be discussion with the evidence leaders about how to handle it, to deal with your sensitivities about it. But you've referred to it in evidence here, so it has to be part of our record.
Chair, it's fine. I will discuss it with the evidence leader that it can be inspected. And then beyond the inspection, if it's really required, then I think going to the psychometric house, it will assist. But their details are also here. Thank you.
All right, I'm happy to leave that there. I do have other unrelated questions. The earlier discussion about extending suspension periods, can you just remind me, Mr. Ngqiza, he was suspended for how long?
I can't remember, Chair.
Did you ever have to extend his suspension?
Yes,
You did?
yes.
Okay. And what was the reason that you extended his suspension?
We were looking at the allegations of the labor
His
relations
qualifications.
cost.
His qualifications.
No, it was the labor relations cost, related cost, labor cost, basically.
Yes.
Yes.
And why couldn't he be at work? And maybe let me first explain that the reason I'm clarifying this for the record is because you did not extend the suspension of Mkhwanazi, Commissioner Mkhwanazi, even as Chief Mapie responded and said he will interfere with witnesses. You have told us how fearful you became when you were told about him, and you didn't extend his suspension, and yet another employee you suspended, you extended his suspension, and the 3 months, 6 months debate that you were having earlier on, that you were starting, doesn't seem to have been a relevant factor. So maybe just explain what, on the face of it, appears to be an inconsistency and feeds into the suggestion by witnesses that, in fact, you were terrorizing and harassing witnesses who wanted to act against Mkhwanazi. And then this is one of the references that you for no reason, no valid reason, extended the suspension of Mr. Nhlanhla when it was unnecessary to do that.
Commissioner, can you respond? There's a witness who says I was terrorizing them.
You were part of Dr. Mashazi's scheme to harass witnesses and pressure, to harass Nhlanhla, Mapiyeye, and Spies. But in this case, we are talking about
I would like to see that, Chair, because I want to refute that.
Yes, you can refute it. I'm putting to you what the complaint is. The complaint is Mr. Nhlanhla makes a number of instances where he says that's evidence of you harassing him, sending EMPD vehicles to his family to deliver documents when it was unnecessary. And when he asks, why do they come in 4 vehicles? They say it's Ms. Gxasheka's instruction that when we come and serve at you, we must bring all the might. We must come in 4 cars. He says that. And then when you sent him your termination letter or something, there were drug enforcement people that came to deliver documents at his house. All of it unnecessary, but meant to intimidate and harass him. That's the sum of his evidence. So,
thank you.
So my conversation for now is confined to the extension of his suspension in circumstances where someone else facing far serious charges, who is very close to the city manager, that you say you got scared when they spoke about, you did not extend his suspension.
Yeah, Chair, I'm not sure now if I must complain formally. Initially, when we briefed yesterday, and there was an agreement here that certain allegations would not be, implications won't be dealt with. When I wanted to deal with the issues of Mr. Nhlanhla, I was cut short here. And I did say that it did look bad outside. But I still complied when it was said cut short. That implication, if I'm not mistaken, is a separate implication. And from evidence leader and from the commission yesterday, there was an agreement that we will not deal with that. And it was concerning Commissioner that it was not dealt with, because I really wanted to deal with it.
Okay,
because
Mr.
you are
Sheka,
reminding me now of
correct.
the implications
No, let me correct you. You have no agreement with the commissioners about what you will be led on and not. The only thing yesterday that we were told you would not be led on was to do with the tender. You don't have an agreement with us as a panel. Having said that, allegations were made against you. I would expect you to be happy that I'm putting this to you to answer. Because if I don't put it to you to answer, it remains the last word on this. So I'm quite surprised that you would complain when you are being given an opportunity to respond to what a witness has said about you. Absolutely don't understand it. I'm happy to leave it at the accusation. If you don't want to respond to it, I'll leave it at what Mr. Nhlanhla said. You can choose which one you want. I can leave it.
Chair, as I said, I was fully prepared to deal with this matter yesterday, and I was told I don't need to focus on it. In terms of that implication, I think he quoted 40-something cars or 86 cars that were taken to his house. And when I give an instruction to be served or request to EMPD to serve, I give to one person, and majority of the time it was Dion. I'll say, Dion, go and assist to serve and come back. In my statement, I said,
Can you please use the surname?
Dion Singh. In my statement, I said, I asked Mr. Nhlanhla way before that when you are serving, because I'll pick it up when they serve HODs, when they serve juniors, I wouldn't necessarily know how they serve it. And I asked, why are you using police to serve employees? Why don't you use your ER officers? And he then said, ideally, they're supposed to use sheriffs, but it becomes expensive to use sheriffs. That's why he's using EMPD. And the reason being that they can trace employees down. There are employees who run away who don't want to be served. And therefore, I'll never take and say the whole crew must go to somebody's house. There he's bluntly lying. If it happened, it was not by my request. At EMPD, I request majority of the time, the maximum number, of the time of the people who will arrive in my office is 2, maximum. Most of the time it's 1. If they see the address is far or they can't find a person, it would be 2. Let's say you did an intention and then the person gives you run around, they would want to go to. It's not true that I've sent so many cars at Xolani's house. He's just exaggerating. If it happened, I wouldn't know. Maybe he's not exaggerating.
Okay.
On the issue of
Extension.
of the
That was my
extension,
question.
yes.
Yeah, I was
Chair,
about
we've
to
discussed
check.
this.
I was still to check whether you remember what my question was. My question was about the extension.
Extension we've discussed for 2 days.
I'm talking about the extension of NISA. Remember the extension we have discussed is the suspension of Commissioner Mkhwanazi, right? I'm not talking about that. I'm talking about the extension of Mr. Nisa's suspension. Because when we were discussing Commissioner Mkhwanazi today, the extension of his suspension, you said, well, 3 months, 6 months, the city manager had an option we could have done, it's the end of 3 months, he must go back to work, or we could extend for 6 months. You don't seem to have made the same consideration when it came to Mr. Nisa. You extended, and that's why I'm asking, why did you treat him differently?
Thank you, Chair. In my response, even yesterday, I've been very consistent in my testimony. Before you didn't have to probe me. I said yesterday, in some instances, we do extend. In some instances, we don't extend. And the reason...
The question is why... No, don't answer generally. Remember...
I'm going to come to Mr. Nhlanhla.
Yeah, I'm asking a very specific question. I think, take it we know that your prescripts, because we've had that evidence, that you can extend beyond 3 months. We understand that. And take it that we understand that you may call an employee back before the end of the period of suspension because you have completed your investigations. Take that as a given. I'm asking you specifically about NISA to try and understand, to make me understand what appears to be different treatment of employees. The one accused of very serious misconduct, his boss says he may interfere with witnesses if he comes back to work, but he's allowed to come back to work. Mr. Nisa, on the other hand, is not allowed to come back to work. He's extended for another 3 months. Can you just explain? And I was just giving you the context in which my request for an explanation is made. It is the accusation or complaint is this was part of the campaign of harassment of people who are seen to be chasing after Mkhwanazi. That's a context in which I would like to understand why him you seem to have treated differently.
Chair, I've said earlier on here, if maybe in the beginning the matter of Mkhwanazi was never taken to Dr. Mashazi, maybe we won't be here. I did say that. The matter of Mr. Nhlanhla was fully managed by myself. Hence, even other matters in other departments are managed by the department. We don't necessarily have this challenge. If there was no interference on instructions that are given differently from Mkhwanazi in comparison to anybody else, maybe won't be here. So normally departments, they decide through our guidance to extend or not to extend, depending on the circumstances. So in this particular manner, I was fully involved, and therefore I made that determination. I didn't need to consult anybody. One mistake we're learning from this, probably me and Chief of Police, is when you are given delegations, fully deal with them.
Okay.
Chair, it's highly possible, even if you were, maybe Chief of Police didn't go to the city manager, she might have still heard about it and she would have still intervened. But at least one thing we must learn, when we are given full delegations, run with them.
All right.
Until we are stopped.
Another question. Why did you become involved in the Chief of Police decision to redeploy Commissioner Mkhwanazi when you lifted his suspension? His boss, who we understand is in charge of deployments and promotions and movements in his unit. Why did you become involved with that?
I've said in my testimony from yesterday and today, if you read, I think the first or second sentence of that upliftment, I said it came to my attention. And I said, I meant that I was told by the accounting officer that once more you are not managing, and therefore, why is this happening? Whereas I've made a decision that Mr. Mkhwanazi must not be, his suspension is uplifted. Why you are not following this?
Okay, so the city manager instructed you to intervene here and make sure that Commissioner Mkhwanazi is returned to his substantive position. Is that how we should understand what you've just said now?
Yes, that's how it happened.
Okay, all right. And then my last question, I think. Yesterday, there are two things, in fact, to it, and I think they are unrelated. I'm going to ask very quickly and hope to get a quick answer. You, yesterday, and in your statement, you say that, I don't have it in front of me, you say something to the effect, we must look at city of Ekurhuleni with a fine eye. You remember you say something like that in your statement? And then in your oral evidence, you said what we have seen or heard is the tip of the iceberg. Now, taking into account our terms of reference, you know what we are investigating, infiltration of criminal syndicates, cartels into law enforcement. What do you say we haven't heard, which makes you say so far what we have heard is the tip of the iceberg?
Chair,
because, and I ask you not to put you in a spot, but because we are that commission that is tasked to investigate this, and you spoke in different in different terms. You said we should look at this carefully.
Chair, I've made examples, and firstly, I want it to be recorded. In the absence of the risk threat analysis not being taken serious, I don't want you to have escalating statistics here. It will be a very sad situation that by the time the commission is concluded, the statistics of how certain lives are managed out there have increased. But because I've put the issue in the commission, I've said, firstly, there's about 20 to 40 forensic that are not yet brought to the fore. When I said...
And they are relevant to our terms of reference.
Remember, Chair, I said, because others, I don't think they are relevant, I said before I suspended to the OCMOL, the that they must look at having perhaps a mirror task team that would look with issues of Ekurhuleni, where they can give every HOD an opportunity to come and raise their challenges. In the absence of those 40 documents and not forensic reports not being brought to the fore, it's concerning. And people were doing runaround. After doing runaround, I was then ultimately suspended when I keep on pushing that bring these files, let's see them, and where possible, let's close them. There's so many media engagement information that is being shared out there, especially Jeff Weeks and I think News 24, that this commission should be aware of. And because they have not been brought here, Chair, hence I said from the OCMOL, and if they take it up, in fact I was reprimanded when I said that. They said I'm out of order. If I remember, one councillor said, because I was mentioned in Madlanga and protest against me. So I'm being out of order to say there must be a task team. Those were articulations, those minutes are available where I was reprimanded. And I was trying to assist Ekurhuleni to say, are we always going to have this commission for the institutional reform to happen?
Is the long and short of what you're saying that there are matters that have not yet served before the commission with the witnesses that have come, which are relevant to the terms of reference that the commission should look at? Is that the long and short of what you're saying?
From those that I've seen in the media space, Chair, I think those people that are implicated in those situations, Jeff Weeks brought this and made sure that EMPD or Ekurhuleni is involved. In the others that I mentioned as well, Jeff Weeks was running with it. Okay. And the other ones that are not yet mentioned, Chair, I think Mr. Philip Rahwale should be called to come and talk to the commission that these cases that is having, what are they all about, if it needs to be, because I don't know they are talking to the terms of reference. I want that to be reiterated. My ultimate proposal was to say, Ekurhuleni, clean yourself. Reforms, institutional and structural reforms can be done, Chair, and be imposed, but if they are not done by the institution itself, I promise you it's going to be documents that are left and gather dust somewhere. All these departments that are implicated here, all these institutions, at some point they must do their own institutional reforms, systems reforms, structural reforms. Okay. And maybe it's something that the commission might make as a decision that says, after 12 months or 6 months, bring back what we have done to change. You'll impose, but I guarantee you, if it's not done by the institution itself, there's little that is going to come with your recommendations on the institutional reforms. That's what I was articulating to the OCMOL. Thank you.
All right, lastly from me, and it comes again from your evidence, you mentioned Mr. Matlala having met him twice or thrice. I think that's how you started. You said twice or thrice. And then you said one of the times was he had come to you about a woman who had been assaulted or something, to come and speak to you about that. And then there were 2 other instances, and it is the second part that I didn't quite get, because I think you said something about COVID tests or something, if I'm not mistaken. You said something. But I want to the second part. So you had the one instance where he came to lay a complaint about a woman who had been assaulted. The other 2 times, what was it about?
The second part, Chair, it was also about an incident, two incidents of involving car accidents where a certain senior person, Ekurhuleni, was protected by certain employees of Ekurhuleni, where he said
When you say senior person, an MMC.
no, an HOD,
Okay.
where that HOD was then protected by his team, and instead of being tested for drunken driving, he was not tested. But the other person who was on the other car, I think he was highly injured, was then tested. That was the first issue. And that issue...
Is that one of the things that Mr. Matlala came to see you about?
Yes, then the second issue, he then said that there's decisions that are made by certain individuals in terms of the succession plan of the city manager, where certain names were discussed somewhere, and the person that we are proposing, but I wasn't part of that, proposing to be made a city manager, also has a criminal case pending, but it was put under the carpet by this other senior person who also had an accident. And my response to him was, I need proper evidence to this. And then he said, I'm stalling things. He's going to report us to the public protector. If I'm not mistaken, he even sent me his writing to the public protector. He also wanted the numbers of the spokesperson. It was a lot of things. That's when I then said, I think you're starting to take me for granted, because I guided him and I said, go to the police. You know, go to the police and speak to the police. HR, it's not a crime prevention or a crime investigation department. We deal with labor relations issues. Then he attacked me. Then that's when I told him where to get off.
Okay. It's quite interesting that he would want to have it, and he has an interest in what the city is planning to do about a city manager. What was his relationship at that time when that conversation about the succession of the city manager? Did he have any relationship with the city, whether business or other form?
I can't recall at that time. I can't recall. As I say, I just dismissed him.
Okay.
I can't recall.
All right. Thank you, Mr. Gxasheka.
Thank you.
Why would he come to head of HR about these issues? What do they have to do with HR?
My suspicion at the time, now that I linked the thing, because if you remember, I said yesterday, I listened tentatively, with full attention of what is this person all about. My own assumption is that he was trying to protect Mr. Mkhwanazi, in the sense that you guys are dealing with Mr. Mkhwanazi, but you're not dealing with other people in the city. That's when I told him where to get off, and I said, go and do what you need to do.
And more or less, when was this?
I can't recall
Not
the
the
event.
exact month, but just, is it 2023? Is it 2022? Is it?
It was around December 2024, if I'm not mistaken.
Thank you.
Not December, sorry, Chair, not December 2024. It could have been around August or September, October. It was before December. Because if I listen there, oh God, I hope I'm going to be protected. And I'm listening there, I said, this guy, I tell him where to get off. After that, he gets arrested. Because he even said to me that I have drones. I'm going to put cameras in your house and I will know what you're doing. And my response was, you can put them wherever you want as long as you don't put them inside my house, before I left him. So it won't be December if he was arrested in December, because I said, yeah, he was dealing with me and life dealt with me, but was not involved in his arrest. I never followed it up. Even in the 3 or few occasions I met with him, it was just casual and then pressing on these issues that I said must refer to the police.
Mrs. Gxasheka, in paragraph 131, or rather from paragraph 131 onwards, you deal with the vetting question, that is the vetting of members of the EMPD. I do not see you directly dealing or categorically dealing with the issue that was raised by Chief Mapia, I think Commissioner Spies as well, to the effect that, I think mainly Commissioner Spies actually, to the effect that a vetting process, that is the vetting of all the police officers within the municipality, a vetting process was conducted, and that Brigadier or Commissioner Mkhwanazi and all the police officers falling under his command refused to be subjected to that process. That is what the testimony of Commissioner Spies said. Are you aware of that?
The way we were looking at the matter, my understanding, they were going to vet everybody. But if I check on the emails, Mr. Mkhwanazi says the data is obsolete, let's start afresh. But I didn't zoom down to see that indeed it's only his department that doesn't want to be vetted. But I think I saw that.
We actually, in testimony, Commissioner Spies showed us a schedule that actually set out even the results of the vetting process. Some of the crimes referred to being crimes that were committed when the police officers were already within the employ of the municipality. So there is a report, the vetting was actually done. But, so says Commissioner Spies, Commissioner Mkhwanazi and everybody falling under his command refused to be subjected to that process. Now, the meeting that you referred to in paragraph 133 of your supplementary statement at page 42. Did that meeting not deal with this subject?
Joy, can I sorry, Commissioner, I think I need to see that.
All right, all right. A supplementary statement.
Yes.
Paragraph 133 at page 42.
Paragraph?
133, page 42. You say you were invited to a meeting by Chief Mapia. So my question is, did that meeting not discuss the question I've just referred to, the refusal by Commissioner Mkhwanazi and all police officers falling under his command to be subjected to the vetting process?
Chair, when I was in that meeting, in one of the meetings, especially this one, I didn't stay long. So if there was a refusal to have that, I could have missed it. But one thing we agreed was that the vetting must happen and is for the whole EMPD. I think that was my understanding. If Mr. Mkhwanazi didn't want specifically for his department division to be processed, it's highly possible. Because I remember somebody also said he called Dr. Mashazi, it's just that I'm also tired now, I can't remember everything, and complained. But when that happens, I was not even there. Because if he called Dr. Mashazi, I don't think would have allowed that, maybe he would have still done it.
Just
so
please explain
recall,
what was the call about? Please explain what was the call about?
I saw in one of the statements, Chair, where someone said, while this was being discussed, then Brigadier Mkhwanazi, the deputy chief of police, called Dr. Mashaz. And then he said after that, it won't happen. But I can't recall, I don't think I was still in the meeting when that happened. And highly possible it did happen.
That is exactly when Commissioner Mkhwanazi was allegedly refusing to be subjected to the vetting process. And he was basically appealing, allegedly, to Dr. Mashazi not to be subjected to that process. In my recollection of the testimony, that was the purpose of the call.
Yes, Chair, as I say, I did see that, but I don't think I was still in the meeting when that happened. I did see in the statements.
Can you tell me why, let me ask this question first. Did you not consider the question of the vetting of the Ekurhuleni police to be a very important subject?
It was a very important subject, Chair. Hence
Okay.
I said...
Why did you say that, but I did not stay long? Why would you not have stayed long for such an important discussion?
I did provide a direction, Chair, and I even said, let's go and seek a legal opinion. So to me, the key issues I wanted to deal with and the understanding of the issues I've dealt with, I provided a direction and the legal opinion was sought. And as I said earlier on, even where I guided them that the letter must be drafted, you must do expungement. So my contribution was done, Chair. I can't recall where I had to go in that particular day, but I gave my full part of that meeting in advising and the way forward. And we did follow up on things that we agreed must be done.
My understanding of the testimony is that the most important issue that in all probability would have been at the top of the discussions was the very issue of the refusal of Commissioner Mkhwanazi and his team to be subjected to the vetting process. So the simple point I want to make is that I do not understand that you apparently should not be aware of that. Should have been top of the list. That was the main thing, because on my understanding, everybody else had agreed to the vetting, had been subjected to the vetting, and results had been obtained. And I've referred you to what some of the results were.
Chair,
So
I fully agree
I find it a bit improbable that you should not be aware, as you suggest you are not, that there was such an issue.
Chair, I think I did speak to it yesterday, that I saw debates happening. What I'm saying, in the meeting, I don't recall.
At which point did you see those debates?
It was on the emails.
Before this meeting?
I'm not sure if it was before or after this meeting, Chair. I think it could have been after this meeting, whereby they were saying that the data is outdated, we must start afresh, and so forth. But in that particular meeting, I could have missed it. I could have missed it. As I say, it could have happened after I left, and I thought I would have put that in my statement.
Let me conclude by making two suggestions to you, two related suggestions. I think I've already made one. One, this vetting issue relating to the alleged refusal of Commissioner Mkhwanazi and his team to be subjected to the vetting was in all probability top of the list in the discussion that was to take place. And secondly, it is very strange, I suggest to you, that you should have left the meeting, or you should, as you say, not have stayed long at that meeting when it was to discuss such a serious issue.
Apologies, sir. I did leave capable people. My team was capable. That's why even when Lefu followed up on the legal opinion, I responded there and there and said, thank you for following it up. And we continued with it. Indeed, I should have stayed until the longest time. I would have picked it up if there's a resistance. But I felt that I left a capable team, And indeed, we did follow it up and make sure that we get the legal opinion. I kept on following it up, and issues of Mkhwanazi Chair are managed by a senior person who seems to be protecting Mkhwanazi. And it's really a pity that we are also sent to be
why
the
was
same.
there a need for a legal opinion? I don't understand this. All other police officers have been subjected to the vetting process. And that vetting process has revealed criminality, basically. And not only criminality that was there before the police officers were employed, but criminality that was committed when some of the police officers were already employed by the municipality. That's very, very serious. Now, Brigadier Mkhwanazi or Commissioner Mkhwanazi and his team cannot be an outlier, the sort of outlier in respect of which there could not have been similar findings. So the simple point or the simple thing that should have been done was for you to direct Commissioner Mkhwanazi and his team to agree to being subjected to the vetting process. I don't understand what the legal opinion was for.
Chair, we did direct in terms of what needs to be done, and we did say that this vetting process must happen.
At what point? At what point? Because you keep referring to the legal opinion and having left a team that you had confidence in, and then you refer to the legal opinion afterwards. At what point did you direct?
In terms of the emails on that document I shared today, I did explain, Chair, at what point I said they must conduct the process.
At what point would this have been in relation to Chief Mapia's meeting and the opinion? At what point would this direction have been? Because I believe that the direction should have been immediate. If there are allegations that they have refused to subject themselves to the vetting process, the direction should have been immediate. And surely you would remember if you did that or you did not. So it can't require you to find some document or some email to respond to the question.
Chair, we all agreed that this must happen, and it was just the process to follow.
My question is at what point? That's the
Immediately,
question.
Chair, immediately. Hence, after the legal opinion, if you saw, we quickly responded and say, let's embark on this.
So are you saying you only directed after the legal opinion?
No, before that, I said, Chair, they must go and get the issue of the consent. They must draft an expungement. They must go and check the expungement policy, how it goes. They must also categorize them into those different categories. When did you receive a legal opinion? Criminal record. Was it before you were employed or after were you employed? And what was the type of the criminal activity that you were involved on?
Thank you. I will ask the question for the third time. At what point in relation to Chief Mapia's meeting did you give the direction that Commissioner Mkhwanazi and his team should subject themselves to the vetting process? I'm asking it for the first time. For the third time.
Yes, Chair, in that meeting, it was very clear that everybody must be subjected to a criminal record, to the vetting process. And if I recall, they already indicated that...
You are referring to a direction by you, as I understand you. Now you're saying at that meeting it was clear. I'm asking you about your direction. When did you give your direction?
In that meeting, Chair.
At that meeting you gave your direction.
Yes, then I said, Chair, in doing it, let's follow a certain process.
Yes.
That's what I said. So when I'm saying let's get a legal opinion, we all agreeing that it must be done. But there's a way of doing it. Then I said, let's get a legal opinion to see how best to do it. And hence I said, let's have categories. Well, when did you get it and so forth, because there could be issues of fraud. Okay, I'm lacking a better word of using, I'll use fraud in terms of sometimes a person, when did you get this? Was it before you were appointed or after you were appointed? Number two, what were the reasons for you to get a criminal record? So I've directed in that meeting, Chair, before I leave, that let's do this vetting.
Was it at the point of your direction that Commissioner Mkhwanazi called Dr. Mashazi?
No, I wasn't there, Chair. I wasn't there. As I say, I'm not sure when did he call Dr. Mashazi. But I agree, highly possible it did happen. In my side, I said everybody must be vetted. All you must do, you must have a consent, and let's check who is due for expungement, and let's also get a consent. That was very clear on it.
That's something quite detailed, you know, and I find it strange that you do not deal with it in your statement, which is also quite detailed on the vetting issue, or do you? The issue of the direction, and whatever else you say accompanied it. You do not say, I gave a direction that Commissioner Mkhwanazi and his team should subject themselves to the vetting process. So I'm saying that's something quite important, something quite crucial. I find it very strange that you do not mention it in your statement.
It's a pity, Chair, that it's not mentioned. As I say, other evidence I thought will be provided orally. And I think I'm trying by all means to show consistency in terms of what roles I would have played. It's something that can be re-looked at if there's a need to do that. But I was very clear in supporting that vetting must happen, Chair.
I will just say, I mean, you have a whole lot starting from paragraph 1 of your affidavit right up to the last paragraph, and you have given testimony with regard to all of those issues, except those that Mr. Chaskalson said, perhaps let us keep these for the reasons that he gave. You stated all of that in your affidavit, and you did not say, I will not state any of these because I'm going to testify on them. So I do not understand your response that you did not say this because you are going to give oral testimony on it. I just find it difficult to understand that.
You
may comment if you want to. Yes.
It wasn't intentional, Chair. As I say, as much as you try to have the statement. Remember, my first statement, it was very rushed. I think we didn't sleep that night. And then we had an opportunity when we had Dr. Mashazi's testimony to relook at.
Yes.
Otherwise, I tried my level best to show that I was supporting the process. I could have missed, you right, an important part where I was saying I gave a direction. But I thought through my evidence, Chair, it will indicate that she had an interest on this. Even when I said, oh, okay, we get the legal opinion, thank you. Proceed, let's move.
Thank you,
Thank you, Chair.
Can I just clarify something from this discussion with the Chair? This meeting that you're referring to, did you know at that time, at the time of that meeting, that that Commissioner Mkhwanazi has refused that he and his people that report to him should undergo vetting?
I didn't sense that.
So you were not specifically addressing that issue of Commissioner Mkhwanazi and his people refusing to go for vetting. You were not specifically addressing that.
I was addressing the issue of everybody that has been identified to have gone, who's supposed to go vetting, and I was saying people must go for vetting.
Yes.
The specifics I can't recall, but
So it wasn't about this issue that the Chair is raising, because there's two things. Everyone is instructed to undergo vetting, right? That's the instruction from Chief Mapia. In response to that, Commissioner Mkhwanazi refuses for him and his team to be vetted. And he's admitted that. He came here and testified that he didn't trust how it was going to be done. That's why he didn't do it. So it's not clear to me from your discussion with the chairperson whether you're saying that meeting that you say you left early, right? Where you specifically, when you said everyone must undergo vetting, this is the procedure, you must get consent forms, were you in that meeting to address specifically the issues that have been raised about Commissioner Mkhwanazi, or you were just speaking generally to everybody?
The way Chief explained it, he said that it's part of their clusteral meeting, police clusteral meeting, that everybody must be vetted. And my response to that was, I agree that everybody must be vetted. And if I recall, they could have done it before with, they were calling them peace officers or whatever, that were supposed to be converted into some MPO positions, and those people were arrested for political reasons years ago. So what I was saying, it was not the first time we had to embark in such a process.
When first did you hear that Commissioner Mkhwanazi has refused to be vetted, him and his people?
In that email where he said everybody must undergo, they don't trust the data, and therefore everyone must restart the process.
So you knew at that time?
I could
from
sense that.
From that email?
Yes, I could sense that there's some resistance. However, it's
no, but he doesn't say in that email exchange that him and his people are not going to do this. He speaks very generally. He says, the data is old, let's redo it, right? Let's do it. So I'm asking you more specifically, did you ever become aware that Commissioner Mkhwanazi has refused that he and his people, those who reported to him, should be vetted? Did you ever come to know that?
When he had engagements with me, it was the data is old and certain people are being targeted, and I don't know who are those people. And remember, that happens when now we go to OCMOL meetings where this issue continuously being discussed. And I think subsequently, I'm not sure if I testified to that, I even wrote to him and said, this vetting, Chief, must happen. If it doesn't happen, we're gonna be implicated. You know, so I did sense that.
So you did become aware that,
yes, I think
that he is resisting to undergo vetting.
Yes, when we went to one of the OCMOL meetings, the way he handled himself, I could sense that he's not too passionate to have this thing done. And I don't know.
And wasn't that something that you should take action about? To make sure it happens, because
I guided him, Chair. I guided him and said, Chief, please ensure that this vetting takes place. Remember, I think by that time, Chief was not even there when we're getting pressure from OCMOL. That when is this vetting happening? Because the allegation that was out there is that now there's people who have criminal records here.
Is there a reason that you didn't? Is there a reason that you did not start a process of disciplinary processes for him and whoever else that was refusing to be vetted? When you became aware that Mkhwanazi is not submitting to vetting, instead of the email that you later send and say, Chief, this is what the councillor was talking about, we better do this, otherwise they will come for us. HRNE MPD, there is that email.
Okay.
So I acknowledge you sent that email at some point, but I think the question is something else, which is, that's all you did. Why did you not, because it's such a serious matter, at least to us outsiders, that you have people who are not vetted, some of whom have got criminal records. We have a long report that Commissioner speaks with numbers of people who have cases of rape against them, of assault, and. When you learn that Commissioner Mkhwanazi, in whatever way you learn, and however it was presented to you, when you learn that he's refusing or resisting to be vetted, and that his people be vetted, why do you not institute disciplinary process about it? Because it's a simple matter. The rule says you must be vetted. you've provided guidance that they should be vetted. When you realize it's not happening, why are you not instituting disciplinary proceedings?
Chair, it's in our discussions, and I could have shared it in the emails. I said it's their capability to have that process done. For the whole city, it's done by them. And EMPD is the same people who says to me, today intervene, tomorrow don't intervene. And I keep on saying here in the commission, my role is to advise them. They keep on writing to me and tell me Section 64C doesn't allow you to be involved in our space. All I keep on doing for EMPD is to advise them. And I think it has been discussed here through other people's evidence that me and the Chief of Police were equals. All I can do is to advise. He has demonstrated, even Chief of Police himself, many times that stop interfering. What I've learned from...
That's not always correct, though.
I was about to say...
You've lifted the suspension of Mkhwanazi, who is in EMPD. You have told Chief you must return Commissioner Mkhwanazi to his substantive position. So you do get involved with HR matters. So it's not always true that you don't get involved with the MPD human resource issues.
Indeed, Chair, I do get involved, Commissioners. And even in this instance, I was fully involved in the sense that I did guide them throughout the process. You know, for them, they take my instructions or it's up to them. Sometimes they do, sometimes they don't. I agree with you, and I think my testimony and evidence is very clear that I do get involved. But you get involved to a space that is not clear. Hence, I said earlier on that one of the communications from Dr. Mashazi to Chief that says, Chief, draft a policy into this confusion. You know, if maybe that policy gets to be realized, it will also assist the city to stop the confusion. And hopefully, by the time everything is sorted, we can also realize the HRBP model so that we have somebody who's fully involved in that department. But I agree with you. I do assist them. I do try to make decisions, but ultimately, they decide what to do or not what to do.
Thank you. Thanks,
Thank
Mr.
you.
Gxasheka.
You want to say something?
I'm sorely tempted to take up this issue, but I think it's late in the day and we've gone very far. So I won't. But I do, sorry, I can't resist this. It seems to me that the chronology is very important. The meeting is on 2 April. The opinion is distributed on 5 April. On 5 April, you send a message to SPIS and to Mapiyeye saying, deal with these different categories. That's 5 April 2024. What then happens is not the chief, but Julius Mkhwanazi takes it upon himself to respond to your email and say, no, let's start the process afresh. And then nothing happens for a year. What did you do in a year? And we're not talking just about people who refuse to be vetted. We're also talking about 250 people who have been charged, who've either been convicted of serious offences or awaiting trial on serious offences. So there are 250 criminals inside the EMPD, alongside another 210 who refuse to have their fingerprints taken, and in respect of whom there must be a fairly strong presumption that if they did have their fingerprints taken, some bad things would emerge. What did you do for a whole year?
In my email, I said to the chief, if you saw, I didn't necessarily respond to one person. I responded to all of them and said, continue with your process. While you are busy with your process, keep us abreast. And that's the same chief who will say, don't get involved in my space. I do advise. If they want to take my advice, they take it. If they don't want to take my advice, they don't take it. We agree that they have the capacity The whole city, when they want vetting to be done, it's done by EMPD. I'm not sure how I would have assisted the chief and say, Chief, why are you not doing this? And subsequently to Chief, when these matters were raised, I said to Mr. Mkhwanazi, conclude this process.
No, what you said to Mr. Mkhwanazi was something different. If we go to page 2063. A year previously, literally a whole year previously, to the day, 6 April 2024, he had written saying, we must start this process afresh. There is no communication between you for a whole year. And then on Sunday, April the 6th, 2025, at 10:22 p.m., you forward him your message from a year ago, from Saturday, April the 6th, 2024. And you forward it under a message saying, this is the issue the councillor is referring to. We need to act on this, not because it's a disaster if there are criminals running around in the uniform of the EMPD, but we need to act on this before they use it against HR and EMPD. You weren't worried about criminals in the EMPD. You were worried about some councillor pointing a finger at you and Mr. Mkhwanazi for doing nothing about the fact that there are criminals in the EMPD.
Chair, I think I did say earlier on that the inference biasness I will accept. And I think I understand that it's based on being on the other side and I'm sitting on the other side. I'm still sticking by my evidence. I did write to them in 6 April, I agreed 2024, and I said, keep me an accounting officer abreast. When this didn't happen, and now it was raised in the OCMOL, to me, the mere fact that it's Sunday, it shows as well that one is not resting. He's looking at matters, despite that it's a Sunday, at 10:22 p.m. It shows you that when they say what things that makes you not to sleep at night, this would be one of them. And if you look now, how things happened is things could have been done better. I agree, and one could have been forced them to do it. When I force them to do, I account. When I don't force them to do anything, I still account. And as I say, Commissioner, we are learning from this, that a policy that integrates all these legislations and systems of delegations will assist. And it was wrong of Mkhwanazi and the Chief of Police and not to ensure that this vetting happens. But I'm hoping that that integrated policy will really assist.
But the real question is, what was keeping you up at night? Was it the fact that there were 250 criminals running around in EMPD uniforms? Or was it the fact that someone had discovered that there were 250 criminals in EMPD uniforms and was now taking the issue up and pointing fingers at HR and EMPD for letting it happen? What was keeping you up at night?
It's all of those. It was all of them. It was all of them.
But then why did it take you a whole year before you started getting anxious about the fact that there were 250 criminals in EMPD uniforms?
Some discussions, Chair, they take place in different platforms, and I think I did speak to that. It might look like because the email, the only written evidence now is this email. Others might not appear, but we do have engagement on these things, and we kept on discussing them. And ultimately, it's an EMPD issue, not necessarily it was my issue. I am taking up that I should have known better and I should have owned this process and not leave it to them, especially because they were fighting among themselves.
Thanks. I don't have any further questions.
reached the end of the testimony. Sorry. Oh,
Mr. Chaskalson, the request for an affidavit to do with that medical report, was anything done about it? Was it addressed to the legal representatives?
No, but it will be.
Okay. All right. Thank you.
There being no application for re-examination, this is the end of the testimony, or is there such an application? Yes, Ms. Magula.
Mr. Chairman,
Yes.
at this moment, I think there are only two aspects that I would like to re-examine on, or bring an application to re-examine on. It's on the matter of the topic of reverse peace and
Which aspect of his testimony?
just a minute, Mr. Chair. The first one
Yes, yes.
The first one, Mr. Chairperson, it's about the issue of that when Ms. Linda Gxasheka testified, she was giving a visionary of what had to happen. So I just request to re-examine her on the aspect that I want her to confirm actually that there was no existing precedent.
No existing
No
prescript.
Prescript, yes. No existing prescript to what was happening with especially with the issue of Mr. Spies having had resigned and joined another municipality. Then there was no restriction and there was no prescript about the issue of the medical aid.
So, yes, all right, we'll allow that. And what was the other issue? I think you
And-
said two, yeah.
And the other one is to clarify on his form again that indeed he wrote that when he was resigning, he said he's resigning because of he resigned or he took an early retirement. And if he took an early retirement, is there anything that was preventing him to join another precinct,
All right,
to be
please,
re-employed?
please go ahead, thank you.
Do I have to repeat the?
No, start with the re-examination.
Okay, thank you. Ms. Gxasheka, would you clarify to me, especially about the issue of reverse peace, as I've already testified? You did not have any policy, or there was no prescript in Ekurhuleni which prevents the action that was taken by reverse peace?
Thank you, Chair. In terms of the, I think the memo that was read here today and his exit form, the exit form talks to retirement, resignation, deceased, and abandonment. And it goes further. In his form, he ticked retirement and then he added early with a pen, and it says 60 years. And then again, in his resignation letter, okay, I'm not sure if this was shared with the commission. In his resignation letter, if I may read it, is that he said, early retirement or resignation from employment, please accept this letter as a formal notification that I'm resigning from my position as Deputy Chief of Police, Auxiliary and Support Services with Ekurhuleni Police Department, effective 28 February 2025. This decision comes after 42 years of dedicated service to the law enforcement profession and 33 years to the city, during which I had privilege of contributing to the safety and well-being of our community. I am incredibly grateful for the opportunity and experiences I have gained through my career. I have reached the age of 60.
Sorry, Mrs. Gxasheka. I hope I remember what the question was. I think it was, is there a prescript?
Yes, Mr. Chair.
Yeah, the question is about the existence of a prescript, Mrs. Gxasheka, not the motivation for taking early retirement.
There is a document that talks to when you take early retirement, and then there will be, you will contribute, the employer will assist you to contribute towards your medical aid until upon death. There is a mayoral or council resolution to that effect.
So that document, does it state as to whether if maybe you get employment somewhere else whilst you are on those benefits, the previous employer will stop its benefits that it has given to you or awarded to you?
Sorry, Chair, I do need to object here, because if we're talking about what a hypothetical document says in relation to Ekurhuleni policy and precepts, we need to see the document. Or at the very least, we need to have some description of the document that will enable us to locate it.
Should we proceed on the... Let's hear the witnesses answer, Mr. Shadrack, and then endeavors should be made to get the document. I think Mrs. Gxasheka would assist in sourcing the document. Your answer to the question?
Okay, thank you, Chair. Yes, Chair, there is a council resolution. I will try and get it through the right channels from Ekurhuleni. And the documents speak, it talks specifically to retired employee, not to employees that have resigned. and intend to join another municipality. Just talks about retirement.
And early retirement is defined as retirement.
Yes, I don't have an issue with the early
all right,
retirement.
all
Chair.
right,
Where I said I had an issue, it's for you to correct.
I'm raising it purely because
Oh.
you refer to resignation and taking up employment elsewhere. That's why I'm just saying early retirement is retirement. Yes, please proceed.
Thank you, Mr. Chair. I have nothing further. I think she has clarified it.
Thank you.
Thank
We'll,
Sorry, Mr. Gxasheka, one last thing I promise. Would you agree with me that if there was a prescript or a policy within Ekurhuleni that said if you are receiving post-retirement medical aid subsidy from the employer and you become employed by somebody else, the subsidy stops? If there was such a policy, then all Ekurhuleni has to do is to enforce its rights in terms of that policy.
Chair, what I said earlier on, or yesterday when I was testifying, was that that policy, it was meant for early retirement or retirement and so forth. I think even the memo that we read today, it mentioned those who qualify. And I said my concern with Revo's piece is I've changed and said he intended to mislead here. Because in his resignation, he says, I'm reaching the age of 60 during November 2024. I've decided to pursue early retirement, to dedicate it to my time, you know. And I think the debate we had yesterday was he can take early retirement today and decide tomorrow to go and work in another municipality. Then I said, it's something that as the city we need to look at, because clearly there is a misconstrued or a misleading situation here. There's two people that I've heard of that have done that thus far. And to avoid it continuing beyond those two people, we have to revise the policy. I think I was very clear in my testimony. And when I said because I've changed my wording and said he has misled the council, I further said the reason that made me to be concerned is that a person could be receiving a what you call this, a benefit that he should not be receiving, Ekurhuleni. If I can go, Chair, even the definition of an early retirement versus a resignation. In early retirement, it's a planned departure often before a standard age requirements, whereby an employer consent and allow access to pension fund benefits with favorable to tax treatment. But on the resignation, my definition I managed to have is that it's a unilateral decision to leave and often...
Again, I'm very sorry, Mrs. Gxasheka. The question is, if what Mr. Revo's piece did was against whatever prescript, if there be, would it not be within the municipality's power to exercise his rights against him? That's the question. I think it's an easy yes or no question.
Once the policy has been corrected, I think what I said...
No, now as matters stand at present.
It can be done, Chair, in the sense that if there's a benefit that is happening at Tshwane, you can't have a double benefit. I don't think it's fair. And we're spending a lot of money in terms of those post-retirement employer contribution. So it's something that can be looked at. Thank you, Chair.
Ms. Gxasheka, I think in fairness to Commissioner Spies, who's not able to speak for himself because he's now testified, when you say he was misleading, I note that you withdrew your statement that he committed a fraud and corruption. you withdrew that. Now you use different terminology. You say he misled. What misleading are you saying he committed in this case?
I'm saying, Chair, in your resignation letter and in your termination form, you're saying you take early retirement, knowing very well that you are going to another municipality. You know.
Is there a rule, whether rule, law, policy, and I tried to get this with you yesterday, that says on taking early retirement, an employee or a former employee of Ekurhuleni is not allowed to take other employment after having taken early retirement?
Chair, what I've said is Mr. Rivospis, he left Ekurhuleni still getting 5,700 every month.
My question.
And he went to Tshwane immediately
Miss
after
Prashad,
leaving Ekurhuleni.
You're repeating what you said yesterday. It doesn't make it any more cogent just because you say it many times. You know that. I'm asking you a straightforward question. Is there a rule, a policy, a law, a collective agreement, whatever, when your counsel speak of a prescript, is there anything that is written and that is binding that precludes him, not just him, any employee, even the other two that you are referring to, on taking early retirement from assuming employment after that? Is there anything? And I expect your answer to be a no. I do. I expect the answer to be a no, because if there was a prescript, you would have said that yesterday. You would have said it. You would have given me that straight answer now, a second ago when I asked you the same question. So I'm putting to you, and maybe let me reformulate what I'm saying. It might be easier for you. I'm suggesting to you that there is nothing, as matters stand now, there's nothing that precludes any employee of the city of Ekurhuleni, and therefore Commissioner Spies, from taking early retirement because they have met the threshold, the age qualification, and then after that going and working elsewhere. I'm suggesting to you there's no rule that says that cannot be done. Do you disagree with that?
Chair, in terms of I think the Pension Funds Act is very clear that when you retire, what do you do? And I think I conceded to that you can retire at any time when you need to retire, even take early retirement.
And go and work somewhere else.
What my issue is that there's a 5,700.
Okay, no, you're not going to answer. I think you don't want to answer my question. I have put it differently and asked you, am I wrong when I say to you, there is no rule, there is no policy of Ekurhuleni that precluded him and other employees from taking early retirement and then finding employment elsewhere? I'm saying to you, there is nothing that prevents them from doing that. You can say to me, I am wrong, and point out, where is that rule? Where do we find it? Because then the evidence leaders will go and look it up. You're not answering that straightforward suggestion that I'm putting to you. I'm leaving it at you don't want to give a straight answer. And the reason, and I'll suggest to you why you don't want to have a straight answer, you don't want to give a straight answer, it's because you are aggrieved personally. You are aggrieved that Commissioner Spies is getting the benefit that the rules allow him, that your City of Ekurhuleni resolution allows him to get, and then he's employed elsewhere. While enjoying the benefit, he's employed elsewhere. It's a grievance that you have and nothing more.
I don't think at my level I'll say I'm aggrieved, Commissioner. What I will say is a concern where I've seen that there's a risk, a serious risk, where a person highly possible is receiving a benefit twice. You're sitting at Ekurhuleni, we give you 5,700, you might be getting it somewhere. And I said yesterday, my concern, and with this situation, already in his own medical aid scheme, we're spending more than $1 million. There's about 4 or 5 of them where this is happening. And I said, I picked up this as misleading. I've changed my wording. And I said, it's something that the city, we must look at and correct it. I wouldn't call it a grievance, but I will call it that at my level, I should be concerned, taking into cognizance that the country has got high employment rate. Any cent that gets out of Ekurhuleni, it should be useful and gainfully utilized somewhere else. And
So he misled City of Ekurhuleni when he exercised the right to early retirement. Because remember you say there's a resolution that allows him to do this, to retire early and to get the benefits. You're saying when he exercised that right, that is the misleading you're talking about. Because I'm trying to understand what you're saying he misled you about.
Yes, when you know you're resigning, you're going somewhere, because you know, let's say for instance, and again, I've said initially that inferences, they tend to be biased because they're based on you subjectively how you perceive and see the matter.
So you're saying your inferences here are biased. You infer he was misleading. Is that what the switch you keep repeating about inferences being biased?
The notion on my side, based on the documents, that firstly, if we'll allow every person to adjust the document themselves with a pen, I don't think will be correct.
Okay.
So to me, firstly, that is very wrong what he did here. Number two, you are saying you're going to sit at home. I guarantee you, and you're right, I'm saying it's my notion, and it's a concern that if it's not corrected, highly possible, if there was not this issue, you'd have just said, I'm resigning, I'm going somewhere, So it's a concern that I have based on my inferences that they need to be looked at. And before I left the city, I was in a process of revising that particular policy, because if it's not looked at, Chair, we're going to have people that are leaving after 55 and go somewhere else and work, and we keep on bearing the cost unnecessarily.
Okay, so
I want us
that's
to
really
agree on
that's a
that.
problem of the city. It's not Commissioner Spee's problem. It's a problem of the city that you have a policy that permits people to go to early retirement, get the benefit, and it doesn't say, your policy doesn't say, but you may not be employed elsewhere. So it's not his issue. It's your issue, and an issue that you as HOD should be addressing, not make it the employee's problem. And that's what I'm debating with you, that it seems it is in fact grossly unfair on employees who act in accordance with what your policies allow or do not preclude, and then you come here in front of the public, you accuse them of fraud, corruption, and then you water it down, it becomes they misled the municipality. Fix your policy. You're head of HOD. Change your policy so that it says if you take early retirement, you may not be employed as well anyway, otherwise we'll take our benefit back. That's a city issue, it's not a space issue.
Chair, through you, I did say that I accept it's a risk that I've identified and that needs to be corrected, because the risk that I've identified that employees now are starting to create this fraud. And I took it
It's
up
not
that,
a fraud, no,
apologies with
Ms.
that word.
Mr. Gxasheka,
Apologies
it's not.
with that word. I think what keeps on confusing me, Chair, is him correcting the form. I think that's why you're not supposed to correct the form to suit what you want. And as I say, if we were to allow that, we all adjust the forms to suit us, it would be wrong. But Chair, I'm changing that the form, it's corrected when it should have been. It was misleading. And the letter as well, it was talking about early retirement.
Gxasheka, my problem with you is saying he was misleading. It's a very serious statement. I don't know if you appreciate the consequence of what you are saying right now, that he misled his previous employer. I've asked you point out where he misled, and we shouldn't allow you to say things that are not backed up by your documents. You've told us council resolution allows people to go on early retirement and to get these benefits, right? You've said that. 2, you haven't pointed out a council resolution or policy or rule that says they may not be employed after that. So you've got a gap. I accept that. You've got a gap, it seems, given your view about it. There's a gap, and I'm saying to you, you cannot say, and it's actually wrong and offensive to employees who use a benefit that is given to them by the city without restriction to say they commit a fraud, they commit corruption, they are misleading. That you use the word misleading doesn't make it any less serious. So I'm quarreling with you for that reason, that no employee who takes this benefit, which by law, your law, being a resolution, they are entitled to, which doesn't say they cannot find employment anywhere else, they go and get employment elsewhere. You cannot say that there was any misleading by them. And it's simply wrong for you to do that.
Chair, as I said, we are learning. I will withdraw if I need to withdraw on this in the context of what I've shared with the Commission. Thank you.
Thanks, Mr. Gxasheka. I think it's a fair concession that you make. Thank you.
I think we've reached the stage at which we should adjourn until 9:30 on Monday. Let's adjourn.